Just before I kick off, just note we've got photography in the room, and I'll just confirm that everyone's happy for that to proceed. Thank you, subject to the usual rules, which are readily available. Good morning, everyone. I declare open this hearing of the Education and Employment Legislation Committee into the 2025-26 additional estimates. I begin by acknowledging the traditional custodians of the land on which we all meet today and pay my respects to their elders past and present, and I extend that respect to Aboriginal and Torres Strait Islander people joining us today. The committee has fixed Thursday, the 19th of February 2026, as the date for the return of answers to questions taken on notice. The committee's proceedings today will begin with corporate and enabling services, cross-portfolio and general matters of the employment and workplace relations portfolio. Understanding Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or to disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. The Senate has endorsed the following test of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has resolved also that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunities to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Witnesses are reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised, and I incorporate the public interest immunity statement into the Hansard. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. An officer called to answer a question for the first time should state their full name and the capacity in which they appear. Before we move on, I would like to wish our Deputy Chair a very happy birthday and apologies on behalf of the committee that you're spending it here with us.
Thank you.
I would now like to welcome Senator the Honourable Murray Watt, the Minister for Environment and Water, who is representing the Minister for Employment and Workplace Relations this morning. Minister, do you have an opening statement for the committee?
No, but can I sing happy birthday to the Deputy Chair?
No, you cannot. I don't have many powers as Chair, but I will rule negatively on that one. I also welcome Ms Tanya Rishnu, Acting Secretary of the Department of Employment and Workplace Relations. Ms Rishnu, do you have an opening statement for us?
No, I don't, Senator, but also let me wish the Deputy Chair a happy birthday.
Thank you, and it's nice to see you in the big chair. We will begin now with questions in relation to corporate and enabling services, cross-portfolio and general matters. Senators, in this section I'll be coming to the Deputy Chair first, then I'll be coming to Senator De Lega. I'll be seeking to do about 15-minute blocks to help us move through this one, but if you've got a problem with that, just let me know. But otherwise, Senator Kovacic, you have the call.
Thank you, and thank you, everyone. Chair, just before I go to questions, I just want to establish a factual sequence. The former Secretary of the Department of Employment and Workplace Relations, Ms James, attended these hearings in the last session in early December. On the 16th, the Minister released a statement entitled Secretary of the Department of Workplace Relations. I'd like to briefly read the statement. It says the Secretary of the Department of Employment and Workplace Relations, Ms Natalie James, will conclude her term as Secretary on the 18th of January 2026. I would like to thank Ms James for her service as Secretary of the Department. I would like to particularly acknowledge her leadership of the Department in delivering the Government's first-term workplace relations and skills and training reforms. Ms James will take leave from the Wednesday 17th of December 2025, noting that's the following day. Ms Tanya Rishnu will act as Secretary of the Department of Employment and Workplace Relations until a replacement for Ms James is appointed. I wish Ms James all the best for her future endeavours. This is a very unusual statement. Could I just confirm when Ms James was appointed Secretary of the Department?
I'll see if we... Actually, the officials may have that detail.
Yeah. Thank you, Senator. Tanya Rishnu, Acting Secretary for the Department of Employment and Workplace Relations. Ms James was appointed as the Secretary of the Department on the 11th of July 2022.
Can I confirm when her term was due to expire?
She was appointed for a 5-year term.
5-year term. So it was due to expire in July 2027.
That's correct.
That seems a bit premature. I understand from evidence provided to the Prime Minister and Cabinet estimates on Monday, Ms James didn't resign her employment but was terminated. Can you confirm if that is correct?
I can confirm that's correct.
Thank you, Minister. Given that termination, who made that decision? Was it the Prime Minister or the Minister?
Well, again, this was explored at PM&C estimates on Monday.
I'm just seeking a clarification of that.
Yeah, so I've got the transcript, or a rough transcript of that hearing with me, and officials there were asked who initiated the termination and provided the reasons, and the answer given by the official was the report is always prepared by the Secretary of the Department.
Thank you. I understand who prepared the report. I would like to know who made the decision to terminate her employment. Was it the Minister or the Prime Minister?
Well, I'm happy to be corrected, but my understanding is that these decisions ultimately are those of the Prime Minister on the recommendation of the Secretary of the Department.
Thank you.
That's correct.
So, if I could just add to that, actually, it's a decision of the Governor-General ultimately.
Sorry, you're right.
On advice of the Prime Minister.
Yes. So the Prime Minister would have given the advice to the Governor-General, who then would have acted on the Prime Minister's advice.
That's right, and it's covered by the Public Service Act, Section 59, in accordance with the Prime Minister and Cabinet.
Thank you so much. Are you able to tell me on what date the decision was made that the former Secretary would no longer continue in her role?
I think that's probably a matter for Prime Minister and Cabinet as the body in charge of that process.
Okay. And just to go back one step, given the Prime Minister gave the recommendation to the Governor-General, so the PMC Secretary recommended that to the Prime Minister, I'm assuming?
That's my understanding, but again, you probably need to put that to PM&C.
Okay, thank you.
Feel free. Ms Rishnu will jump in if I get any of this detail wrong.
Yeah, perfect. I'm happy for that. No problem at all. Had Ms James's future been canvassed with her prior to her termination?
Again, that's a matter for PM&C.
Okay. But do you have any knowledge of that?
I don't.
Don't. Thank you. And my next question may garner the same answer, but I will ask it. Had the Minister raised any concerns regarding her performance prior to her termination, if either of you have any knowledge of that?
Again, that's really a matter for PM&C.
Acting Secretary, do you have any knowledge of that?
I don't have any knowledge of that.
Thank you. Do either of you know whether, or have any knowledge of whether she had been encouraged to resign prior to the termination? I
don't have any knowledge, and again, it's all of these matters are for PM&C because they're responsible for the process.
Okay. So I know they're responsible for the process, but I'm just wondering whether the whole thing is really a matter for them, given it's due as a department.
But the decisions to appoint and, if it occurs, terminate a secretary are all handled by PM&C.
So they would have received some advice, surely, from the department.
Well, I don't think they would have received advice from the department. No.
No, Senator, I can confirm the department wouldn't normally provide any of this advice to PM&C. Okay. It's a matter for the PM&C Secretary.
Okay, and so that means that your minister just wasn't aware, it was just PM&C?
No, well, again, the transcript from PM&C estimates this week, I read the part of that before where the official was asked whether a report had been provided to the Prime Minister. Yes, it has. Who initiated the termination and provided the reasons? The answer was the report is always prepared by the Secretary of the Department. Typically, these reports are done following consultations with relevant ministers and the Prime Minister, and they are required. It is a requirement that consultation occur with the Public Service Commissioner, which occurred in this instance.
Okay. And I note the word typically. So what I want to understand is two things. Is if in this case, not typically, the Minister was made aware prior, or perhaps an easier question then is, when did the Prime Minister inform the Minister of the decision?
I don't know that, and again, I'd suggest that gets put to PM&C.
Are we able to find that get that on notice?
I can take it on notice.
It's relevant because
I can take it on notice, and then we can make an assessment.
If they're taking it on notice, Senator, it might be a smoother process to put it on notice to PM&C and get it back.
Yeah, I guess because it's this department, they're able to say when their minister found out from PM&C.
So, Senator, we wouldn't typically be involved in that. Any discussions between PM&C and the Minister would be a matter for PM&C. The department did not provide any advice, nor would it normally in these circumstances.
Okay, so if we can try and find out on notice then when the Prime Minister informed the Minister, that would be wonderful.
I can take that on notice and we can work out whether that's better answered by PM&C than this Minister or department. Yeah.
Thank you. Are you able to tell me how the decision was communicated to Ms James, and did the Minister meet with her in person or call her?
I don't know that. Again, I'm at the risk of sounding like a broken record, these questions really should go to PM&C as the body responsible for the process.
But I guess it relates to what the Minister found out, when she found it out, and if she then communicated with Ms James. Which is probably outside PM&C's remit.
Yeah, I don't know the answer to your question, sorry.
If we could potentially try and find that out on notice as well.
Sure.
Thank you so much. And again, we may get the same answer, but let's try. Did Ms James raise any concerns regarding her termination?
I don't know. I can take that on notice.
Thank you. Were any payments made to the former Secretary in connection with the end of her employment, including termination payments, ex gratia payments or payments in lieu of notice?
That was definitely explained in PM&C estimates this week.
Do you have that information there in your transcript?
So the...
Minister, I can take that
sure.
if you like. Senator, any payments would have been made in accordance with the provisions of the REM Tribunal and Section 59. We can confirm that there was a payment made to the Secretary upon the conclusion of her term, and Ms Rule will give you the detail of that.
Thank you, Senator. Catherine Rule, Chief Operating Officer. There was a payment, a gross payment of $845,314 made to Ms James, which included salary, her accommodation allowance and a termination payment and a payout of her leave entitlements. As Ms Rishnu said, that is in accordance with the provisions of the Remuneration Tribunal and the Determination and the Public Service Act.
Okay. Thank you. Was Ms James ever the subject of a formal complaint regarding her conduct?
Not that I'm aware of, Senator, and I would note that PM&C's evidence this week confirmed that there wasn't any misconduct or misbehaviour.
So what I'm trying to understand then in that context, because I have read that, is why did she have to leave so immediately? Like, the statement was issued on the 16th. She took immediate leave from the 17th, and that's it. And to say that there's no misconduct, no issue, no concerns, but it's just so immediate, 18 months earlier than the contract was intended to end, and a cost of almost $1 million.
So your question is, why did Ms James...
Yeah, why was it so immediate? Why did she just have to leave straight away?
That is definitely a question for PM&C.
Okay, and the Minister has no insight into that?
Not that I'm aware of, no. So
no awareness at all? This was just something that completely blindsided the Minister?
I wouldn't put it that way. What I'm saying is that the steps in the process, including the decision around what day Ms James finished, would have needed to be made through PM&C.
Okay. So would it be PM&C then that asked her to take the leave, or the minister?
I don't know.
Could we find that out on notice?
I can take that on
please?
notice.
Yeah.
Again,
or acting secretary, if you happen to know the answer to that question.
So, Senator, I don't know the specifics of that. As the minister's pointed out, obviously this process is prepared by PM&C. The only thing I would add is obviously Ms James would also have a say in when she was applying for leave, and at which point she chose to take some leave. Her final date as the secretary was actually the 18th of January. So she took a period of leave once the announcement was made.
Okay. So ultimately you're saying that it's potential that she decided to take the leave immediately, that she wasn't instructed to take the leave immediately?
I can't give the details of that.
But
obviously that's a matter. It is possible.
Okay. So since that time, acting secretary, and given the sort of the manner in which the termination occurred and the leave, have there been any steps to proactively check whether any formal complaints were made regarding Ms James's conduct and whether that needed to be addressed?
Senator, I'm not aware of any allegations of misconduct. As I said, PM&C on the record noted that the termination was not as a result of misconduct or misbehaviour. Any matters of conduct or performance are obviously a matter for the Secretary of PM&C and the Public Service Commissioner. So I wouldn't generally be expected to know any of that.
Right. So, you wouldn't have any issues that you would come across that you would flag to them?
If there was an allegation made, obviously I would flag that, but I'm dealing with hypotheticals. Nothing of that nature has come forward to me.
Okay. Because the thing I'm trying to get my head around, which is a bit confusing for me, is all of the answers to the questions are that they are a matter for PM&C, and I acknowledge that there is, a responsibility there. But it was the minister that issued her termination release and the lack of reasons for it. So that's why I'm trying to understand what's actually happened here.
I think it's pretty customary for ministers to issue press releases at the conclusion of the term of their secretary. In some cases, I've also seen ministers issue press releases when new secretaries are appointed. In my portfolio, we had a retirement of the former secretary. I think there was a statement issued by ministers at the time, and then when the new secretary was appointed, there was a statement issued by ministers. So it's not unusual for ministers to issue those types of statements, and I wouldn't read more into it than that.
Okay, thank you.
Senator, we do need to
I'll just finish off with one on this tranche. Acting Secretary, just for clarification for me, you made the comment that there were not formal findings of misconduct, but I just wanted to understand if you were aware of any complaints actually being made without there being formal findings, because it's sort of weird to me that, this has all happened. There was an immediate sacking. The minister shot out a release, but didn't really have anything to do with it or any knowledge of it or any communication with Ms James.
Well, I don't think we've said that. What we've said is that we're not aware of that.
Right.
You're at a disadvantage, Senator, because I don't think you were in the Finance Committee the other day when this was discussed. But, I can read back to you the transcript, a separate part.
That's okay, because I'm mindful of time, but thank you, Minister. But just to answer that last bit of the question so the Chair can move on, are you aware of complaints, Acting Secretary, not just findings but complaints?
So, Senator, I think I covered this before. I'm not aware of any complaints having been made against the Secretary.
Thank you. Thank you, Chair.
Thank you. Senator Delega.
Thanks very much, and morning, Ms Rishnu. I have some questions about your contact centre branches, and I understand some of the decisions that I might ask you questions about today might have been taken by the former secretary. Does the department consider your contact centre branch to do core work?
Senator, I might call the relevant officers to the table, but in the process of looking at the Public Service Strategic Commissioning Framework, the department recently, I think it was last year, but Ms Lauman will correct me, added some of the contact centre functions as core work under that strategic commissioning framework.
Good morning, Senator. Miranda Lohman, First Assistant Secretary, People and Communications Division. The Acting Secretary is correct. It was on the 5th of August, the Executive Board considered our broader review of the Strategic Commissioning Framework and of core work within the department. And as part of that discussion, 2 different functions were added to core work for the department. That included customer advice and support functions. So some of those functions delivered by the contact centre branch.
Okay, and that work has been predominantly completed by APS employees?
I'll defer to my colleague on that.
Senator, Fiona Dewar, First Assistant Secretary, Workforce Australia for Individuals Division. So the contact centre branch is staffed by a mix of APS, that's permanent and non-ongoing, as well as some labour hire staff.
Can you confirm to me that that there's been a decision made to replace some APS employees in the contact centre branch with labour hire workers?
No, Senator, no decision has been made, and we are not replacing APS staff with labour hire staff. We are considering options to staff and resource our contact centre, and that may include APS ongoing, non-ongoing and labour hire, but no decision has been made.
No decision has been made. So I understand there are 13 non-ongoing workers that are currently at the end of their contracts. Can you tell us about this?
Sure. So we have 12 non-ongoing staff, APS staff, who are at the end of their contract. They've been extended to the full length of the 2-year term that's available to them, and they will finish up with the department over the coming months. We have one staff member who has, we have extended their non-ongoing contract to the length of that, the available term.
Was your decision in relation to more labour hire workers, was this made before or after you classified the contact centre work as core work?
Thanks, Senator. So reiterate that no decision has been made. We are currently contemplating what our options are. The contact centre has always used a mix of APS and labour hire staff, and that enables us to surge our capacity within the contact centre as and when we need. I would say that as at the 30th of November 2025, we had 78% of our staff in the contact centre are APS staff, and the remaining 22% are labour hire.
Thanks for that. When it comes to outsourcing the work, what problems does outsourcing that work, how does it solve any problems that you might have in the department when it comes to the contact centre work?
So, Senator, I wouldn't say we're outsourcing the work. As my colleague has outlined.
Ms. Dewar, I'm a former public sector official, union official, and I can tell you when work is done by APS employees and not APS work, there is a clear definition of what workers and what is in the real world. Can you, yeah.
Sure. So we consider labour hire staff as part of our workforce when we do bring them on. So the challenges in the contact centre branch, the demand is driven by a variety of factors, which is how we seek to staff and resource our contact centre. And those demands, can surge from time to time depending on a range of drivers. So that's when we seek to employ labour hire staff to support that.
Have you weighed up how much each option of labour costs compared to APS and labour hire?
No, we have not, Senator.
So, and just saying then you haven't done that, and that means no, and like you're saying that no decision has been made. So I'll take it that you would do a cost APS versus non-APS?
Senator, as part of our regular budget management, we are always looking at the cost of various staffing measures, be that APS staff or other, and the affordability of that and our ability to expand and contract our staffing depending on demand and priorities of the department. So, yes, we would do that.
Just back to those, sorry, I thought it was 13, the 12 labour hire workers. What sort of salary were they on as a non-ongoing contract?
Sorry, Senator, I should confirm those non-ongoing staff were APS non-ongoing
Yeah,
contractors.
that's, sorry, APS non-ongoing staff. Yes, sorry, yes.
Yep. So the salary ranges are commensurate with the APS levels, and they are engaged at a variety of levels, APS 4s and 6s, I believe, but I'd have to take that on notice.
I can
sorry.
I can provide that information for you, Senator. From the APS 4 level, that salary range currently starts at $82,039 a year. That goes through a range of increments for the 4s, for the 5s, and then for an APS 6 that goes up to the starting range for an APS 6 is $101,833.
Thank you. And when this work is being done through a labour hire company, how much would they be paid, and will they have the same conditions as APS employees?
So when we engage with labour hire companies, we do share with those organisations our enterprise arrangements, and obviously our salary ranges are also published on the DUA website. So
for APS employees?
Sorry?
For APS employees?
For APS employees, yes. In order that labour hire companies can follow the kind of same work, same pay principles.
So they will follow the same work, same pay principles?
Yes.
Excellent. Is the department meeting all of your legal obligations in relation to this matter? So, if you do take the decision to outsource or to labour hire, sorry, I say through gritted teeth, these jobs,
So, Senator, I'll start by acknowledging that actually over the course of the last 2 years we've converted most of the contact centre staff into APS employees. And we converted those staff, there were over 61 converted into ongoing public service roles.
Yes.
We take our legal obligations very seriously, and you will understand those legal obligations relate to the Public Service Act, the PGPA Act and the Fair Work Act.
Your enterprise agreement?
All of those, absolutely, but the enterprise agreement is obviously part and parcel of, our obligations. We take our legal obligations seriously. We manage our staff in accordance with those legal obligations. At times, you would appreciate that the contact centre does have surge demand. There will be times where we need to make sure that we have capacity to meet that surge, but it's not ongoing work. And there will be some time-bound measures that we need to manage. So, as Ms. Rule outlined, we manage our staff in accordance with our legal obligations and making sure that we meet our fiscal, our public service and our fair work requirements.
And have you been consulting with the CPSU over this matter and over matters of the contact centre workers, but also in relation to your workforce and shifts in your workforce?
So, Senator, we regularly meet with the CPSU on a whole range of employment matters, including these. And
what's the CPSU feedback been about labour hire?
I think the CPSU's position on labour hire in general is quite, it's on the public record.
So is mine, actually, to be perfectly honest, but yes.
Issues that go to their opinions around these particular matters, I don't think it's for us to speak for the CPSU in this forum. Needless to say, they've put their views to us which are consistent with their public views.
And I trust, as per your obligations under the enterprise agreement, when the CPSU and their members put their views forward to you before you make any decision, you will take those views into consideration before you make that final decision.
So, Senator, I think the Acting Secretary has been very clear that as we make this decision, we'll be looking to balance all of the obligations that we have under all of those legal and policy frameworks that apply both to us as a department and to those groups of staff who are affected.
Thank you. I look forward to talking about this over the next couple of estimates periods and see how it goes. Thanks, Chair.
Thanks, Senator DeLaga. Senator Pocock, and then I'm returning to the Deputy Chair after that. Senator Pocock.
Thank you, Chair. Thanks all for being here. When do you expect to make that decision that you've just referred to?
Senator, I think in terms of the contact centre staffing, we make decisions based on, as I said, kind of funding arrangements, surge capacity. We make decisions looking at our workforce needs according to our fiscal, our PGPA Act, our Public Service Act requirements and the Fair Work Act. In terms of specific decisions, I can't give you a specific date, but we will look at all of our resourcing requirements for this financial year over the coming months.
So can you tell me then what your total spend on outsourced work in 2024-25, including labour hire, is?
I'll ask Ms Rule to provide those figures, but we should make a distinction. There's a number of workforce requirements, particularly in our IT area, that surge according to time-limited requirements. So I'll go to Ms Rule.
Thank you, Secretary. I'll just have a look and see if we've got that data at hand in terms of the actual cost, the amounts of money spent. So just bear with me for 1 second. We can give you the number of staff in the different categories and perhaps take on notice the amount that we spend on those staffing groups, Senator.
So as at the 30th of November 2025, Senator, our headcount of APS employees for the department was 4,421. We also had 749 non-APS. Within the APS, there were 160 who were non-ongoing and the remainder were ongoing. Breaking down the total...
Sorry, 160 not ongoing and...
And sorry, that's 4,261 ongoing. So 96% of our APS staff were in ongoing roles.
Okay, and 749?
749 non-APS, so external employees.
External, mostly through labour hire?
So that was 518 in the ICT space that Mr. Rule just referred to in labour hire, 90 in non-ICT roles in labour hire, and 141 who fall into the professional contractors category. And looking at that overall picture, that's a decrease of 190 non-APS workers over the last 12-month period. So consistent with the strategic commissioning framework, we've been taking those gradual decisions as we can within the confines of our financial and legal frameworks.
So you've confirmed that your call centre work is core. That's your agreement, but 22% is contracted out. So just how do you reconcile?
Yeah, I think we've agreed some roles in the contact centre, and most roles are core in terms of advice, but there will be some that surge in cases of emergency and don't fit into that category.
So there'd be a mix of roles that are in the centre, but also the strategic commissioning framework importantly does recognise that there are circumstances in which non-APS sourcing may be required. That's particularly in relation to surge matters, and so there is a recognition within that framework of the need to prioritise that ongoing APS employment, but also to have that option for surge in order to support quality service delivery and to meet demand. That's one of the reasons that within the contact centre, it doesn't matter in terms of a person's experience as a labour hire or an ongoing in terms of their support for training, their ongoing development within the role, because if they'll be doing client-facing work, we want them to be well supported and to be providing that quality service.
So the figures that you've given me, are they full-time equivalents or headcount?
That's headcount numbers, Senator.
Could you give us the full-time equivalents on notice?
On notice, we can provide that.
Just curious about that. And I'm also curious about the tenure of your labour hire people. Are they genuinely circulating through on very short-term contracts, or do they have extended periods with you?
We'll take that on notice,
Great.
Senator,
Thank you.
to see what we can do.
I wanted to go back to the Secretary's employment and ask did Ms James sign, or is she bound by any non-disclosure agreement?
Sorry, Senator, I am not aware of that. That would be a matter for PM&C, but I'm not aware of any non-disclosure statement being signed.
What are her obligations having left in terms of future employment, how she's bound in relation to information from the department? Can you give us a description of what her obligations are?
Sorry, Senator, that's a matter for PM&C.
Okay.
Directly.
I'll ask. Don't worry. Thank you. In a previous estimates hearing, my colleague Senator Penny Allman-Payne asked if suspensions under the targeted compliance framework were lawful. And she was told there was still an ongoing process to review this and determine if they were operating lawfully. Did this influence Ms James no longer being in the role?
I think, Senator, you may well have been the person who asked the questions at PM&C estimates earlier this week. And what I think you were told there was that reasons for termination are put and were put to the person concerned prior to termination as a procedural fairness step. But what I think you were told by PM&C is that because of matters of personal privacy, we don't speak publicly about the reasons for termination. And that's the position we'll be taking today as well.
Okay, but there's no, I'll come back to that, but there's no reason why Ms James can't talk about it publicly if she chose to. Is that correct?
I don't know the answer to that, and again, that would be a question for PM&C about her obligations.
The Commonwealth Ombudsman recently released their latest report on the targeted compliance framework, and in this report, in a letter to Mr Ian Anderson of the Commonwealth Ombudsman's Office, Secretary James writes, and I quote, "I will not take any decision to resume cancellations unless and until it can be clearly demonstrated that the process to support the decision-making complies with the law," end of quote. Did Ms James want to end suspension of payments too?
Senator, I am not in a position to speculate what Ms James was or wasn't thinking. Certainly, as we've been working through the issues of the targeted compliance framework and cancellation of payments remains paused under the provisions that have previously been raised by the former Secretary. At the time that she made that statement, and certainly as we've been working through suspensions, we still consider that they're operating lawfully and that there wasn't any reason to suspend suspensions or pause suspensions at this point in time in the TCF.
So in the MyEFO, unlawful decisions under the TCF were listed as a contingent liability, and that, quote, "the total fiscal impact of these payments is currently unquantifiable." It goes on to say that it will depend on the number of applications received and the outcomes of these individual assessments. The timing of the MyEFO announcement and the decision to terminate Ms James' contract came in quick succession. The details of the MyEFO indicate the government intends to resume the targeted compliance framework. Are the two decisions to remove Ms James and to resume the targeted compliance framework related?
Well, again, we're not in a position to speak publicly about the reasons for termination because of Ms James' privacy.
Ms James' privacy?
Well, that's what you were told in the PM&C estimates, and I'm reiterating that point.
So we're protecting Ms James here. I mean, the reason I'm curious about this, and I think a number of people clearly are curious about it, is that we have gone through a very painful chapter in our public sector in the last few years with robo-debt. And there is a really important right that secretaries and all public servants need to have, which is give frank and fearless advice to those they serve. And I am really concerned about the coincidence of concern that clearly Ms James had, it seems to me, around this compliance framework, and her sudden dismissal. Not a dismissal she chose, nothing to do with her performance. But the only other terrain that I'm thinking about, I was a public servant for a decade, the only thing I can point to is a difference of opinion about a really critical policy question. Is this it? Did Ms James give advice in relation to a program which was at variance with the government or minister's view, and is that why she's walked the plank here?
Well, again, as I've said twice already, we're not going to be discussing the reasons for termination, but I don't think it's productive for anyone to speculate when they're not in possession of the facts, and I'm not in possession of the facts either.
Did Ms James make any written correspondence or provide any correspondence to people within the department as she exited in relation to her dismissal?
So the former secretary provided a video farewelling and thanking the department for its service, and I made a statement through our channels and to our staff explaining that the secretary was leaving her term and that I was acting secretary. So we can provide the detail of that on notice, but that is the extent of the correspondence that I'm aware of from the former secretary.
And so what impact, Ms Richner, has the immediate and sudden departure of the leader of the department with no explanation as to the grounds of her removal had on the department and its staff? There must be enormous discussion out there about what happened. What's been the impact within the staffing of the department?
So, Senator, I would make the point that the department continues to take its obligations to serve as the public service and as the Department for Employment, Workplace and Relations very seriously. We continue to serve the Minister and the Government of the day. In terms of impact, we have been clear with staff around the timing, the acting arrangements and the way that we as the senior executive lead the department and continue to lead the department. And I would like to think that the performance of the department has not diminished.
I was not casting any aspersions on the commitment and contribution of any member of staff of the department, but I am wondering what the chilling effect may be on other senior officers, not just in this department but in other, to see a dismissal like this without explanation, knowing it has nothing to do with that person's performance. That is a really, that will have caused, I imagine, enormous concern and discussion across the senior service and those in the department. Do you see a chilling effect where there is no explanation for this very sudden departure without explanation?
I couldn't comment across the service, but Senator, I can assure you that we as the senior executive and I take our responsibilities under the APS Act very seriously. We continue to provide frank and fearless advice and apolitical advice in line with the APS Act. And I should also note that the Secretary and the former Secretary, and as do I, take our responsibilities and our powers under the Social Security Administration Act very seriously. So I can't say that there has been a chilling effect in the terms and the nature of the advice that the department provides.
Have any other sudden departures occurred in the department around this period of time?
The only other departure, Senator, that I am aware of is our former Chief Operating Officer took some personal leave, and Ms Rule was appointed as the Chief Operating Officer. That was at her own discretion and to address personal issues.
I have another theme to turn to, is that...
No, we need to rotate now. So Senator Kovacic, you have the call.
Thank you. The questions from Senator Pocock have me literally scratching my head. I'm probably a little bit more confused now than I was before. So we don't know, but we do know. The Minister you said there were reasons in part of that explanation before. It was very sudden. There's no specific criteria about why it occurred. The department is still continuing to give frank and fearless advice. Nothing wrong was done, and yet someone was gone within literally 24 hours, the same day, disappeared. That just doesn't stack up to me. So what is it that's happened here that we don't know, or what specific question haven't we asked that will provide the answer so that we're actually not digging? There's clearly something has transpired here, and we're trying to get an understanding of what it was, because this is not a normal termination. This is a termination that has happened suddenly. It has happened 18 months early, and it has come at a cost of almost $1 million to the taxpayer. I think we actually deserve an explanation that isn't Ms James deserves her privacy and it's a matter for PM&C.
Well, I think I understand that you may be frustrated about information you have been able to and have not been able to.
Well, we're actually entitled to seek that information. That is the purpose of this process.
Sure, but we are also entitled to respect the privacy of the individuals involved, in particular Ms James, and reiterate what was said at PM&C estimates, which is that a public explanation is not going to be provided out of respect for her privacy. However, as was advised at those estimates and has been reiterated today, to quote PM&C estimates, there's no question of misbehaviour or misconduct on behalf of Ms James. She was, I understand, based on this transcript, provided reasons as she's entitled to from a procedural fairness perspective, but it's not our intention in a public hearing to elaborate on that.
So you've said that there were reasons that she was terminated, but there was no misbehaviour or misconduct.
That's
right?
Correct.
So I'm trying to understand how is Ms James's privacy, as it's being framed, in her best interests or in the best interests of the Minister or the Prime Minister? Because this is government expenditure. This is taxpayers' money.
Well, I don't think...
So if she's done nothing wrong and she's been terminated and it's cost $1 million, wouldn't that actually be a better outcome for her, for people to be clear about what happened? Because clearly she's, based on what you have said here today, she has done nothing wrong.
The termination occurred under Section 59 of the Public Service Act. I don't have a copy of that with me, but that would provide you with some information about possible grounds for termination. It has been said that it didn't involve misbehaviour or misconduct. I don't think that anyone in Australia would particularly appreciate the circumstances of their employment termination being discussed in a public hearing like this. So I don't think it's unusual to respect Ms James's privacy in that regard.
I think there are more elements to it than that. Can I just, for clarification, ask, is it the decision not to answer the question, is that related to Ms James's privacy, or are you making a public interest immunity claim in relation to this? Because if you're not, it's a serious amount of public expenditure, and we actually are entitled to hear the answer to that question.
Well, what I'm doing is repeating what was stated at PM&C estimates the other day. The reason I'm doing that is because PM&C, as we've said numerous times, is the agency that handles the appointment and termination of secretaries. So I think it's safest for me to reinforce what they've said, given that they're the agency in control of this. And what I've done today is repeat, for the record, what PM&C has already said.
Okay, and this is a question to both the Acting Secretary and to you, Minister. So we have a very good senior public servant who has been almost immediately terminated, even though there's no misbehaviour or misconduct, at a cost to the taxpayer of almost $1 million, and you've been asked by more than one senator in Senate estimates for an explanation of that public expenditure, and we are not able to get an answer based on privacy grounds.
That is what PM&C advised, and I'm standing by that.
Okay. Acting Secretary, do you have anything to add?
Senator, as the Minister has outlined, the process by which PM&C prepares a report, tests that with the outgoing Secretary, advises government, and the Governor-General makes that decision. That obviously takes time, but we are not privy to that. And as the department, we wouldn't be privy to those processes. The payments that we have made are in accordance with the requirements of the Remuneration Tribunal and the advice from PM&C of payments under Section 59 termination.
And you both believe that that overrides the right of the Senate to ask questions?
Senator,
That's the position that PM&C have taken as the agency handling this, and I think it's best that we follow suit.
Okay.
Well, it's Senator Kovacic has the call.
I'm happy to cede one question. Yeah.
Did Ms James seek privacy in relation to her termination in any way, verbally or in writing? Because you're using that as and so did PM&C, I agree, as a defence against giving Senate the Senate.
I don't know the answer to that, and that would have to be put to PM&C because they were the agency who handled this. There's no one in this agency who could answer that question, but you feel free to put that question to PM&C.
Senator Kovacic.
Yeah. I'm going to come back to that in a minute because I'm interested in the public interest immunity elements of that, because I do believe there is a requirement to answer that question unless you are seeking to not provide it on that basis, given that we have asked that question. Senator Pocock and I have asked those questions and I believe you are compelled to answer them, but we'll come back to that. I understand there is an efficiency dividend being applied across the department. Are you able to confirm what amount that is?
Senator, I'll go to the Chief Operating Officer, but, process of efficiency and, accountable expenditure for the department are a routine budget matter, but I'll ask Ms Rule to elaborate.
Thank you, Acting Secretary. As part of our regular budget management, we've applied an efficiency dividend of approximately 1% across all of our departmental funding to our supplier expenses. So that is consistent with our portfolio budget statements and part of our our regular management of our budget.
Is there a specific savings goal?
No, it's about balance. It's about bringing our budget in on balance.
Okay. Was the department under Ms James's stewardship behind on that goal, on that 1%?
We're carefully monitoring our expenditure through to the end of the financial year. We expect to come in line with our budget by the end of the financial year.
So kind of year to date it's close and close to being, let's call it green by the end of the...
That's right. There are ups and downs. Budgets are lumpy, if you like.
They're not linear.
So that's right. So we're managing those lumps and the ons and offs and making responsible budget decisions throughout the financial year.
Okay, so there weren't any issues there. So thinking about what has happened here again, there don't seem to be any issues in the financial elements. Can I ask... Minister and Acting Secretary, do you know the reasons that Ms James was terminated? And I'm not saying tell me, because you've already told me you won't tell me. Do you know the reasons, or do you not know the reasons and are unable to share them with me?
I do not know the reasons because I wasn't in the conversation that seems to have occurred between representatives of PM&C or the Public Service Commission and Ms James.
Okay.
And Senator, I do not know either, nor would I know, given that the report is prepared by PM&C, the Secretary of PM&C. I wouldn't know, and I don't know.
Okay. I'm now going to refer to the Department of the Senate Estimates Tip Sheet 2, and I'm going to read steps 1 and 2, and I'm going to seek the information on the basis of those steps.
Senator, feel free to do that. If this is leading to you asking us to claim a public interest immunity, I'm not seeking to do that here. What we're seeking to do is to refer questions that can only be answered by PM&C to PM&C. It would then be a matter for PM&C to decide whether they want to seek a public interest immunity. So we're not trying to claim an immunity. We're simply trying to refer questions to the agency that is best placed to answer these questions.
But you've just told me that it's not been released due to privacy. So then PM&C would say it's because of privacy as well.
Well, they already have.
Yeah, so that's the whole point I'm trying to make.
And what I'm saying is that if you wish to challenge that, then I suggest that you challenge that with PM&C.
Well, I'm entitled to challenge it here as well. So I'll just ask one more question. So Acting Secretary, you don't know the reasons. Minister Watt, you don't know the reasons. Do we know if the Minister knows the reasons why Ms James was terminated?
I can take that on notice.
Okay, well, could you take that on notice for today or come back?
I can take that on notice.
And
I'll answer it in the usual course.
So do I need to read through steps 1 and 2 of the estimates tip sheet in order to seek the information?
I think only you can answer that, Senator.
Yeah, well, I was just like, ultimately, okay, I shall.
I think the Minister's taken it on notice, so I think that closes that question. But if you've still
no, in relation to the reasons for the termination.
Pardon?
So the reasons for the termination.
You're in control of your time if you want to ask those questions.
I just wanted to know whether we needed to go through the formalities of it. So we understand that ultimately that an officer who declines to answer a question or provide information or a document has to state the grounds on which they believe it is not in a public interest and specify the harm to the public interest that could result from that information being provided. I don't think there is any harm to the public interest in that information being provided. So I request that the Minister, the responsible Minister, provides the information to us.
So, Senator, the Minister's been clear that in relation to those two parts of the standing orders, he's not seeking to make a public interest immunity claim because these are not questions best placed to this portfolio, but he has taken your prior question on notice. You still have the call for another few minutes if you wish to use it, and we are due to wrap up with corporate at 10.
I do still wish to have the call.
Okay,
I want it to be stated clearly on the record that the government is and the Minister is not seeking a defence under or the reasons to not answer the questions under the public interest immunity, purely just for the privacy of Ms James. That is your reason for not answering the questions.
Well, it's a little bit hard to know. I mean, you've asked many, many questions about this, and most of them I've...
The reason for her termination, or reasons.
Well, again...
It's a very simple answer.
But if you were...
It's either for her privacy or public interest immunity.
If these questions were about an officer of this department who had their employment terminated by this department, then we could answer those questions because this department would have handled that termination. That is not the case here. In this case, because PM&C are responsible for managing hiring and terminations of secretaries, then only they can answer those questions. So we're not even at a point where I'm claiming a public interest immunity. Any decision about a public interest immunity would need to be made by PM&C.
I think the issue or perhaps the area where this overlaps is that the Minister of the Department of Employment and Workplace Relations, so the Minister responsible for this department, the individual that has been terminated is her secretary. And I would expect that that Minister would have knowledge of the reasons as to why her secretary has been terminated with no notice 18 months early at a cost of almost $1 million to the taxpayer. If the Minister for the Department of Employment and Workplace Relations does not know that, then we have an even bigger problem.
Well, about 5 minutes ago, I took your question on notice as to whether the Minister knows the reason for the termination. I think that was the question, and I took that on notice because I don't know the answer to that.
Yeah, and I would expect that the PMC did consult with the minister in relation to this termination. I can't imagine that a departmental secretary would have been terminated
Senator,
without the minister's knowledge.
At the point where the question has been taken on notice, that resolves that question. For the purposes of this hearing, they are entitled to take it on notice and comply with that in the usual time frame. That is the end of your block, though. So, Senator Pocock, I believe, is seeking to clarify where an appropriate place to put questions
I have some
is.
questions in relation to labour standards on cruise ships and in relation to migrant workers. Is it appropriate to ask them now?
Can I suggest that's probably the workplace relations outcome, depending on the specific questions, but
Which is where we're heading next.
That's right.
Okay, so do you want me to try them out here or just go to the next one?
Well,
I suggest going to the next.
We'll do them where
Okay.
they belong in outcome 3, which is where we're going in a moment, but I just will seek advice from the table regarding questions on corporate and cross-portfolio if there are further questions before we move on. You can put them on notice. Does anyone have? Okay. All right. In that case, then we'll move on from cross-portfolio on the
star this committee.
on the dot. Minister, don't get ahead of yourself. Okay, so we will now be moving to outcome 3, workplace relations. So we'll just give officers, we'll just suspend for 30 seconds as officers shuffle to the table.
We are in a downstairs committee room, so if we could
It
just
may
have
be
a
more than
couple of
30
minutes.
seconds,
Yeah.
yes. I will
I
resume.
might just do a quick bathroom break in that case.
Happy? Yeah. So for this one, we've got
It's just a bit above where it would be.
Issues with audio have been resolved, so if I could ask people. Being resolved, so the committee will be able to resume. And we are in outcome 3, workplace relations. I have the call to pass to Senator Pocock first, and then I'll be coming to the Deputy Chair. So Senator Pocock, you have the call. I'll just seek guidance from the table. We have been doing 15-minute blocks for corporate. Do you want to speed that up for this section? Because I can do 10-minute blocks. Okay. All right.
Tell me when to stop.
We'll work with 15 and see how we go. Senator Pocock, you have the
just
call.
a couple of follow-ups, given that you're both here, Acting Secretary and Minister, on what we were just talking about. I just wanted to check, did the Secretary, Ms James, at any point provide advice to the government around stopping all penalties under the TCF?
Senator, not that I'm aware of. The powers under the Social Security Administration Act are powers that vest in the Secretary. She was, at the time, actively monitoring, and we continue to do so. So I'm not aware of any advice. I'll take on notice to double check, but I'm not aware of any advice that went to suggest that we were stopping all penalties under the TCF.
And similarly, if you could take on notice, did the Secretary at any time provide advice to the government around stopping payment suspensions under the TCF? You could...
I'll take that on notice just to be sure, Senator, but there's nothing that comes to mind that I'm aware of.
And also, did she provide any advice around removing the TCF permanently?
Let me take that on notice. Yep.
Great, thank you. I wanted to go now to some questions around recent reports on working conditions on cruise ships and ask about what's going on and what you're looking at. The allegations, of course, will be known to many in the room, where workers have been forced to live in overcrowded conditions below decks, not to get safe drinking water, and earning as little as $2.50 an hour. Is the Department aware of the investigation that's underway by the Australian Maritime Safety Authority and these alleged conditions of work?
Senator, I'll go to my colleagues. Obviously, particular conditions in specific industry sectors. There may also be questions for the Fair Work Ombudsman, for example, but I'll seek advice from my colleagues.
Yeah, I was going to say that. Senator Greg Manning, Deputy Secretary Workplace Relations. We can talk briefly. We're aware of the media reports that saw them yesterday. I think those questions are ones where the Fair Work Ombudsman is going to be able to assist more, but we can speak briefly perhaps about some work that they're doing, and they could speak in more detail about it when they appear later, if that assists.
Thank you.
Thanks, Senator. Lavinia Grachiganchevska, Assistant Secretary, Workplace Exploitation Branch. The Fair Work Ombudsman is engaged in a pilot at the moment that is looking at monitoring the Seagoing Industry Award Schedule A wages on foreign vessels that are engaged in coastal trading under a temporary licence. And that involves working very closely with the Australian Maritime Safety Authority and doing onboard inspections. The purpose of that pilot was in response to stakeholder concerns about non-compliance on those vessels and to help ensure seafarers on those vessels receive their lawful entitlements under Australian law. There have been around 28 investigations. I think 26 of those are underway at the moment. Probably further questions about the specifics would be best directed to the Fair Work Ombudsman.
Do you have there in front of you over what period of time those investigations have occurred?
So the pilots began in November 2024, and let me just check. I think as of 30 September 2025 is the number of investigations occurring as of.
Okay, so what is your role in relation to these allegations? Tell me what you're doing.
We're responsible for the framework, I suppose, in relation to assisting governments that put in place the legislation under which the investigations are occurring. The pilot that's been referenced to was, I think, I'd have to take on notice the details, but was attained through some separate budget funding to Auspice Flow's usual ability to do work in this area, so we'd help with that as well. But in terms of the actual investigation, the liaison with AMSA, going on board the vessels, etc., that's all the Fair Work Ombudsman.
So what was the pilot specifically? There's clearly an investigation, but what's the pilot?
The pilot was, the focus of that was to increase that monitoring on those particular vessels and check compliance with wage entitlements for those seafarers,
So is it correct that Article 3 of the Maritime Labour Convention requires that those subject to the Convention respect the fundamental right to freedom of association and the right for everyone to collective bargaining? Can you confirm that?
I don't have that knowledge, Stuart.
Could you repeat that, Senator?
So I'm referring to the Maritime Labour Convention. Article 3 requires that those subject, I'm asking you to confirm, subject to the Convention respect the fundamental right to freedom of association and recognise the right to collective bargaining. This has been a real issue for these workers in public reports, access to collective bargaining and access to the right to organise.
I don't have a copy of that in front of me, Senator, but I assume, given you're reading it, that's correct.
Okay. Is it correct that the provisions of the Fair Work Act which create a pathway to collective bargaining for workers cannot be accessed by the crews on foreign-owned vessels flagged in a country other than Australia who have been exempted from the Coastal Trading Act by the relevant minister?
Senator Stuart Kerr, I'm the Assistant Secretary and Senior Executive Lawyer in our Workplace Relations legal area. The extent to which Australia can apply the Fair Work Act overseas or to foreign employers is quite fact-specific and dependent on the particular circumstances. So I'm hesitant to express a view on the basis of some recent media reporting about the particular, I think, case you're referring to. But would it assist if I provide a general overview of how the Act applies?
These workers, yes.
Yeah.
And obviously brevity is valued.
Understand. I'll do my best, Senator, at a framework level. So I think the key issue is that an employee's nationality or visa status does not impact their Fair Work Act coverage. The Federal Court has held that the Act applies basically to employment relationships that are in and of Australia. So the key issue is the status of the employment relationship, and that can go to issues sort of like where the employment contract is made, the place where the employee is obliged to perform work and so on. There is some extraterritorial application of the Fair Work Act, and that includes to certain ships engaged in coastal trading, which is, I think, what you're referring to. The legislation regulating coastal trading is actually managed through the infrastructure portfolio, not this one. So any detailed questions on that are probably best put to them. My understanding, though, is that the infrastructure minister has made an instrument exempting cruise ships from coastal trading. So, as I say, that's a sort of general overview of how the Act may apply, but I can't really specify this particular case.
So a blanket exemption by the minister in another department which severely affects the labour standards of a group of workers who are certainly engaging in work which Australians have other beneficiaries of, is a real concern, is it not, Minister? What's your view about that blanket exemption, which means those workers are not protected, as I understand it?
I would need to know more about the situation to really comment on it, but as a general statement, the Albanese government strongly supports the rights of all workers to be treated fairly and paid well at work, which is why we've undertaken so much workplace relations reform that's delivering better pay and conditions for workers.
So is there any law that prevents the MUA from negotiating an agreement for workers in a jurisdiction that sits alongside and is not subject to the Fair Work Act?
I think we'll have to take that on notice, Senator, because we're talking about the interaction between two systems. Why don't we take it on notice and attempt to address your concern specifically? I think there is a review in the infrastructure portfolio underway at the moment about the application of these things. So
is that right?
That's my understanding. Okay. But again, that's questions directly. But again, on notice, we can flesh out what we know about that.
And could you give us the details of that review, its parameters?
If there's a publicly available terms of reference, etc., we're happy to do that. Otherwise, there's questions that could be directed to infrastructure about the parameters of it. Yeah.
Okay. I think there's a lot of public interest in it. And I'll ask this question, you may take this on notice as well. If workers are excluded from the provisions of the Fair Work Act, which create a vehicle to commence collective bargaining, and the MUA has sought to invoke the Maritime Labour Convention Article 3 by commencing collective bargaining with a ship owner on behalf of its crew, and the ship owner has refused to bargain, is that ship owner in breach of Article 3 of the Maritime Labour Convention? I'm sure you go to bed every night reading that convention.
Yeah, as you're asking the question, I must admit I would have to check whether the convention, if it applies to nation states, as most international treaties do, or whether it applies to individual businesses, which your question's sort of based on. So again, we would need to take that on notice.
Okay, great, thank you. I look forward to hearing those answers on notice.
I might just do a supplementary question, just to thank Senator Pocock for raising these issues as well, but also just the general concern about those allegations that were made in the media. There are obviously, as from the participating member of the committee, deeply concerned about what this means for those workers that are working on Australian coastal shipping. There is questions about what actually applies and what the law and how the law applies and how it's managed, and that's obviously the department and the Department of Infrastructure's responsibility. But also, however the law applies, many of us, including myself, are seeking justice for those workers if those allegations are proven to be correct. And I've got a great deal of confidence that those allegations have a great deal of veracity, and I'm deeply concerned about them as well.
Yeah, it's those issues that led to the pilot that we've discussed earlier in relation to the flow, so turning it into actual enforcement, if you like, and I'm sure the flow will be able to answer questions about their actions under it, and they're working with AMSA when they appear later on.
I think a lot of Australians would be really surprised to learn that their fabulous holiday is underpinned by conditions that we've been hearing about. They're so appalling, and it's not just, of course, the black and white regulation, it's also the enforcement that we need to be paying attention to. So thank you. Look forward to your response.
You've got about 3 minutes left.
Okay, let me have a go at this. I wanted to go to the question of the PALM scheme, the Pacific Australia Labour Mobility Scheme, which has also had some attention in the press in recent times. We've got reports out of Peter Mayer's, you may well have seen it, a bunch of recommendations to improve the scheme. Very concerned about making it easier for palm workers to change jobs rather than tethering them, as some reports describe it, regulating labour.
Sorry to interrupt you. That's the next outcome.
Okay.
The PALM scheme. It's an employment.
Yep. Okay, great. Thanks, Minister.
Thank you, Senator Pocock. Senator Kovacic, you have the call.
Thank you very much. I just wanted to have one question on notice relating to some of the questions that Senator Pocock asked before. I want to understand on notice if the Minister provided any feedback in relation to any response to advice from Ms James in relation to the targeted compliance framework. So did the Secretary at any time provide advice to the government around stopping the payment suspensions under the TCF? And did the Secretary provide any advice around removing the TCF permanently? So on notice, if the former Secretary did provide that advice, did the Minister provide feedback formally or informally? I'm not asking for the details of the feedback because that Minister Watt may suggest is cabinet in confidence. I just want to know whether feedback was provided.
I can take
Thank
that
you.
on notice.
Thank you, much appreciated. Okay, I want to now return to matters that I've canvassed previously in relation to the CFMEU and the Administrator. And just to get a factual flow of the last few months, particularly given this serious information in the newspapers this morning. So since the Administrator has been put into place, the administration had comfort with the Secretary of the Vic-Tas branch, Zack Smith, arranging meetings with the underworld figure Mick Gatto. Zack Smith facilitated ongoing conversations with the disgraced former head of the CFMEU, John Setka, without the Administrator's approval. Zack Smith resigned from the National Executive of the Labor Party. Zack Smith then resigned from the National Construction Industry Forum. And then finally, Zack Smith removed himself from the CFMEU. And then, in addition to that timeline, I want to place on the record, or the information I want to place on the record relates to Mr Geoffrey Watson SC and the report he referred to at the recent Commission of Inquiry in Queensland. And at that inquiry, Mr Watson advised on the record that he would soon be providing a report into the Victorian Division and that he intended to complete it by the 1st of December. And in fact, he did. And at our last hearings, you advised Mr Manning that the Administrator's practice had been to release these reports publicly. And so far that hasn't happened. The report has been completed, but we are now in February and the report has not been publicly released. And so now this is a matter of media reporting today, which raises serious questions about the handling of the report, including whether multiple versions of this report do in fact exist, whether sections were removed after completion, and whether findings critical of the government were withheld from that report. These developments are particularly concerning given the seriousness of the matters under investigation or examination and the Minister's repeated statements of full confidence in the Administrator and the characterisation of the administration as the strongest possible. In light of that reporting, it is important for this committee to understand what the department knew, when it knew it, what versions of the report it has received, and whether any changes were made to the report after its initial completion. So my first question with that background is, can you confirm if the department has received a copy of the Watson report?
Senator, I might just go to a couple of matters in that introduction comment. I think you said that at last estimates we discussed that Mr Smith had met with Mr Setka without the permission of the Administrator. That's not correct. His letter we discussed said that he knew of those meetings.
My understanding is that there were admissions both with the Administrator's knowledge and without.
Well, the letter that we discussed at last estimate spoke about...
there was a letter and other discussions. We can leave
couple of cases. I just wanted to raise that. And I think you also said that the report was... is the subject of your question was finished on 1 December. That's not my understanding, Senator. So
your understanding is that it was not completed by the 1st of December?
We had a conversation at last estimates, which I think was on the 3rd of December, where you were saying, had we sorted, it was meant to be finished on the 1st, and referring to comments Mr Watson made about his keenness to finish it by that date. That's different from saying it was finished on that date.
So to your knowledge, on what date was it finished?
At the end of January, Senator. So
do you know the date at the end of January?
From memory, the 27th is my understanding.
Okay, so it was completed on the 27th. I'm actually going to ask you some more questions about that, but I just want you to answer the first question first. So you have received that report and you received it at the end of January?
No, Senator.
Okay.
And I should just say, I am conscious that Mr Watson is giving evidence before the Queensland Commission of Inquiry today, very soon, Queensland time, so I imagine it will be happening there. But in terms of...
This isn't in relation to his evidence, this is in relation to when you received the report. I'm sure he's not giving evidence in relation to that.
So we received a copy of the report late on Monday afternoon.
Of this week?
Of this week. So Monday just gone.
So on Monday the 9th of February. Okay.
Yes. And we received a version of the report. My understanding in terms of the process that led to us receiving it was that there was an expectation from the administration that it would be made public as a result of it, the notice to produce to the Queensland Inquiry on Monday or Tuesday or possibly Wednesday of this week. The administration provided a copy of a redacted version of the report to the General Manager of the Fair Work Commission on that day and copied that to us.
So the Fair Work Commissioner received a redacted version and you were copied into that communication. So the department, and that was on Monday because there was a view that it would be publicly released in relation to what was occurring in Queensland.
Understanding.
So just so I have this clear in my mind, until such a time as it was going to be publicly released, you were not provided with a copy of a report that the administrator had, and when you received it, you were copied into it, and it was a redacted report.
That's right, Senator.
Right. Okay. Did you have an awareness that the administrator had received the report on the 27th of January? At that time, or you only found that out on Monday?
I mean, consistent with the evidence we gave at last estimates, I think gave evidence to the effect that the administrator, when getting work done, normally then assesses that work and decides what to do with that work, including when to release it. So we hadn't had any advance copy of the report, for example, before it was provided to us on the date we just went over.
You only became aware that content had been removed from the report on Monday when you received that redacted copy.
When we talk about the redacted copy, the version we received on Monday spoke about redactions occurring for protecting people who'd provided information. My understanding, I can't confirm this, but my understanding is it's the version that was provided to the Queensland Commission of Inquiry, and those redactions were provided to the Queensland Commission of Inquiry. That's separate from the issue that's been ventilated in the media today.
Right. So are you telling me that it's your understanding that this is for my clarity so I don't get confused, that the version of the report that you were given on Monday was a redacted version, and that is the same redacted version that was provided to the Commission of Inquiry?
Jodie Anderson, First Assistant Secretary, Workplace Relations Policy Group. Yes, Senator, as Mr Manning stated, the version that we received was a redacted version, and the advice that we received, we have informal meetings from time to time with the administration team, and they advised us that they would be submitting a redacted version to the Commission Inquiry, and I think that had occurred, and I'm not sure of the date of that that it was submitted to the inquiry, but certainly we were provided on the basis of getting a redacted version because of the concerns to witness statements within that version.
Thank you. The other thing I'm seeking clarification on is, do you know which version of the report you received noting the redactions, but did you receive the full report or the report that had sections removed?
What my understanding, Senator, is we received the final report.
So not the original report?
Not earlier drafts, the final report.
So I'm not speaking about earlier drafts. I'm talking about the fact that Mr Watson provided a report that the reporting today is saying had sections or chapters removed. So you don't have the report pre the removal of the chapters, is that correct?
The report we received on Monday was not that report that was pre-removal. I know where it sounds like we're engaged in semantics, but my understanding is that the process was that a draft report was provided. The administrator's made a statement, I think, that he asked for 2 sections to be removed, or directed Mr Watson, the media says, and I think that's my understanding as well, that 2 sections be removed because he wasn't satisfied they were well-founded. They were removed, the report was finalised. It's that final report that we received a copy of, which includes redactions about identifying information out of concerns for the safety of the people identified.
Right. So there were 2... So I understand about redactions. Yeah. That's a different story. But and I know you said it sounds like semantics. Why do you actually say it sounds like semantics?
No,
because
I said I'm trying not to sound like I'm engaging in semantics because I'm saying there's one report, and our understanding is we received a copy of that report. The media today speaks of previous versions of that same report, but you're talking about 2 reports. So that's what I'm just wanting to clarify.
Well, I don't know how many there are. That's what I'm trying to find out, how many versions of this report there are. And just to clarify, and I'd love to hear your thoughts, Acting Secretary, is that we have a problem where we have a report that's been commissioned from Jeffrey Watson to tell us what is going on and what is wrong by the best possible administration. The administration has then received that report and then asked the person who's provided the independent report to remove things that they don't like because they don't think it's well-founded, even though they weren't the ones conducting the report, and they may well have been the ones that the report was suggesting weren't doing what they should be doing.
Well,
so that is a significant concern. And
my understanding, and happy to be corrected if this is wrong, is that the administrator commissioned a report from Mr Watson. It's a report to the administrator. It's not to the world at large. It's to the administrator to enable him to continue his very good work in cleaning up the CFMEU. It's then a matter for the administrator, Mr Irving, to make a judgment about that report and what should be released publicly. And he's obviously made a judgment that there were aspects of that report that were not well-founded. It's a report to him, and it's his call about what gets released. Again, happy to be corrected if that's wrong.
So without commenting on the safety of individuals, what is your understanding of what was in the sections that were removed?
Senator, I don't think we can answer. In many ways, as the minister's outlined, the report, as I understand it, the administrator commissioned it. He was working with Mr Watson to make sure that he got a final report that was robust. The department received a copy of the report on Monday afternoon, as Mr Manning's outlined. It's the first time the department has received the report. We're not aware of the other versions in terms of what they did or didn't contain.
So you
beyond what's in the media today.
Yeah.
You have no knowledge of what was in the chapters that were removed?
No, well, my understanding is the same as what's reported in the media, in that there were chapters that went to estimates of costs of corruption in the building sector and estimates that went to knowledge about corruption in the building sector. They are the 2 factors which, based on the content of that draft, the administrator formed the view that they weren't well-founded or properly tested, and so directed Mr Watson that they be removed from the report before its finalisation. That's the extent of our understanding. So.
we're due to rotate. If you've got one more question to place, Senator, and then I'll rotate to Senator Mulholland.
So you've received the report on Monday. Will you be seeking any advice or independent verification of whether the removed material was not well-founded or properly tested?
I don't think we're in a position to do that, in the sense that it goes to the administrator's conclusions around, for example, discussions that Mr Watson had, etc. And I think these are issues that will be, I would expect these are issues that will be discussed at the Queensland Commission of Inquiry, so we'll get more information about that today, I imagine.
I'm hearing Senate estimates. I'm not at the Commission.
No, but I'm just saying I would expect fairly soon that there'd be further information in the public domain about that, but I don't think we'll be able to go and verify that.
No, I'm not asking you for verification. I'm asking you whether it's something you would look into as a matter of course as to whether or not they were in fact robust, because it was an independent report. I'm wondering whether you're concerned that there's a conflict there for the administrator, and whether perhaps you should look into what was there and if in fact those chapters related to connections to the government.
Well, my understanding, Senator, is there's no connection to the Australian government raised in those chapters. It's so I'll just come back to what the Minister said about the report, the nature of the report, and being prepared.
So just to clarify again, have you seen the chapters that were removed?
I've seen the material that was removed, yes.
You have?
Senator, we are due to rotate. I'll come back to you after the following rotation on this call. And can I just ask senators who've joined the room, if you haven't, let me know if you're seeking questions in this outcome to do so I can add you to the queue. Senator Mulholland.
Thank you, Chair. Now, my questions relate to labour hire and the same job, same pay legislation. Thousands of workers are already benefiting from Labor's same job, same pay laws across the country. Last estimates, I asked some questions relating to workers in central Queensland mines who had secured pay rises of up to $30,000 per year. Today, I would like to ask about some retail, distribution and logistics workers in Queensland. In particular, I would like to ask the department about a recent same job, same pay order for a Queensland Kmart warehouse located in Lytton, where the SDA union made an application for an order. Can the department please provide an overview to the committee about how the Albanese Labor government's closing the loopholes legislation has allowed for these pay rises?
Senator David Keynes, Assistant Secretary, Bargaining and Industry Policy. Senator, the government introduced reforms which allow entities to make an application to the Fair Work Commission for a regulated labour hire arrangement order in its closing loopholes legislation. So parties have been able to apply for orders since 15 December 2023, and orders have been able to commence since the 1st of November 2024. So far we've seen more than 8,000 workers benefiting from these provisions, and that's through in excess of 100 orders. In relation to the particular case you're talking about concerning Kmart, we're aware that an order has been made covering Kmart's Lytton Distribution Centre in Queensland. We understand that up to 200 warehouse workers will receive pay rises of up to $12 an hour under that order. So the labour hire provider there is Program Skilled Workforce, and that the application was sought by the SDA.
Thank you. So you've mentioned there around $8 to $12 an hour. Do you have an average pay rise? I mean, if I did the numbers in my head, let's say $10 an hour by 38 hours times, 50 odd weeks, it could be up to $20,000 a year. Have you got an average pay rise, a total pay rise for a year?
I'm sorry, Senator, I don't have that information in front of me, but obviously $12 an hour, as you say, over the course of a working week, and over a year would be a very substantial pay rise for these workers.
Okay, so based on what we know, just to confirm, up to about 200 or 180, you said, warehouse workers at the Kmart distribution centre in Lytton are benefiting from up to $12 per hour because of the government's changing the loopholes legislation changes and the order that was brought. That's correct?
That's correct.
Okay, thank you very much for that. Minister, can you please elaborate for the committee on how Labor's same job, same pay legislation is benefiting workers and putting more money in the back pocket of Australian workers in particular?
Sure. Thanks, Senator. These changes, the same job, same pay changes, are a really critical part of the government's wider workplace relations reforms. You'll be familiar that when we were first elected in 2022, one of our core commitments was to get wages moving again. We'd seen 10 years of deliberate wage suppression under the coalition government, which had seen real wages fall, so wages not keeping up with the cost of living. These changes are a significant reason why we're now seeing wages rising above inflation, which is obviously really important to working people when they're feeling cost of living pressures. You've heard some of the figures in the retail sector. You've previously heard some of the figures in the mining sector. We've also seen orders made in meatworks, in other warehouses, in a range of industries, and that's putting more money in the pockets of Australians who are not typically that well paid. So a really critical part of our reforms to workplace relations, and it's really terrific to see them working in the way that we had hoped.
Thank you. Noting that under the former government, their record of keeping wages low for some of our most vulnerable and minimum paid workers was pretty abysmal across, as you say, retail and warehousing sectors. Can you please confirm and remind the committee on the voting record of people in this parliament, particularly when it comes to same job, same pay legislation and about Australian workers' pay packets?
I'd be delighted to do so, Senator. So it is worth remembering that when Labor passed these laws through the Parliament, they were opposed by the Liberal Party, the National Party and by Pauline Hanson's One Nation Party. We've heard a lot of talk over the last week or two about an emerging coalition between those three different parties. Not sure if it would be led by the Liberal Party or the National Party or Pauline Hanson's One Nation Party, but what we know is that those three parties voted against these changes as they voted against every change we've made to workplace laws which has lifted people's pay. So, you know, particularly, I mean, I don't think anyone's surprised that the Liberal Party and National Party voted against those laws, given they've typically always sided with big business on workplace matters. But I think a lot of Australians would be surprised to learn that Pauline Hanson's One Nation Party joined with the Liberal and National parties to vote against these laws. I know from my time in Central Queensland, and you would know yourself, Senator, from Central Queensland, that there are a significant number of working people who have been voting for Pauline Hanson's One Nation Party. I don't think they necessarily are aware that that party in Canberra votes with the Liberal and National Party to suppress wages. So for a party that claims that it's standing up for battlers and people who are struggling, when they come to Canberra, they vote with the Liberal and the National parties to drive down wages. And they should have a think about whether they're being honest with the people who they say they're representing.
And specifically 200 workers at Kmart in Lytton would be $12 worse off if they had their way.
That's exactly right. And I mean, I think the other thing going forward, who knows whether Ms Lee will be the leader of the Liberal Party by the end of the day, but she has said that she intends to have a battle on workplace relations policy at the next election should she remain the leader. So I guess the only way we can interpret that is that this ragtag coalition of the Liberals, Nationals and One Nation would seek to change these laws, which, as you say, would amount to a pay cut of $8 to $12 an hour for workers at this Kmart distribution centre and thousands of other workers around the country who've benefited from these laws.
8,000, I think you said before, 8,000. So thank you.
Thank you, Senator. Returning the call to Senator Kovacic just before I do, just to give senators an indication of where I'm going next. We do have some issues with audio, so we will have to break right on 11, Senator. which is about 15 minutes, and then I'm coming to Senator Payman. I'll return to the opposition and then Senator Pocock. So if you can be here after the break. Senator Kovacic, you have the call.
Thank you. Just for clarification, does the department understand that the author of the report has stated publicly that he was directed to make changes and may not have necessarily wanted to make those changes?
I understand from the media reports today indicate he's directed, so that's my understanding. Whether or not his attitude to making the changes, I have no information about, Senator.
Okay. And Mr Manning, you, before the end, just as we ended my last block, you said that you had seen the copies of the sections that were removed, or you had seen the sections that were removed. Did you ask for those? Were they provided to you voluntarily? How did you come to receive those sections?
So last night, I don't have the precise time, after 9:30 p.m, the General Manager of the Fair Work Commission let me know, I think it's because they'd become aware of the media reports planned for today, that the Administrator had made a statement about them and had provided them to him, and he subsequently forwarded them to me.
Okay. So, so you only became aware then last night that there were sections that were removed?
Correct.
Right.
So I should just say I had become aware at around after 6:30 last night about the media, and they went to that issue. So that was my first knowledge of the issue.
So up until that point, you had received a copy of a redacted report on Monday that you believed to be the full report, and last night, when perhaps some media chatter began or whatever occurred, you then became aware that there were 2 chapters that had been removed. So you held the view on Monday that that was the report, and then last night you found out there were chapters removed.
I held the view on Monday and still hold the view that it was the final report with redacted chapters.
Yeah.
It turns out that in the finalisation of the report there had been some information removed at the direction of the Administrator.
Yeah. Do you? Is it your view that that the author of the report actually thought that the report that he handed to the Administrator was in fact the final report and not a draft?
I don't have any knowledge of that process.
Okay. Yeah. So the language that we're using is draft, and that's a language being provided by the Administrator, or is that a language that the department is using?
That's language we're using, but it's been provided by the Administrator.
Okay. Right. So we would need to understand from the author of the report if, in fact, Mr Watson intended the report that he provided to the Administrator to be a draft, or if that is something that's now been conveniently manufactured by the Administrator.
Well, my understanding is that, I mean, the Administrator has auspiced a number of reports from a number of different people. My understanding is his usual practice is he would get a draft. It's sort of not surprising to me, to be honest, that you would get a draft of a report and look at it before finalisation, whether it be this report or any of the other work that he's had done.
Perhaps. I think it would be unusual, though, to remove chapters that you don't like, because and I mean you've seen the chapters, I haven't. That perhaps create issues for the Administrator and have those removed. But I will move on. Were you advised last night who directed those chapters to be removed, whether it was the Administrator or whether it was the Administrator perhaps in conjunction with the Minister?
Now, my understanding is it's solely the view of the Administrator and that he directed the changes.
Okay.
Can I just pick up? I think it's important to be accurate, Senator.
It is.
The Administrator's stated reason for redacting those sections was that he believed they weren't well-founded, not that he didn't like them. And we shouldn't pass it off as something other than what it is.
And I agree, and perhaps we should say that the sections were removed, not redacted, so they're actually deleted from the report.
I'm not going to quibble
to the point
about
that the department didn't know they existed until last night at around 9:30 p.m.
Sure. I'm not going to quibble with that.
Were you aware, Minister, that the sections of the report had been removed?
No, the first I knew about this was when I read the article this morning.
Thank you. Was the department advised whether that direction to remove the sections was provided to the author of the report in writing or verbally?
I don't know, Senator.
Okay.
Said
You haven't been given that
no
information?
information.
You don't have that information? Okay. And this is a question to you, Mr Manning, and to you, Minister. To your knowledge, did any government official or ministerial office have visibility of the full report or draft report, whatever we want, the report prior to the removal of the chapters, before those chapters were removed?
Not to my knowledge, no, Senator.
Not to my knowledge.
Thank you. And on that basis, you would not have knowledge of whether any commentary was provided in relation to that?
Correct.
Does the department think that that's okay, particularly?
That's an opinion. So.
I haven't finished my question.
Yeah.
Yeah.
Well, why don't I let you finish your question before I...
Yeah, because there's a bit more to go after it. What I'm trying to understand is if we're getting a report that relates to something, and maybe I'll change it and won't say, does the department think it's okay? Is it usual practice, or would you consider it good practice to remove findings from an independent report?
I'm happy for the department to answer this, but can I just take the opportunity just to remind you and other senators, if you like, about the structure of this whole administration process. I've noticed in a number of your questions, Senator, you've talked about this report we've received, or this is not a report to the government. This is a report to the administrator to assist with his management and cleaning up of the union. He is an independent person that's been appointed through an Act of Parliament, and he has independently commissioned a report from Mr Watson that's been provided to him. It would appear he believed sections were not well founded, took the action that he did. I can only presume that he's provided a copy of that report to the department as a courtesy. I can only presume. There's no official role for the department in regulating him.
I understand. I just wanted to understand what the department knew, and I'm happy to take on notice the answer to that question in relation to whether the direction was in writing. So if I could have that on notice, if you could find that out for me.
Just to clarify, Senator, further to what the Minister said, we don't have that knowledge. It's not another agency, for example.
The Minister can provide that on notice. And my next question is to the Minister. Do you know if the Minister has spoken to the Administrator in the last 24 hours?
I do not know that.
Okay. Thank you. So I guess what we're trying to understand here is whether there was any impact and what the reasons are as to why an independent administrator would remove sections of an independent report that allegedly speaks poorly of the government. So that is the information that I'm trying to get an understanding of here.
Well, the Administrator has answered that question in the media. He has said that his view was that sections of the report were not well founded.
Yeah.
Now, that might not be the answer you're looking for, but that's what he has said.
Could you take on notice for me, Minister, whether the Minister has met with the Administrator in the last 24 hours or if the Minister has sought to meet with the Administrator in the last 24 hours?
Sure, happy to take that on notice.
Are either of you able to tell me what the chapters or the sections were called and what information was in those chapters that the Administrator deemed not to be liable?
I'm going to refer to my earlier answer in which I referred to the media reports about the subject of those chapters.
You've read the chapters.
Yeah, I said I can't recall the titles of those chapters off the top of my head, having received it late last night and then prepared for estimates this morning.
Well, if you could provide that on notice, could you tell me then what was the general subject matter of those chapters?
Yeah, well, I'll refer to my earlier answer. The general subject matter of the chapters went to the costs of corruption in the building industry and knowledge, if any, in the Victorian government of what was occurring.
Okay. So when you answered my question before and said they didn't relate to the federal government, they just related to the Victorian state government and the knowledge of ministers, the Premier, like which individuals?
Senator, can I just state, Mr Manning's informed you he received those chapters late last night. I suggest we take this on notice. I can't expect my deputy to have read all of the content of those chapters.
Of course. I'm not asking... Yeah. I do appreciate that, Acting Secretary, and I'm not asking for specific details. I assume that if I had read that report, as I read many documents, as you know, did my fellow senator here in relation to these matters at 10:30 and 11 p.m. last night, if I had read them, I would know whether they related to senior ministers in the Victorian state government and whether they referred to the Premier of Victoria. So that's all I'm asking.
At this point, sorry, Mr Manning, at this point, if the official has taken the question on notice, they are entitled to do that, and that closes off the question. So you can place another question to them, but if they're taken on notice, that is within their rights. Senator Kvasic.
Was there reference to the Victorian Premier in the chapters, to the best of your recollection, in the chapters that were removed?
I don't recall there being anything specific about the Victorian Premier. I actually will have to take that on notice.
Okay, thank you.
Sorry, can I just clarify with that question? The Victorian government of that time.
The chapters, yes.
Just the confirmation.
Yes.
That was. Thank you.
Is the department worried, and do you believe there are concerns that need to be addressed in the nature of removing these chapters and the risk to public confidence, particularly in relation to the administration and how we navigate that moving forward?
I'm happy to take that, Senator. I cannot stress the confidence that or cannot overstate the confidence that this government has in the administrator. I mean, you know, we were lectured for years about the ABCC and how great it was. It did not remove a single official from the CFMEU, despite what we all know now was going on there. In the time the administrator has been there, he has removed or accepted the resignations of over 120 staff, more than 2/3 of whom were in leadership positions or organisers. That's in addition to the people who were removed as part of the when the administration first occurred. He's put in place a code of conduct for the first time within the union around expectations of behaviour. More than 75% of organisers in New South Wales and around 50% of organisers in Queensland and South Australia have been replaced since the administration began. He's commenced a union education and development unit to deliver ongoing education and training to change the culture of the division of the union. I could go on.
Thank you. I have heard that
attempts
before.
to besmirch the administrator. I mean, and I notice you've called for him to be sacked, which is just ridiculous. Absolute. You want a guy sacked who has removed 121 staff of this union, including more than 75% of the organisers, when your party presided over an ABCC that did nothing.
Minister
and
Watt,
allowed this to flourish.
I could go through my preamble again, but I do have one question on notice, which I would like...
Senators, actually, I'm making ruling as chair. We are due to break at 11 o'clock. That is because we've got, as you will all notice, some quite serious audio issues that we need to resolve. So it's 10:59 now. I'm happy for you to place a short question, and then we need to move... Well, it's 11 o'clock now, so we need...
well, it'll take me 30 seconds, and then I'll finish this block. Mr Manning, if you could please provide those chapters that you received last night on notice to the committee. Thank you.
Can I just very quickly add, not just the government has confidence in the administrator, so do all the key construction industry groups. The only people who don't are the Liberal opposition, who did nothing about what was going on in this union for 10 years.
Thank you, Minister. I just need to confirm, Mr Manning, did you take that on notice?
Yes, Yes, Chair. Noting that I understand from the media reporting the administrators released them, so they should be publicly available.
Well,
I don't know where, but I'll take that on notice.
That's very simple to provide.
Thank you, Mr Manning. We've
Thank
taken
you.
that on notice. The committee will now suspend for 15 minutes and hopefully returning with an improved audio. Right, the committee will now resume. We are remaining in outcome 3, workplace relations, and Senator Payman, you have the call. Senator Payman.
Thank you, Chair. Good morning. My line of questioning is around the Fair Work Amendment Baby Priors Act 2025. With regards to the Act, were unions consulted on the legislation before it was tabled in Parliament?
Senator, we'll just let the officer come to the table. Thank you.
Anshu Desilva, Assistant Secretary, Equity, Title and International Branch. The reforms were subject to the usual consultation processes that come with amendments to the Fair Work Act. That does include consultation through the Committee on Industrial Legislation, that does include unions and employer representatives, and there's also consultation with state and territory officials as well.
Fantastic. Which unions were consulted on the legislation?
I believe it's the ACTU on behalf of the union movement.
So just the ACTU?
Yes, that's correct.
Okay.
Well, they are the peak body for all unions.
Yep, no, I understand. Just wanted to get that confirmed on the record.
Senator, just to add, it may well be that the Australian Services Union was specifically consulted as well, because baby Priya's mother or both parents were members of that union, and they were very involved in this too.
So can I get a complete list of the unions consulted? I mean, we've just heard that ASU could have been also consulted.
Thank you, Senator. We can certainly take the full list of those.
Appreciate it. So when drafting the Baby Priors legislation, I'm curious to understand if the government considered including other forms of reproductive leave that unions, including the ACTU, are calling for, which would allow for 10 days of extra leave enshrined in the NES to cover things like menopause, endometriosis, miscarriage and fertility treatment.
Thank you, Senator. The Baby Priors legislation was progressed in the context of a specific election commitment that was really addressed to provide clarity for grieving parents and employers about the treatment of employer-funded paid parental leave in circumstances of a stillbirth or the death of a child. So the consultation and engagement did not engage beyond those parameters, but I am happy to take you through the existing frameworks that apply to reproductive leave, if that would be helpful.
Yes, that would be great, thank you.
So, Senator, there's no specific category of reproductive leave that's currently in the Fair Work Act. However, there are a number of aspects of the Fair Work Act that that may enable some workers who are experiencing reproductive health issues to be able to seek access to entitlements under the National Employment Standards. For example, there's personal and carers leave that is available to them. There's also provisions in relation to flexible working arrangements as well that may be of assistance. The government has also made a range of reforms to enterprise bargaining, including the supported bargaining streams that does enable workers to be able to negotiate specific entitlements.
Thank you. Wonderful. And Minister, would you say that reproductive leave and expanding reproductive leave is something that the government may consider during this term?
I wouldn't want to speculate at this point about what, if any, further workplace relations reforms the government's going to consider this term. I mean, I'm certainly aware that there's a number of unions who have been campaigning for that. We will give that consideration, as we will, a range of other issues that are raised with us.
Senator, I'd just add to that, there is an inquiry into the national employment standards that's underway at the moment, and I would expect that various submissions to that will look at these issues of adequacy of leave and different types of leave for different types of employees.
Yeah, absolutely. Yeah. Fantastic. Thank you for your work. Thank you, Chair.
Senator Payman. Senator Kavassi.
Thank you. Just going back to the questions in relation to this report and the removed chapters, do either of you have any awareness, Minister or Mr Manning, whether the Minister was advised in advance that the Administrator was going to seek sections of the report to be removed?
I don't have any knowledge of that.
I don't either, Senator.
No? No. All right. Was the Minister advised that the author has since stated publicly that he was directed to make changes, and has there been any discussion or concern in relation to that?
Given that, we earlier went through the timeline, it was reported in the media today, I saw those articles today, I haven't provided any advice since those articles were published in relation to the issue, Senator, so not by the department.
And the Minister hasn't sought advice this morning?
Not that I'm aware of, but it wouldn't necessarily be, given that I am here.
Not to your knowledge so far?
That's right.
Okay, thank you. Would it be a regular practice if there was such a report that perhaps had contentious elements that were removed for the Minister to seek your advice on that, or perhaps even legal advice on that?
Remember, as I've said before, it's not a report to the government, so it's not the government's report.
I understand. I'm just saying, in general practice, would that be something that would occur?
It's not something that's occurred in relation to the various reports that the administrators produced. As I said earlier, my understanding is his usual practice is that he would get a draft from the author. We've not had a situation where we've been, for example, providing advice on that process.
To your knowledge, have any other reports provided to the administrator had substantive elements of them removed?
Yeah. I'm not aware of the process that's been gone through in detail, Senator, so no, to my knowledge, I'm not sure.
To your awareness,
no, but it wouldn't surprise me if there's changes been made to draft reports prior to their finalisation, Senator.
Have you been provided with any information as to whether the Minister or the Minister's office discussed the Watson report with the administrator at any point?
No, Senator.
Minister, are you aware whether the Minister has, or her office has discussed the Watson report with the administrator at any point?
No, I'm not.
Are you able to find that out on notice?
Yep.
Thank you. Was the Minister advised at any point that the report had actually had those elements removed? And do you know if there are any discussions around why they were removed?
I can take that on notice as well.
You can? Thank you very much. Okay. If you could also take on notice in that case, Minister, whether the Minister's office raised any concerns with the administrator in relation to the substance of the report, and whether or not those concerns were before or after the relevant chapters were removed?
I can take that on notice, yeah.
Thank you. If you could also find out on notice for me whether the Minister's office expressed views or perhaps, I won't say directions, I'll leave it as expressed views about whether any of the findings should or should not be publicly released.
Happy to take that on notice.
Thank you. If you could also please then take on notice whether the Minister or the Minister's office endorsed or encouraged the decision to remove sections of the report.
I can take that on notice.
Thank you. Did any advisor in the Minister's office receive a copy of the report before the sections were removed? And then, did any advisor in the Minister's office receive a copy of the report after the sections were removed? And if we could also clarify if there was more than one iteration of what's been termed the draft report. So how many copies, how many iterations of this report there actually are?
I can take that on notice as well.
Thank you. Could you also please take on notice whether any advisor received a briefing or summary of the removed content?
I can take that on notice.
Thank you. If you could also take on notice details of the communications exchanged and the timelines of that communication between the Minister's office and the Administrator about the report's release or content and removal of those chapters.
I can take that on notice.
Could you also please take on notice if there were any communications exchanged between the Minister's office and the department about managing the timing of the report's release and what the details of those communications were?
Yes, I can.
Well, we
Sorry.
don't need to take that on notice. It concerns the department. We've had no communication about the timing of the release of the report.
And
in terms of
Senator, can I just say, I think the Minister's made clear the Administrator is independent. It was his report that was commissioned. We'll take those elements on notice, but I would be surprised that we would have any interaction with the Administrator in the preparation or a release of a report that he commissioned.
Well, we didn't.
Thank you, but if you could confirm that on notice
Yes, we will.
for me, thank you, and thank you for that clarification. If you could also provide on notice, or you can answer now, if there are communications there, to confirm whether those communications will be preserved, including the different iterations of the report, if you are in possession of those different iterations of the report.
So we'll take that on notice, Senator. I think Mr Manning's been clear that that the department received any, previously redacted chapters was late last night.
Okay.
That's right.
Okay. At the time, I'm thinking about the Minister's confidence statements, and I'm wondering whether the Minister had an awareness of the removal of the chapters. And Minister, this is a question for you, and you may have to take it on notice. If the Minister was aware of the removal of the chapters from this report when the comments were made about full confidence?
Well, I will take that on notice, but I, on behalf of the Minister and on behalf of the government, have expressed our confidence in the Administrator today since these reports surfaced. And as I say, I'm not going to question the Administrator's judgment that some of the aspects of Mr Watson's report were not well founded, to use the Administrator's words. And what I will do, again, is point to the excellent work the Administrator and his team have done since being appointed in incredibly trying circumstances, and the success they've had in ensuring that construction workers are well represented on the job, while also having their union restored to a clean form that was not achieved by the former government.
Are you aware whether the Minister has had any meetings this morning with the Administrator, or any briefings with the Administrator this morning in relation to what's been in the media?
I think I answered this earlier. I think you asked whether the Minister had spoken to the Administrator, and the answer was no, and I haven't received any
update,
any alternative. So as far as I know, the answer is still no.
Still no? Thank you. I just wanted to confirm that. Do you know if the Minister was advised that the failure to release the report in full could actually create a perception of political interference?
Do I know whether the Minister was advised that what, sorry?
That the failure to release this report in full could actually create the perception of political interference?
Well, I don't know that, but again, I repeat the point that this is not the Minister's report, it's not the government's report, it's not for us to write the report, it's a report that, it's the Administrator's report.
But surely the Minister has an interest?
I think all of us have got an interest in the excellent work of the Administrator and his team to clean up the union and ensure construction workers are well represented. I think we've all got to just that. As I've said to you before, we've also got an interest in employers in the industry not being corrupt, but I never hear a question from your side of politics about that.
Minister, have you seen the 2 chapters that have been removed? Or the chapters? I actually don't know if it's 2.
No, I haven't.
You haven't?
I haven't seen any part of this report.
Because
Rightly
my
or
next
wrongly,
question was going to
minister.
be, do you have a view as to why they're not well founded? Because I would be curious, and perhaps the department can answer this, were there any substantive reasons provided by the administrator as to why they felt that the information that had been taken out, the chapters that had been taken out, were actually not well founded?
His statement simply said he determined to remove the 2 sections because he's not satisfied they were well founded or properly tested. He didn't go into detail.
But didn't provide reasons?
He didn't go beyond that statement.
Okay. And noting again your time frame of knowledge around this is very small. Obviously you received the report on Monday and you became aware of the 2 sections or chapters last night. Can you confirm for me that at no time, or to your knowledge, did the minister, the minister's office or any Commonwealth official request, suggest or support the removal of those relevant sections?
That's my understanding.
Yeah.
I've
So
no knowledge of that occurring.
No knowledge of that at all.
And I understand from the minister's point of view, the answer is the same.
Thank you. And then just one thing that sort of I'm a bit curious about, and it goes to this, the sections not being well founded, is the department seeking to understand more detail from the administrator as to why he felt they were not well founded, given that information wasn't provided?
I mean, it's certainly something, as I said earlier, I'd expect Mr Watson might be asked about in his evidence, and we'd be interested in that. I think once we have a bit more time, we'll look at the report as a whole, including those chapters, and if we wanted to discuss it further with the administration, then we would. Yeah.
So from a procedural perspective and a best practice perspective, it's the department's view that it would be a good thing to understand how those chapters or sections failed whatever test it was to be included in the report.
I mean, obviously, given the public sort of discussion around it, we have an interest in it. The report goes to historical matters. I mean, we given our role in the framework, we clearly have an interest in making sure that the administration works effectively, that where there is evidence, actionable evidence of wrongdoing, that's shared with regulators, and regulators are able to make decisions to take action. And some of those regulators will be here later on today and you can speak to them. But clearly we have an interest in that framework of the administration working as intended.
Yeah, absolutely.
That's not to say that we'd be second-guessing the administrator's judgment about the content of the
No, not
reports.
at all. I think that's where we are all at. We actually all want to understand that the processes in place are transparent and robust, and they're doing what they need to do. So I'm also curious then whether you've actually sought clarification as to why those sections weren't fit to be included in the report.
No, haven't sought detail around the administrator's statement.
Will you be seeking to understand why? So if it doesn't come out in the Commission of Inquiry today in Queensland, will you be seeking clarification from the administrator on what basis he determined those sections or chapters should not be included?
As I said earlier, I think we'll sit down when we've got a little more time and look at the report in its totality, and it may be then that we do, but I can't say now that we will. They're quite general, so I'm not sure we would. But as I said earlier, we're not in the practice, and nor is it our role to go and second guess the administrator for those reasons that the minister referred to in some of his earlier testimony.
Sure,
Senator,
but like
we are due to rotate so after this
last
question.
one, very quick. Thank you. I mean, thinking out loud, Mr Watson is a senior counsel specialising in anti-corruption and has been the counsel assisting in public inquiries that investigate corruption. I mean, I don't understand why you wouldn't be seeking an explanation as to why the administrator believes sections of his report were not well founded. I don't know him, I have no connection to him. He doesn't sound like a flippant kind of guy. These are serious allegations. Wouldn't you seek clarification for the Minister on this so you can actually brief her and go, hey, we checked this out for you and this is what we found out?
I suppose what I'm saying, Senator, is we might form our own views on that, and if in forming those views we think it's worthwhile chatting to the Administrator about, discussing it with the Administration, then we would.
Are you intending to form your own views on that?
No, we're intending to have a look at the report and the excluded matter in its totality, so that's. I need to be careful here to distinguish between forming views on the veracity of everything that's in it, as compared to what you're asking about whether or not we need to have further discussions with the Administration.
I'm finding it very hard to follow where we're in opinion and I'm not placing that all on you, Senator Kovacic. It's quite difficult to follow, but we are due to rotate.
I just want to make this clarification, Chair, if I can. When I referenced forming views, I was using your words, and I assumed that they were forming views of the department as to advice to the Minister, not your own opinions. Thank you.
Okay, thanks for that clarification.
So if you could provide an answer to that question on notice.
Minister Watt, and then I'll go to Senator.
Sorry, just Senator, thanks, Chair. I understand the Administrator has just released a public statement, which I haven't had a chance to read myself yet, but that may shed some more light.
Okay, thank you for alerting us to that, Minister Watt. Senator Pocock, you have the call. Then I'm going to Senator Sheldon, and then I'll return to Senator Kovacic.
Thank you, Chair. Thank you for your time while we're still morning this morning. And Ms Godden, can I just start by saying congratulations on your Public Service Medal, very well deserved. I have some questions about the SRC Act review, or the Comcare review. It was obviously released publicly on the 12th of December. Could you confirm what date the government received the review from the independent review panel?
September 2025, the final report was delivered to government, Senator.
Thank you. And Minister, this is probably one for you. In releasing the review, Minister Rishworth said, and I'll quote, "The government will carefully consider the review recommendations with a view to progressing necessary reforms." I've had a lot of concern raised to me by people affected by Comcare who are very interested in the government's response to this review, and just wondering whether the government sees that some of the recommendations are necessary and some of them are unnecessary.
Well, look, I haven't been briefed on this myself. Obviously, I think the review started when I was the Minister, but I haven't kept up to date since changing portfolios. I'm not aware that the government has yet tabled a response to that review. Once we table response, that's when we'll be in a position to say which ones we agree with, which ones we don't. But it sounds to me like that thinking is still happening.
And Senator, I'd just point out there were 124 recommendations in that review, so obviously we're just working through them.
Sure. When will the government respond to the review?
I think that's a matter for government, sure. Senator.
Minister.
Yeah, I don't know is the honest answer, but you know we acknowledged in commencing this review that there were things in the Comcare system that needed to be considered, so I'm sure the Minister will progress this as quickly as she can.
Thank you. And maybe to the Department, have you provided a draft response to the Minister's office?
The Department hasn't provided a draft response to the review as per the Minister's media release. It is, and as the Senator Minister just outlined as well, there was 124 recommendations. The recommendations are quite complex, as you can appreciate, Senator. So they do require careful consideration. The Department is still working through the report, and the Minister has also indicated that the government will work with stakeholders to inform the development of any reforms. So we'll be undertaking that work.
Do you have a date you're working towards for the response to government?
In terms of the response, I don't have a date for you in terms of a specific date.
An estimate?
I think the best we can say is it will be linked to budget cycles because, of course, there's a cost in relation to the reform, and in making its report to government, the review panel itself indicated that they hadn't done complete actuarial costing of it, nor had they done a cost-benefit analysis of the overall report. As Ms Anderson said, I mean, we've haven't produced a final response to it. Have clearly briefed the government about it and are looking at working through that, looking forward to, in the pretty near future, hopefully, subject to final decisions of government, going out and doing some consultation amongst stakeholders in relation to that response. And then as part of that, once that forms up, we'll have to do that overall cost-benefit analysis and further actuarial work that the panel itself said needed to be done. And then we'll have to feed into a budget process in relation to any final outcomes.
And so we're probably looking at budget 2027.
Again,
Senator,
that's a decision of government. There's MyEFOs and budgets. So
I don't think we can speculate at this point in time. I think Mr Manning and Ms Anderson have outlined there's a lot of recommendations. They need to be worked through. They need proper kind of expert actuarial advice, and we need to consult with stakeholders.
No, I understand that, but surely it's not a decision of government when you provide a draft to government.
No, but we would hope to provide a comprehensive draft in terms of a response.
Sure, but sorry, I just heard from Mr Manning that would have to tie in with a budget cycle, so I'm assuming this budget is out of question. So, like, could you see yourself completing all that work and acknowledge that there's a lot of recommendations by budget 2027?
Yeah, I mean, I have to go through the motions and sayings for the Treasurer to announce what's in this budget, but you're right, it'll be a lot of work to get it in the next budget. In part, it will depend on some of that consultation we're doing, and including across government and the work. So what we can say, Senator, is we're certainly endeavouring to do it as soon as we're able to. We are subject to those broader government decisions about what gets brought forward in various processes, noting that it would require both funding and legislation.
Sure. Thank you. Could I turn to delegated claims management? The review has found that while it had delivered strong performance outcomes for participating agencies, particularly in terms of reducing premiums, that there were clearly issues of integrity and fairness in delegated claims management. In fact, they said, and I'll quote, financial savings may come at the expense of injured workers' access to statutory entitlements. Workers feel discouraged from making claims, perceive a lack of independent decision-making, and experience a diminished sense of procedural fairness under delegated claims management arrangements. And clearly, we're talking about Services Australia and the ATO, and problems there have been well ventilated publicly. Minister, does the government share the concerns of the reviewers about the delegated claims management arrangements and the serious issues in terms of well-being of public servants?
Well, I think that's sort of going towards what the government thinks of the recommendations, and it's premature for me to say while a response is being prepared. So we will obviously take good account of the recommendations that have been received and the findings, but I really couldn't say at this point in time whether the government shares those opinions. We're working through that now.
Okay.
But we recognise that there are aspects of the Comcare system that need to change, but I'm not in a position today to say what they are.
So, this is sort of outside of the review. This is well known publicly that at Services Australia and the ATO there are serious issues where public servants go through the Comcare process because of the delegated claims management, and the government can't even say that you are concerned about public servants having to go through that.
Well, I'm here representing the Minister. I haven't been briefed on that, so I don't want to comment on something that I haven't been briefed on.
It is one, you may know, Senator, I mean, there was a fairly extensive consultation process done. Well, obviously aware of those concerns, there's recommendations on it, and clearly a focus of any reform will be early support for injured workers, streamlining the claims process, trying to reduce the potential for disputes, etc., and likewise the financial sustainability of the system. So I certainly would expect as we develop it, there'll be views we're getting within government, but we're certainly fully aware of the views that were given to the panel in relation to what those stakeholders saw as the issues with it as well.
Sure, thank you. Yeah. And so, just to come to the sort of financial sustainability that you mentioned, has the department or the government modelled the cost of delivering this recommendation around delegated claims management?
We haven't done separate costing since the report was provided to government. I can't recall off the top of my head if that's one of the areas the panel itself got actuarial costing of. But as I said earlier, we will in developing a suggested reform package, need to get actuarial costing of a number of elements of it, and looking at the cost-benefit analysis overall, which are both factors that the panel itself indicated government would have to do in responding.
Maybe you can take on notice whether an actuarial costing was provided for this recommendation, and sure, if you could provide that costing on notice.
I'll take on notice whether that was one of the elements that they did, because they did get some actuarial work done on a number of elements throughout it. They just never stepped back and looked at overall and didn't do some elements. So we'll confirm that on
thank you. And if that does exist, if you could provide it to the Senate, that would be appreciated. I had one more. How am I going for time, Chair?
You've got 5 minutes.
Okay, thank you. I had one more question about step downs. I fear we're sort of going to get caught in the same situation, but this clearly I think is really urgent and has a massive impact on predominantly the AFP and officers who need to go on leave for long-term injuries or PTSD. And effectively, despite what we know about mental health in 2026, the current system punishes people for having PTSD that comes from their line of work. And there was a very strong recommendation that a worker should never drop below the minimum wage while they're on leave because of a step down. Minister, I assume with the government's support, sort of agenda around industrial relations and a living wage, that the government would support a recommendation that ensures that AFP officers aren't living below a living wage? The minimum wage?
Again, I'm not familiar with the 124 recommendations myself. It sounded like, from what you were saying, that is one of the recommendations. We will obviously consider that, as we will the other 123 recommendations. You know, as a general principle, you know that our government wants to see workers of all kinds, uniformed or non-uniformed, treated fairly in the workplace and around their workplace rights. I have confirmed, with the Minister's office that we certainly acknowledge that the issue of delegated claims is definitely an issue of concern, and we'll consider seriously the recommendations that have been made about that.
And Minister, just finally, in terms of the timing of responding to this review, does the government have a time frame in mind? I'm just conscious we've seen other Senate reports and reviews. It's been years. And there's a lot of people who are very anxious about seeing this.
We don't have a time frame set at the moment, but we do recognise there's a lot of interest in this, and we'll get moving as quickly as we can. 124 recommendations is a lot to work through for any review, so that I don't think we can be expected to be delivering that response overnight, but we understand the seriousness of the issues.
Okay, thank you very much. Thanks, Chair.
Thank you, Senator. I've got Senator Sheldon, and then I'm coming back to Senator Kovacic.
Good, thanks, Chair. I just want to ask some questions regarding the minimum standard orders Fair Work Commission.
Just change it.
That's right. Good, thanks very much. I refer to the minimum standard orders application made by the Fair Work Commission for the Transport Workers Union on the 17th of December 2025, covering employee-like workers who perform passenger transportation work. The department just give me an outline of how the Albanese Labor government, this world-leading closing loopholes legislation regards to gig workers, how the new rights apply and the minimum standards across the gig economy?
Senator. Henry Jones, Assistant Secretary of the Strategy and Protections Branch. So the Closing Loopholes Reforms establishes a framework with a couple of elements in relation to regulated workers, as they're called. The first one of those is the ability to set minimum standards, both for regulated road transport workers, but also for employee-like workers. So those are what we might call gig workers, they're digital platform workers who satisfy certain employee-like characteristics. So that's low remuneration, low bargaining power, low control over their work. So the Fair Work Commission has an application process where it can set those rates subject to certain guardrails and guiding objectives. In addition to that, there's also unfair deactivation protections. There's a bargaining framework, and supporting those, there's a new interpretive principle for employment and an unfair contracts jurisdiction, all of which seek to kind of deal with this situation where contractors don't have, I suppose, the protections that employees do under the Fair Work Act. I can talk to the rideshare one in particular.
If you could, that'd be helpful.
Yeah, sure. So the rideshare application is still very much in its early days. Was made last year, in the sort of end of last year. I understand there has been a directions conference listed at the Fair Work Commission for later in February. I think the 17th of February it's listed before the Commission.
We've got, just want to set the scene. We've got a high pressure industry, below minimum award wages. Of course, these are employee-like workers we're talking about. Where people are getting paid, you know, some reports and studies were saying as little as $6.20 on average an hour. No workers' compensation, no sick leave, no right of reinstatement, being terminated by algorithms, no right of repeal except through to the algorithm. And these laws came into place, and part of the horror story of people trying to earn enough money, you know, driving around our dangerous streets, can be very dangerous streets. The 23 gig workers have been killed on our roads since 2017. That's recently the Transport Workers Union, regarding a September 25, talked about a motorbike crash where a worker's only living relative was not informed of his death until 6 weeks later. Before the laws the Labor government passed, delivery riders didn't have access to, say, to minimum fair wages, sick leave, protection against unfair contract terminations, and workers' compensation. Now, they're literally thrown to the wolves under the previous system. So my question is this: can you just confirm, if approved by the Fair Work Commission, that this proposal that was launched, that was submitted, the application submitted on the 17th of December 2025, would rideshare drivers finally have access to world-leading minimum standards as a result of these law changes?
Yes, they would be quite unique, I suppose, on the global stage, in that we have our industrial tribunal setting them, and I think Australia's been quite forward-leaning in terms of setting that framework in place. In terms of the order that is sought, it would include minimum rates for the first time for those drivers, and it would include a mixture of rates depending on which vehicle they're driving, a mechanism to adjust rates in accordance with significant fluctuations in costs, and a minimum rate of engagement regardless of distance travelled, and particular allowances for trips over 50 kilometres. The draft standard also has 4 weeks of unpaid annual leave and 10 days unpaid personal leave for workers who work on a regular basis over 12 months. Things like fatigue, breaks, personal injury insurance, potential for safety training, and certain requirements around information to be provided when gig workers are using the app about what the journey might be. So to the extent it goes through the process now before the Commission, it's got to go through a significant process of consultation, of working through with the other parties. It may include consideration by the Road Transport Advisory Group, for example, to try and narrow those, and we've seen that process already with some of the other applications before the Commission. That may change what the final form of it looks like, but if it does make it to that final stage and is made by the Commission, it would be minimum standards, including rates of pay potentially for the first time for gig workers.
Thanks. I just want a question to the Minister in light of that answer. Just, these reforms do have challenges, and one of the challenges is that Angus Taylor, currently the Shadow Treasurer, we'll see how the next 2 days rolls out, said in September 2023 that Labor laws to give gig workers the ability to apply for minimum standards would, and I quote, just raise more barriers to getting people into jobs. Big employers are saying this, small business is saying this, and gig economy workers are saying it. Well, the 23 gig economy workers who have been slaughtered on our roads aren't saying that. The devastated families certainly aren't saying that. They're saying that fair minimum standards would make a difference for safety, wages and cost of living. Minister, what are the Liberals and Nationals and One Nation's approach to these important decisions and these important protections?
Thanks, Senator. Well, again, similar to the discussion we were having earlier about same job, same pay, these changes to support gig workers are another important component of the government's agenda to get wages moving again. You know much better than me the kind of pay and conditions that were faced by many workers in this sector over your career. And it's really heartening to hear that these changes are starting to make a difference to workers in this sector. Again, this is another example of where we've seen the Liberal, National and Pauline Hanson's One Nation Party vote together, as they almost always do, to try to block these changes to the law, which have delivered higher wages and conditions to workers who don't earn a lot in the first place and have quite insecure work and quite unsafe working conditions. So that's what we know we get from that coalition of One Nation, the Liberals and the Nationals, and God forbid that coalition were ever to reach government, we know that these sorts of rights would be on the chopping block. I wasn't aware of those comments from Mr Taylor when these laws were passed, but I guess what we now know is that whoever ends up as the leader of the Liberal Party by the end of the week, Susan Lee or Angus Taylor, they're both opposed to these kind of laws. I was mentioning what Susan Lee has said before about wanting a battle on industrial relations to take away these sorts of rights. Mr Taylor has indicated he doesn't support these rights either. So whoever we end up with as the leader of the Liberal Party is going to be taking away these rights and cutting people's pay. Supported by One Nation.
Minister, I've met with large numbers of gig workers, and I've had the honour of meeting those wonderful family members of a number of gig workers, 6 different gig workers that had lost their lives. One gig worker was under the front tyre of a wheel, still receiving directions on work, but not receiving pay, no workers' compensation, and getting paid below the minimum wage, just to add horror to the story of injustice. I mean, to see those laws taken away from hard-working people in the Australian community would be devastating, and it's no sense of sense of callousness to actually do that. What's significant about those changes is that those laws giving people minimum standards means that they're less likely to be economically forced to run lights, economically forced to work extraordinary hours. And also those gig companies, those big tech companies that are impacting our lives in so many ways, being held to account by saying a simple algorithm could terminate anybody on the basis of a heartless decision.
Yeah, I couldn't agree more, and I'm really proud, and I know you and the rest of our Labor team are really proud that these are world-leading laws that our government has put in place, and I'd like to think that they won't only provide a safer, better, more well-paid environment for Australian gig workers, but that will benefit workers in other parts of the world as well.
And most certainly those people driving on our roads will have a safer, and on our pathways will have a safer environment as well. Thank you, Minister.
For sure.
Thank you, Senator Sheldon. Senator Kovacic, you have the call again.
Thank you. Minister Watt, I just referenced the statement you said the administrator made just before the last rotation, Could you table that? I haven't been able to find that
I can
anywhere.
get a copy of that table for
Thank you. I really appreciate that. In addition to that, before I sort of go to another section, and this is for the department, Mr Watson has told the Queensland Inquiry that his role has ceased with the CFMEU. Was the department aware of that?
No, I was not aware of that before today's hearing, Senator.
Okay, thank you.
I was not aware of that either. Again, happy to be corrected on this. My understanding is that Mr Watson was never hired as a sort of a permanent employee of the union. My understanding is that he was engaged to deliver reports and conduct certain investigations, which he's now done. So I wouldn't read anything into that.
Okay. Do you know how many reports and investigations he has conducted?
He certainly did one into the Queensland branch.
Senator Sarah Godden, First Assistant Secretary, Workplace Relations, Legal Division. We're aware of a number of reports that Mr Watson has done, as Minister Watt has indicated, certainly into the Queensland branch, into the Greenfields, payments in New South Wales. I would have to check my recollection on this on notice. I do apologise, Senator, but okay. I believe also potentially into South Australia. In relation to some activities of a Mr Pare. I believe that was Mr Watson, but I would just appreciate the opportunity to check my recollection on notice.
Of course, on notice is fine.
And as well as Victoria, obviously, which we've been discussing.
Thank you. I'm going to ask some other questions in relation to Zack Smith. On what date did the CFMEU advise the government or any Commonwealth agency of Mr Smith's resignation?
I think Mr Smith released information about it publicly, my notes say on 21 January of this year.
And so is that the date that the department became aware?
Yes.
Okay. Minister, are you able to provide, if not now, on notice when the government became aware?
Why don't I, if it's anything different to what you've just heard from the department, I'll advise on notice. But if it's simply confirming that,
of course,
yep.
Yeah, I think that's very reasonable.
You should assume that it was the same date,
unless you tell me
otherwise. I'll come back to you on notice if it's different. Yep.
Thank you. This may be connected, but it's a slightly different question. If I could have on notice when the minister first became aware that Mr Smith had resigned from his position, unless someone does hold that information now.
No, my understanding is it only became general knowledge on 21 January 2026. I'm not aware of anyone having any knowledge before
What
that.
I'm trying to understand is if Mr Smith had advised the minister or others prior to his making the resigning.
Not that I'm aware of, Senator.
Thank you. Do you have any awareness whether the resignation was voluntary or if it followed any internal investigation, any disciplinary process, or as a result of external scrutiny?
The only knowledge we have is the reasons put forward in his statement, that he was resigning for personal and health reasons. I'm not aware of any other background or context.
Okay. Minister, do you know if the minister is aware of any other reasons?
No, again...
if different, could you provide on notice?
I'll advise if it's different, but my understanding is that all the minister knows is what Mr Smith has said, which is that he resigned for personal or family reasons.
Does the department or the minister have any awareness of any Commonwealth agency raising concerns about Mr Smith's conduct or his fitness to hold office within the CFMEU before his resignation?
No, Senator, the department doesn't.
But I'm confused. Wasn't the administrator reviewing Mr Smith's conduct?
I think we covered this a little at last estimates, where the administrator had...
he hadn't resigned yet, so now he's resigned.
No, but the administrator had provided a letter to the General Manager of the Fair Work Commission just before the last estimates, expressing his confidence in Mr Smith's undertaking the role, and then Mr Smith has resigned subsequently for the, as I understand it, for the reasons he put forward in his statement.
Has the department assessed whether Commonwealth funding, procurement or projects were affected by decisions taken while Mr Smith held office?
That would be a question that you'd potentially have to ask of the Department of Transport and Infrastructure.
Okay. Were any briefings, risk assessments or any other advice prepared for the Minister or Cabinet in relation to Mr Smith before or after his resignation?
In relation to Mr Smith's resignation?
No, in relation to Mr Smith, either before or after his resignation.
No, Senator. I mean, obviously, Senator, I feel compelled to say that we're unable to talk about what's been considered by Cabinet, but I wouldn't read too much into that other than to say, as we said, saying no.
Yeah, no. Okay. Well, there was reference to the Minister as well. Yeah. Has the government referred any matters connected to Mr Smith's tenure to law enforcement, regulators or integrity bodies?
The department hasn't, Senator, and I'm not aware of it occurring otherwise.
Do you think it's strange that in the background you have this report and Mr Smith resigns on the 21st of January, and noting the report was meant to be released in the first week of December? So Mr Smith resigns on the 21st of January, then the report has sections removed from it, 2 sections, because, you know, they weren't good enough, according to the administrator. And then the report is published on the 27th of January. And now on the morning of the of estimates, and we have the Commission of Inquiry in Queensland, we find out that there are 2 chapters that have been removed. Do you consider that to be a concern or unusual, or something that the department should be looking into?
I'm not aware of any linkages between those. I would just make the point, as I said earlier, that the latest Watson report that we've been discussing today goes to historical matters in Victoria. Mr Smith wasn't in Victoria historically. Mr Smith was in the ACT, as I understand it. So I'm not aware of any linkages at all between the two, and you putting it to me now is the first I've heard of that.
Okay, yeah. But Mr Smith was the head of the VicTaz CFMEU, correct?
Beg pardon?
He was in charge of the VicTaz CFMEU.
Pardon, so under the administration?
Yes.
Yeah, it's under the administration he was, yeah.
Yes.
But not historically in relation to the... Because the report looks at when Mr Setka was running the Victorian branch prior to the administration.
Yeah. Did the resignation trigger any review of governance, compliance or oversight arrangements relating to the CFMEU?
Not from the department's perspective. I can't speak for the administrator, but not that I'm aware of. So.
Certainly, Senator, the administrator has an ongoing program of work relating to the governance of the union. We understand that they are developing certain policies. I believe the industrial mediators policy has been released, at least in draft form. We understand they are formulating other governance policies that are under development. So, in a sense, that work is ongoing.
Okay. And this is probably connected to that. Are there any steps in place now by the department, or has the Minister requested any steps, or perhaps even the administrator to that end, to ensure that we similar issues recurring in relation to unions involved in federally funded work meeting appropriate governance and integrity standards? Is that kind of work in play?
Yeah, I mean, we discussed at previous estimates the work of the National Construction Industry Forum, which is really a recognition across government and all aspects of the industry about the need to improve the culture of the industry, and looking at that from a number of perspectives. So certainly there's quite a bit of work being undertaken in that forum that will be relevant to how industry participants relate to each other and run their affairs and engage, resolve disputes, etc.
Yeah, okay.
Oh, sure.
Sorry, just to add to that too, I think we traversed this at the last estimates as well, but in terms of government-funded projects as well, Minister King has previously written to all her counterparts about the expectations of behaviour on federally funded agreement projects. And Minister King has also written to government business enterprises involved in the delivery of Commonwealth-led infrastructure projects as well, again outlining expectations on those projects.
Okay, thank you. Chair, I'm happy to rotate the call. I've got a different block.
Sure.
First this one.
Mulholland.
Thank you, Chair. We've been talking a little bit this morning about wages, so I just want to come back to a couple of questions about the latest wage trends. And particularly,
we'll just rotate.
Yeah, sure, no worries. No worries. Thank you. Okay, so just to recap, just going to some questions about the latest wage growth trend, in particular the latest ABS data. Can the department confirm that the latest ABS data, what it tells us about the latest real wage growth in this country?
Thank you very much, Senator. I'm Matt Cowgill, Chief Economist. The latest ABS wage price index data is for the September quarter. That shows that wages increased overall by 3.4% over the year to September quarter 2025. That is greater than inflation over the same period. So real wages over that 12-month period rose by 0.2%. And that marked the 8th consecutive quarter in which annual real wages growth had been positive.
Thank you. So you said 8 consecutive quarters, so that's about roughly about 2 years. Is that a relatively long period of growth, I suppose, looking back and historically speaking? Is that a fairly large period of time to have growth over?
The real wages growth tends to fluctuate, Senator. I'm afraid I don't have to hand information about previous consecutive periods of real wages growth in those terms. It's certainly the case that
I actually had seen previously that it was one of the longest periods of consecutive annual growth in the last sort of decade or so, but that's, that was just in a report recently.
Certainly would have been if you're looking at it over that period. I think Mr. Cowgill was taking it in terms of
year on year,
historically, but yes, certainly that 8 consecutive growth follows a period where there hadn't been the same number of consecutive quarters of growth.
That's correct. Mr. Manning's correct, Senator. So prior to those 8 quarters, we did have a period from around mid-2021 in which inflation was elevated and real wages fell as a result.
Sure, thank you. And I just want to also talk about how do the economy-wide wage increases compare to wage growth for workers covered by enterprise bargaining?
Thank you very much, Senator. So we are seeing wages growth in enterprise agreements outpace overall wages growth. So for agreements approved in the September, these are federal enterprise agreements approved in the September quarter of last year, the average annualised wage increase in those agreements was 3.8% compared to the wage price index over the prior year of 3.4%. So we are seeing slightly faster wages growth in enterprise agreements.
Okay, thank you. My last question, I might come to the Minister if I can. We know that there's been a lot of focus in this building on jobs, people, who's got what job, lots of focus on job, who's in what office, who's getting the big offices, who's getting the small offices, all that going on here at the moment.
That's the focus of some parts of the building.
Some parts of this building, sure. And obviously there's a couple of big decisions coming up at the end of the week for the other side around who leads their party, but what really is at risk for workers when it comes to wage growth in this country? It doesn't matter who ends up with the job down the other end of the corridor at the end of this week. What's at risk for workers?
Well, yeah, I mean, there's a very clear difference between the Labor government's agenda around workplace laws and the pay and conditions that those laws support, and what we're seeing from the ragtag coalition of the Liberal National, Pauline Hanson's One Nation Party. There's obviously been a number of statements referred to already today from, the alternative two leaders of the Liberal Party. We know that One Nation has always voted with the Liberal Party on these issues, and what that means in practical terms is that if they had their way, working people would be paid less, and then we'd really see people struggling even more with cost of living pressures. So these are really important issues. I forgot to mention, when Senator Sheldon was asking me before about the comments of Mr Taylor about the gig worker laws, I mean, there are some on the Liberal Party has consistently argued, and it sounds like Mr Taylor was as well, that for workers to have a pay rise, that has to come at the cost of jobs. But one of the things we've been able to demonstrate is that since we've been in power, we have lifted wages above inflation while at the same time holding unemployment at historically low levels and creating record numbers of jobs. There's never a good time for a pay rise from the Liberal Party or the National Party or Pauline Hanson's
Depends
party.
on the person is.
For the average worker, that is. But Labor's very proud of the fact that our laws have turned that around, and long may it continue.
Thank you, Minister. Thank you, Chair.
Thank you. Senator Kavasic. Thank you. Mr Watson has given evidence in Queensland relating to some of the reductions that he was directed to make by the administrator. Mr Watson said, and I quote, people were coming straight out of jail. A man who had killed somebody and participated in a beat where a dead man's body was dumped was released from jail and almost immediately appointed a health and safety officer. I'm trying to understand why an administrator that has the full confidence of the government would want this removed, and if that is in fact something that Mr Watson came to learn, why the administrator wanted that removed.
Well, I haven't seen the bits that the administrator decided to remove. I'd want to see that and see what else is in that section as well. I don't know whether it was that particular statement that you've read out or some other part of that section that prompted its removal.
Okay.
Senator, I was going to say it's not clear to me either. I mean, I understand, I've been told while we've been appearing that the Victorian report has been published by the Queensland Inquiry. Yeah. So you're able to see that the report contains...
I've been here, so I haven't seen it.
Oh, right,
so,
no, but sorry, I mean, people can all see now that the report contains quite a few assertions about improper behaviour in terms of appointing people to represent the union, etc., in different roles. So it's not clear to me that was removed, but you're saying that's part of the removed
I am told
content.
That Mr Watson gave evidence.
I need to confirm that because, as I said, the two sections the administrator spoke about went to that estimation of cost and knowledge. There is a lot in the final report provided to the Queensland Inquiry, which everyone can now see, that looks at the appropriateness of people fulfilling various roles on work sites.
Correct, and this is what that reference.
So that's why
right?
I'd be surprised if that was part of the information that was removed.
So, assuming that information is correct, would the government consider it's appropriate that an administrator would direct the removal of that kind of material and of that serious nature from an independent report commissioned to examine union governance and the appropriateness of individuals holding positions in the union?
As I said, I don't feel that I can answer questions based on what's happening in another forum as we go. I'm aware that the final report contains quite a bit of information about inappropriate people fulfilling certain roles, including health and safety reps, which would be appointed under state legislation. So I can't really answer that question. I think we need to look at it. It seems surprising to me that that's in the information that the administrator determined to remove, but I can't comment on it.
Senator, I think it's a little unfair to ask us to comment on a hearing that's underway as we sit here in front of the Estimates Committee and be able to compare documents that we received last night. I think it's fair to say that...
I'm not asking you to compare the documents. Yeah.
So, like I say, I'm not sure that we can comment on evidence that's being given in another inquiry at this time.
Yeah. My question related to the appropriateness of actually removing that type of information and made the assumption that, if that was accurate, and I'm not seeking a statement of accuracy as to whether it was removed. Yeah. Whether it's appropriate for that type of content to be removed.
So I think we'd need to have a look at the whole report, but ultimately it's a matter for the administrator. As the Minister has said, the administrator's been clear about the reasons he had for asking for that redaction. At this point in time, I don't think we can comment on that without seeing the totality or context of the whole report and elements that may or may not have been removed.
Okay. Minister, Mr Watson makes 8 points about factors that wrecked the CFMEU. He talked about the rapid increase in money which became available through the big build, the CFMEU taking over civil sites and workers ordinarily covered by the AWU, a growing fear amongst contractors that the CFMEU would use its power to damage them, the influence of each Mick Gatto, John Setka and Joe Miles. But the final point they said was the government inaction on the CFMEU. Do you know, or does the department know if this is one of the sections that Mr Irving had a problem with?
I don't know that because, again, I haven't seen the sections that have been removed. Happy for the officials to answer. Can I just say one or a couple of quick things? As I've mentioned already, Mr Watson has delivered a number of reports to the administrator about different state branches, and that has led to a lot of the action the administrator has taken to remove particular individuals or take other steps to clean up the union. So the point being, we shouldn't assume that the administrator doesn't take Mr Watson's advice seriously. Obviously, the administrator had concerns about some aspects of this particular report, but he has acted on many other recommendations that Mr Watson has made across a number of reports. The second thing I just want to remind you of, if you're not aware, is that our government, well before this report, has taken action to assure ourselves around the project delivery and value for money of infrastructure projects that we are funding. Now, the infrastructure estimates would be the appropriate place to explore that in detail, but just to give you a quick flavour, Minister King, Catherine King that is, has written to her state and territory counterparts on multiple occasions, reinforcing their obligations under the Federation Funding Agreement schedule on land transport infrastructure projects. That FFA requires compliance with Commonwealth and state legislation and mandates reporting allegations or instances of criminal behaviour and corruption to the appropriate regulator. Minister King has also reinforced to state and territory counterparts, again, the need to report instances of suspected criminal behaviour or corruption to the relevant regulator. She's also written to government business enterprises involved in the delivery of Commonwealth-led infrastructure projects, outlining expectations that all instances of suspected criminal behaviour are reported to the relevant regulator. And she's also sought assurances that procurement and contracting practices are achieving value for money of public funds and that delivery partners are implementing ethical employment practices. So, well before this report was provided, regardless of what it did or did not contain, Minister King in particular has taken numerous steps to ensure that practices in state and territory run infrastructure programs that we help fund are up to scratch.
Thank you. Do we know if this is the only report that the administrator has provided, that Mr Watson has provided, that the administrator has asked him to remove sections from?
No, Senator, I think I said earlier, I'm not aware of the details of the process they go through in producing the reports.
But have you come to know whether any of the other reports have had sections removed?
No, I think I said earlier, I don't know.
So, to your knowledge, this is the first time that sections of a report have been removed by Mr Watson at the administrator's request.
That wasn't my evidence, Senator. My evidence was I don't know if it's happened previously, and the details of the process they go through in finalising the report is something I don't have knowledge of. That's different from putting it in the context you just did.
Okay, so you have no awareness?
I'm not aware of what's happened in the finalisation and drafting of earlier reports, whether there's been changes like it. I am aware that the administrator, in his statement, says he determined to remove 2 sections, that he directed it. Whether or not that's occurred before, I don't know.
Will you seek confirmation on notice from the administrator whether any of the other reports have had sections removed at his request?
You're asking me to take that on notice?
Yeah.
I can take that on notice.
Thank you, and noting it's a very short window, has the department, or does the department plan to ask the administrator why he directed wholesale removal of these sections as opposed to the specific claims or points that he felt were not well-founded being removed? Because I'm just trying to work out if there are a few things in there that are well-founded, well then just take those bits out rather than the entire sections.
We covered that earlier, I think, Senator, but as to why he determined the 2 sections to be removed, he said they weren't well-founded or properly tested.
No, my question is...
I wasn't proposing to go and seek an examination of all of the individual assertions in the 2 chapters, Senator.
Okay, well, I'm just trying to understand whether you're seeking an understanding of why the bulk of the information had to be removed as opposed to the elements that didn't meet a particular test of being well-founded.
I don't really have much to add to what I said before, that we'll have a look at it when we've got time and have a look at its totality. If we've got any queries on, I'm sure we'll raise them, but I don't feel that I can commit here to a particular course of action.
I'm just trying to understand. Okay. I'm just trying to understand. As you can imagine, it's quite concerning if one of the key elements that we need to deal with here relates to transparency, and we've got 2 big sections of a report, an independent report being removed, but I'll have a think to some further questions on that. Talking about the federally funded infrastructure projects again, Senator Watt, if the government has taken steps to assure itself that there is value for money across all federally funded infrastructure projects, are you suggesting that the Watson report's findings that up to $15 billion flowed through the CFMEU linked arrangements on Victorian construction sites involving criminal elements is wrong?
Well, I should just say, Senator, I think you're referring to the sections of the report that the administrator determined to be removed because he was satisfied they weren't well-founded or properly tested. I'll just make that point before the Minister.
Yeah, actually that's what I was going to say as well, that the administrator has made a judgment that those sections were not well-founded. I've got no reason to doubt his judgment about that.
Okay.
I mean, you'll see in the newspaper reports about this today, Mr Watson acknowledges that, how did you describe it, a rough estimate, or I think even he wasn't, a very rough estimate is what he said. So I'm not sure that even he is saying this is absolutely right. I mean, I'm just going off what was in there.
Yeah. And noting if that is accurate, then that even challenges it even more. If he's saying it's a very rough estimate, why would it need to be removed?
Well, as I say, I don't know exactly which statements in the sections that have been removed were the ones that the administrator believed were not well-founded.
Which highlights the mess that this has created in terms of that public scrutiny and public trust in removing sections of an independent report that relate to the public cost of perhaps inappropriate or criminal conduct, and now we have a grey area as to why they were removed, and and ultimately we only found out that they were removed last night. Even the department didn't know until last night.
Again, I mean, my understanding is that this report has become public because it was provided by the administrator to the Queensland Commission of Inquiry at that inquiry's request. The administrator, to my knowledge, outside of that, is not under any obligation to make any of these reports public because they are reports that he has requested as the independent administrator. They're not. I sometimes feel that opposition senators think that there's a greater level of government control over this administration than there is. Our role has been to enable an independent administrator to be appointed. He effectively is the union. He is running the union. He's not sort of just a corruption buster, which I think a lot of people think he is. He is actually running the union to ensure those workers are well represented in their workplaces. And he is also doing a power of work to clean up the union at the same time.
Yeah, well, my concern relates to the fact that the person who is running the union has actually asked the person who's written the report about how the union is going to remove sections that suggest that the taxpayer is copying $15 billion worth of impact through those infrastructure projects. So I think that that's a valid concern.
Well,
so you say he is running the union. So
well,
he's running it.
I think that any fair observer of the administrator's work to date shows that he is fearless and he is not here to do anyone any favours. He is focused on the interests of the members of that union. So, you know, the things that he has done already are things that no one was prepared to do before. So, you know, I don't think it's fair to assume that he's got some ulterior motives.
I'm not suggesting an ulterior motive.
That's the entire line of questioning.
No, I'm trying to get an understanding of why the transparency wasn't there. Why not leave the information in there? You said yourself, I haven't seen it, you read from it, that Mr Watson said that it was a very rough number. What is the harm in leaving something like that in the report?
Well, because the administrator commissioned the report. Yeah. It is effectively his report.
I get it.
And he has a responsibility, if he's putting those documents into the public domain, to feel confident that they are accurate. He has obviously decided that in some parts he didn't think that the report was well-founded, and I can only assume that he believed that he wouldn't be fulfilling his responsibility if he allowed a report to become public that he believed was not well-founded. I mean, if any of us were preparing if any of us commissioned a report and then released it, you'd want to feel confident about what it said. And he obviously had a view that there were some parts that he wasn't confident about.
The only thing I'd add to the evidence that the Minister, Senator, is that, as the Minister said, the administrator determines what reports to get and what to do with them. He then brings that together and provides 6 monthly reports to Parliament, which are tabled. His next report is due, I think it's the 24th of this month, and so he'd be preparing that now, but it is the normal course of events that he undertakes a whole range of action according to his judgment and then reports to, in a way that is tabled in Parliament on the outcomes of that action.
Yeah, that's his reporting. That's the administrator's obligation when it comes to publicly reporting on what he's been doing and what he's achieved. That was inbuilt in the legislation.
I just find it very difficult to believe that you know, material that's been put together by Mr Watson, who's done many, many reports for the administrator. We've not heard of any of those reports having massive sections removed or large sections removed en masse rather than massive sections. And now all of a sudden we have this because the administrator deemed them not to be, you know, good enough to be included.
Well,
to be well founded.
The administrator must not have had those concerns about the other reports that have been received.
And now all of a sudden, Mr Watson is no longer, you know, performing work for the administrator.
Well, I've already explained that. You shouldn't try to distort what's
I'm not
happened
distorting.
there.
I'm stating a fact.
Well, it's not all of a sudden he's no longer working for the union.
Well, we've only come to know of it now.
He was only engaged for particular projects, and those projects have come to a time. It's not as if he's been sacked or wound up, and that's the implication of what you're saying.
So you're saying there were no further projects in the pipeline for him to work on?
I'm not aware of any.
This was the final project?
I'm not aware of any.
Well, then we can't make that statement either. Well, we can't. It's a fact.
Anyway.
I think we're
Thank you.
diverging from the kind of question and answer part of this session. So if we could resume with that, Senator Kovacic.
Thank you, I shall. I might go to a different block of questions in relation to TWU agreements.
Maybe before you do, Senator, I've got a couple of updates on some of the questions you asked earlier.
Sure.
So what I'm advised is that Minister Rishworth's office was notified verbally by the administrator's team of the imminent release of Mr Watson's report by the Queensland Commission of Inquiry, and that verbal notification occurred on the 6th of February, which I think is last Friday, towards the end of last week. A copy of the Watson report was provided to the Minister's office by the department on the 9th of February, so Monday. A copy of the elements of the report that were removed were provided to the Minister's office by the department today. Neither the Minister's office nor the Minister raised any concerns with the administrator about any part of the final Watson report or the removed parts of the report, and nor did they endorse, encourage or request the removal of any part of the Watson report at any time.
Thank you, Minister. That's great. I have one additional question to that then. The Minister found out, or her office, on Friday verbally and received a copy of the report from the department on the 9th. Could I just confirm that the administrator also did not send a copy of the report at any point in time to the Minister and or her office?
I'll take that on notice.
Thank you. Okay. Is the department or Minister aware the TWU has coordinated a mass expiration of 200 enterprise agreements for the 30th of June on 2026, or 30th of June this year?
Senator, we are aware of media reporting around that.
When did you become aware? Just in the media, or?
Yes, Senator, from media reporting.
Okay. So the department wasn't alerted through any routine monitoring, external advice or direct communication from the TWU?
Senator, the department does have a role monitoring enterprise agreements and negotiations, and are broadly aware of, when agreements may expire at similar times. So we're broadly aware of when there's particularly a sort of a cluster of agreements that may be expiring in certain industries. That would be general knowledge that the department has.
Thank you. So which part of the department has lead responsibility for monitoring this?
Senator, I have people in my branch that speak to stakeholders in relation to bargaining and bargaining disputes, including unions and employers. Our Office of the Chief Economist also monitors the making of agreements, or the content of agreements, I should say, and develops statistics and data on agreement expiry and other issues relating to agreements.
Okay, thank you. Has the department produced any internal briefing notes, risk assessments or scenario planning documents related to what very much appears to be a coordinated expiry?
Not to my knowledge, Senator.
Okay. So why would, just so I have an understanding, why wouldn't that team have an awareness that this was going to occur? Because it's quite a lot of agreements. It's 200 major enterprise agreements.
Senator, it might be helpful though for Mr Keynes just to take you through the process of remaking an enterprise agreement. I suppose what we're talking here to is the indication that a number of agreements will expire at a certain point. There are steps and processes that parties to agreements need to follow to replace any of those agreements as well. So I just give that context to that there, while there's indications that agreements may expire, there's still procedures and processes that parties have to go through.
I understand. I understand how an agreement is made. What I'm trying to understand is if at any point there has been an awareness or a red flag raised or something that we're going to have 200 enterprise agreements all due on the 30th of June 2026.
Senator, and the other point I would make as well, just going to the point around as a process, there's also processes attached to protecting industrial action related to any expired agreement as well. So I just make that point that the pure fact that they expire at a certain point will have different consequences depending on the workplace and what that workplace and the workers decide to take in respect to pursuing a replacement agreement.
So they won't all have the same process in renewing them effectively. Is that what you're saying?
Yes, sorry, Senator.
There won't be the same process for each of those agreements.
That's correct. They may agree to negotiate a replacement earlier than others, or vice versa, and so it would be on potentially a case-by-case basis in terms of what that workplace decides to, how they decide to pursue a replacement agreement.
Have you considered the impact of the government's IR changes and how they will impact those negotiations?
I think that wouldn't be something that we could do. It's really up to then the parties. The system's designed for the parties to negotiate.
I understand. Like TWU representatives have already foreshadowed industrial action, and we have 200 agreements expiring on that same day. I'm trying to understand whether there were any alarm bells, concerns in the department, or any additional actions that the department decided to take to ensure that we don't have unnecessary disruptions and that the agreements are progressed in a timely manner to ensure that there isn't any public impact.
I would just again point to the processes that are in place at the moment around the fact that there are steps required of parties. They simply can't take industrial action from the date of the expiry of the agreement. There's requirements around genuine agreement and genuine bargaining processes as well. So I would suggest that it would be a hypothetical, I guess, at this point in time to suggest that something might happen that that is being reported at this stage, but we would just point to that there's processes in place, there's long-standing processes in the Fair Work Act for the parties to work through.
Okay. So has the department produced any internal briefing notes or risk assessments or scenario planning documents in relation to this large group of expiries on the same date?
Senator, just to go to Ms Anderson's point as well, that there's also provisions in the Fair Work Act around suspension and termination of industrial action in certain circumstances. Just in terms of anticipating these agreements, I might need to, back to your original question, my team does do some analysis at the start of each year to try and anticipate what may occur during bargaining across that year. So I'm not sure whether they've picked up on this and where we're up to with that analysis, but I'll need to take that on notice.
If you could provide that on notice, that would be great. Because what I'm trying to understand is whether the department has any concerns or any processes in place, if it does have concerns, about the combined impact of the expiry of all of those 200 agreements on the 30th of June this year.
I think, Senator, there's about just under 12,000 agreements been made in the last few years. So it's I just put that in the context of it. The other sort of contextual comment I would make is it's perhaps not unusual in upcoming negotiations that people make claims about what they would like to see in those negotiations, and that's quite different from what actually occurs in those negotiations. So I just think we need to acknowledge that could be occurring as well in terms of public statements made about it.
Of course, yeah, of course.
Senator, we're due to go to the lunch break at this point, but do you require these officials to return after the break?
Thank you.
All right. We will now be suspending for 1 hour, resuming at 1:45. We will require outcome 3 to remain with us after the break. Thank you. All right, the committee will now resume. We're returning to outcome 3, workplace relations, and Senator Kovacic has the call.
Thank you. Is the department aware, or can the minister confirm, that the CFMEU administrator has appointed 3 long-standing members of the Labor Party to his staff, with the total cost of administration, I think now sits more than $2.5 million per year from union members?
I am not aware of that.
Not aware of that? Yeah. Would you be able to take that on notice and find out for me?
I mean, I would say that it's not unusual for people who work for unions to be members of the Labor Party in the same way that many employer groups employ people who are members of the Liberal Party.
Yeah, it's one of those things.
And I think the end of your question was about pay.
Well, yeah, we're talking about the high cost already that union members are facing as a result of the administration.
Yeah, I was going to...
And just noting that, we've got these additional people working there now, and whether there is an awareness of that. Yeah. Yeah,
the reason I picked up on that point, I wasn't sure whether you were suggesting that public funds were being used to pay those people, but they're obviously union funds.
Union funds,
and again, without confirming that, because I don't know, if there are people employed in those roles, in some ways that's analogous to other employees of a union. These are people who are running a union, in addition to all of the work that gets discussed here.
Gotcha.
But happy to take that on notice.
Also, is the minister aware that former Labor pre-selection candidate Clancy Dobbin, he was a fellow that was sacked by the CFMEU, has now once again been employed by the union, and if so, what the terms of that re-employment are?
I'm certainly aware that, when I was the minister, I was aware that Mr Dobbin had been engaged or employed by the administrator. My recollection was that he was in a communications role. You would be aware there's a lot of media interest in what's going on there, and someone's got to handle those media inquiries. I'm not aware of whether Mr Dobbin has been previously sacked by the CFMEU. Are you saying
yes, that he was
by
sacked
the administrator
previously,
or by the former regime?
I actually can't answer that question, which is a good thing that I'm on this side of the table. But I just do know that he was sacked by the CFMEU, whether it was previous to the administration or during, but he's now employed again by the union. I would suggest that it would have been beforehand, otherwise the administrator wouldn't have re-employed someone that he had sacked. Yeah, that would be my view. We'll get that for
you on notice. I have a feeling that if he was ever sacked, it was by those who are no longer running the union. But we'll come back to you on notice.
Wonderful. Can you also confirm that Alison Curry and former Labor Treasurer Tim Pallas is now the Administrator's Chief of Staff, and that ACTU Growth Head Michael Flynn is the Deputy Chief of Staff for the Administrator, noting that he presided over the collapse in union membership in the ACTU and previously the CFMEU and the ASU?
Well, I think if we're going to attribute blame to the collapse in union membership, we might look at the IR laws that previous coalition governments put in place that made it impossible for unions to organise, but, leave that aside.
For another day, maybe, yeah.
Say again?
For another day, perhaps.
Indeed. That was in the days of low wages. Ms Curry certainly was the Chief of Staff to the Administrator, but has not held that role for at least several months. But was, I think, when the administration first began, she was the Chief of Staff to the Administrator, but she concluded in that role after some time. I understand Mr Flynn is still in that role as Deputy Chief of Staff.
I think he's Chief of Staff.
Oh, he's Chief of Staff. Chief of Staff. That's right, he was initially Deputy Chief of Staff, is now the Chief of Staff when Ms Curry departed. So yes, and again, it's entirely normal for unions like employer peak bodies to have CEOs, chiefs of staff. You know, they are organisations of multi-million-dollar organisations with many members and many issues to resolve.
Yeah, I understand that, you know, there are sort of commonalities perhaps between different organisations and the people that they employ, but it appears to be that it's sort of the entire leadership team of the administrator that seem to have come from the Labor Party, and perhaps people who have been, you know, candidates or operatives within the Labor Party, and, you know, some might say hacks, but I wouldn't use that term myself.
Well, having worked with some of these people, I can tell you they are high-quality individuals who've taken enormous personal risks to do under enormous stress to do the work that they've done, and have done more to clean up the CFMEU than anyone has previously done before. So it's easy for people, you know, no disrespect, but people in the cheap seats to have a crack at these people. They are doing an incredible job under enormous pressure. As to their backgrounds, again, you know, it's not unusual. In fact, I think it's a helpful thing for people who are being brought in to run a union to have some experience running a union. You know, in other states, the executive officers and other roles, so essentially equivalent to a state secretary outside of administration, they are former union officials.
I guess where my questions come from in relation to that is, do you have a concern particularly in relation to, you know, the events of the past few days with, you know, the allegations in relation to why those chapters or sections of Mr Watson's report were removed, if in fact the influence of, you know, Labor Party people or key Labor Party people within the administrator's office would have perhaps influenced that, if it reflected poorly on the government?
I think that's completely speculative. Mr Irving has made clear his reasons for removing those sections. I understand, by the way, that Mr Watson, who's been giving evidence in the Queensland Commission of Inquiry today, has said that he is absolutely appalled, quote unquote, to see calls for Mr Irving's resignation.
I did see that myself.
So even Mr Watson isn't backing you in.
Yeah. So to continue with my questions, Minister Watt, do you consider there to be an issue in relation to transparency and perhaps public trust in having senior party officials or senior party operatives and or former candidates assisting in senior positions or the most senior positions in the administrator's office?
No, I mean, the roles that these people are filling are similar to national secretaries, assistant secretaries of unions. Those roles, I'm sorry to say, but in most unions those roles are held by people who are members of the Australian Labor Party because they believe in workers' rights. That's why they work there. Just as, you know, if we go through the organisational structure of employer groups, we'll see lots of Liberal Party members. So I don't see that there's a transparency issue. And on the point of transparency, as we were discussing before the lunch break, the reports that Mr Irving has published that were commissioned by Mr Watson, in most cases he was under no obligation to publish them. He's been very transparent. This Victorian one obviously was provided to a commission inquiry in Queensland, but the various other reports from Mr Watson, there was no requirement on the administrator to publish them, but he has done so because of the need for transparency.
And that sort of has led to my questions, and I think I suggested that before the lunch break. Why was this one so different? Why not only was it not published, why did it have chapters removed and then was only shared when the Queensland Commission of Inquiry requested it, which sort of raises the temperature of those questions. There's been nothing to see here before and everything's been fully transparent before. However, now not only did we not share it, but we actually then, when we were going to share it, we removed chapters or sections.
I don't know that you and I can speculate about things we don't know. But
agree, but I'm trying to, on the surface, that would look unusual, right?
Well, it may well be that the administrator was, I mean, the administrator obviously was, I think he was served with a notice to produce or a notice to provide various documents, including this report by the Queensland Commission of Inquiry. It may well be that he decided that given he was going to be producing that report to that inquiry, there was no need for him to separately publish the report because it was going to become public anyway. I don't know. But as I said earlier, the point about why have some sections of this report been redacted and not other reports, I can only assume that Mr Irving did not believe the other reports were not well founded in the way that he considered these aspects of this report to be.
Senators, I'm not making a ruling, but I suppose an observation. The scope is operations and expenditure of government agencies. I feel like we are veering away from that scope, so I just remind senators of the scope before us. Senator Kovacic.
Thank you, Chair. I'll move on. Thank you, Minister Watt. Is the department aware of public statements made by the TWU National Secretary Michael Cain asserting that members are prepared to shut down Australian transport?
Just while the officials are preparing your answer, I might read into the record exactly what Mr Watson has said about Mr Irving today, because it actually went further than what I said before. So I understand Mr Watson told the Queensland Commission of Inquiry he was, quote, absolutely appalled to see some calling for Mr Irving's resignation today. Mr Watson said, if anything I've said here today would suggest that that is an outcome, they should think again. They would be mad to get rid of Mark Irving. Mr Watson said, I might have said harsh things, they're my opinion, and Irving may have had another. I've worked for Irving for 2 years now, and I've never met a more honest or decent man. I can tell you everything he did was opposed to corruption and was in favour of fixing the CFMEU. Doesn't get a lot more glowing than that.
Thank you.
Thank you.
Is the department ready?
Answers? Senator, certainly going back to the earlier questions, certainly aware of comments around the upcoming negotiations. I'm not aware of those specific comments, but
just broad in terms of what's been reported in the media, that would be the extent of.
Yeah, so nothing beyond that. Okay, thank you. Does the department consider these statements to represent a credible risk at all?
What? Sorry, Senator, I didn't hear you.
Does the department consider those public statements that you've heard to be a credible risk or not?
Oh, well, firstly, just to repeat what I just said, I can't confirm that I've heard the statement you just put to me. I'm aware of some...
you can't confirm that you actually have heard it?
No, I can't confirm the specifics you just put about bringing, I think you said bringing transport in the country
to shut... The quote was shut down Australian transport.
No, I don't have a recollection of hearing that. As I said earlier, though...
Did you hear something similar to that?
No.
Okay.
As I said, I'm aware generally that there were media comments made about the enterprise agreements that were up for negotiation this year. And as I said in my evidence before lunch, again, I'm not surprised that in the context of that people will make statements about outcomes or desired outcomes or potential consequences. I do think, though, that what actually happens can be very different.
Gotcha. Okay, thank you. Has the department conducted any modelling on any potential impacts to the economy if there are ongoing disruptions in relation to the expiration of those agreements?
Senator, I think we previously, before lunch, took on notice the extent of any analysis that we have done. So I don't think we've got anything further in terms of that evidence.
Yeah, and if we could add the element in relation to potential impacts to the economy, if there's been any modelling done on that, that would be great. Thank you. And in addition to that, if you could provide on notice any modelling in relation to national supply chains, freight and logistics, or essential services and food security as well.
So, Senator, we'll take that on notice. I would be surprised if we've done that kind of modelling, given, you know, as we've articulated and officers of the department have articulated, we've done some analysis, but once again, there are a range of steps in any renegotiation of an enterprise agreement before, action can be taken.
Okay. Have there been any interdepartmental meetings with Jura about this? But I'm assuming no, given that it's not on your radar?
No,
okay.
Senator.
Cool. All right. In regards to Mr Kane's comments, has the Minister or the Department had any discussions with Mr Kane or the TWU executive?
In relation to... no, I haven't.
No?
Discussions with you about that. No.
No. Okay. All right. I'm curious why the government hasn't directly engaged with the union on these matters, given the importance of the transport sector to all of the things that I've outlined earlier. Yeah, I'm curious as to why you haven't. Yeah.
Well, I think under the enterprise agreement framework, the parties will negotiate the enterprise agreement, so that process will play out in the ways Ms Anderson and Mr Kane outlined before lunch.
That's right, Senator. And in terms of any industrial action, as I mentioned before, these things will play out at the workplace level as well. So each workplace, they need to vote in respect to whether they will undertake protected industrial action. Like I said, before they even get to that step, they do have to. There are genuine good faith bargaining requirements in the Act as well that have to be worked through. So we are talking sort of hypothetical situations that we do monitor very closely. We do monitor these matters very closely, and we would certainly continue to do that as the agreements expire.
For sure, and I note that there can be a view that they're hypotheticals, but they're not hypotheticals necessarily if there have been public comments made in relation to what could and could not happen, as the public comments from Mr Kane suggest. But the TWU would also be involved in those negotiations that you've outlined at a workplace level, obviously.
That's usually
correct, yeah. So what I'm trying to get at is Mr Kane's statements don't necessarily foreshadow like good faith bargaining or the usual processes that you talk about. If before those processes have begun, he's making statements or public statements that they have the ability to shut down transport. So I'm just wondering whether that's like a red flag or not, or if it's not a red flag, why it isn't.
I mean, I'd just come back to my earlier evidence that I'm not... It's quite common that people will make assertions at the outset of different negotiations. As Ms Anderson's outlined, there is a process that has to be gone through in those negotiations. And I think you mentioned 200 agreements, so there won't necessarily be a one-size-fits-all. So for those various reasons, I think we'd be waiting to see how those were playing out and whether or not they do actually lead to disputes before you're able to actually properly and credibly assess the impact of those disputes.
Senator, the department does monitor all industrial disputes. As far as we're aware, bargaining hasn't commenced in relation to the agreements referred to in those articles. As Ms Anderson said, there are good faith bargaining requirements that apply during the conduct of bargaining. There are, quite prescriptive rules around taking of protected industrial action, including that the parties must be genuinely trying to reach an agreement at all times during that process. Employees at each employer need to be balloted and support industrial action. There are notice requirements. There is a ban on payment for industrial action. So that there are substantial processes. It is quite a regulated area, and that, as I mentioned previously, there are also provisions for suspension and termination of industrial action in certain circumstances.
Yeah, and that's where what my questions relate to, is that preparation or that preparedness. and the readiness to deal with that, because ultimately, you know, we talk about good faith bargaining, and you mentioned genuinely trying to reach agreements. So my concern and my questions relate to what measures are in place to ensure that happens, particularly when the National Secretary of the TWU has said that they are prepared to shut down Australian transport even before those negotiations have begun. That sort of seemed to me, as someone on the outside, seems to suggest, well, you know, unless, you know, XYZ happens, know that we can do this. So that's where that preparedness piece, that risk assessment, all of that I've been asking about leans into.
Senator, as Mr Kane said, we do, his area do monitor these things closely. We obviously have been involved in industrial, you know, in monitoring industrial action for some time, under both, you know, either sides of politics, and you know, if anything does escalate, you know, I think the department is quite equipped to provide advice if and when those industrial matters do escalate. But in terms of some comments, I would just refer to Mr Manning's evidence. It's probably not unusual to have a degree of posturing around bargaining as well. It's up to the, you know, the party's right to do that. I don't think in terms of those statements they have at this stage, as Mr Kane's mentioned, the bargaining process has not yet commenced. So I think we are still at a hypothetical stage as to whether these workplaces will undertake any action that may be inconsistent with the law. That simply hasn't played out in that way.
And you're comfortable if it does play out, you'll be ready to deal with it at that point in time.
There's pretty long-standing provisions in the legislation that deals with such matters, and I'm pretty confident that those provisions to date have worked adequately. There's also the Fair Work Commission available to parties as well to assist with disputes, and so there's a lot in the system, I would suggest, that will allow parties to work through these matters together and cooperatively.
So I guess the concern that I'm trying to express is that, you know, for everyday Australians and for small businesses in particular, the impacts of industrial action and whether or not, in fact, you know, threats in relation to shutdowns is actually a part of good faith bargaining, or if it's effectively a warning. And I guess that sort of leads me, Minister, to ask you a question in relation to that. If, as Mr Kane has foreshadowed, the TWU does move to shut down significant parts of Australia's transport network during bargaining, will the Minister exercise powers available to you under Section 431 of the Fair Work Act to prevent serious economic and supply chain disruption?
Well, again, that's hypothetical, built on hypothetical.
No, it's a question. It's a direct question. If it happens, would you do it?
If this happens, that's exactly what a hypothetical is, with respect.
So it's not. Well, it's been foreshadowed, number one. So that's not a hypothetical. That's happened. So the TWU National Secretary has said that he's prepared to do that publicly.
Many things get said in industrial campaigns on both sides of the bargaining table, and I have confidence in the negotiating capability of all the parties in that dispute.
Yeah, and I'm glad to hear that, but I guess that everyday Australians don't have that same confidence and understanding of those bargaining processes, so they're right to be concerned about what will happen to the transport network and to supply chains if these discussions go outside the realms of good faith.
Well, they particularly get concerned when politicians try to convince them that things will be the end of the world. I mean, we've seen what the coalition's high conflict model of workplace relations does. Industrial action under the Albanese government is significantly lower than it was under the coalition, and yet that high conflict model of the coalition also delivered wages that were going backwards. So I don't think we're about to take lessons from the coalition about how to run a workplace relations system.
Can I confirm then, Minister, just to make sure I've got my thoughts correctly aligned in my head, that you won't rule it out. So even though it's a hypothetical, you won't rule out exercising powers under Section 431 of the
I'm not ruling things in
Fair
or
Work
out that are hypothetical and speculative.
Okay, all right. Okay, maybe if I rephrase it, Section 431 of the Act says the Minister can intervene when industrial action could cause significant damage to the Australian economy or any important part of it. How does the government define that significant damage? Like, what is that?
Well,
and what's an important part of it?
My recollection is that that is a phrase that has been interpreted by the Commission and the courts, and the reason I remember that is because Senator Cash, when she held the role of IR, was constantly calling on me to seek orders of this nature, ignoring the fact that it is a very, very high bar, and that our preference is always to see the parties reach a negotiated agreement, but the officials may be able to elaborate.
And then if I could just add before we do that, what then would be that trigger point, and then we go to the officials?
Well,
like if it's a very high bar, what is that bar?
The point about significant damage or whatever the exact wording in the legislation is.
I'm just going to make the point, Senator, that you know that provision hasn't been used in its existence. Right. There are other provisions that have been used where parties are able to seek suspension or termination of action or ministers.
That's right, Senator. And in terms of the evidence required to demonstrate that those thresholds have been met, to often require a significant degree of inside knowledge in terms of any economic harm, for example, and so employers, for example, have well in their right to make applications to seek protected industrial action to cease, for example. They often have, you know, the information required if they believe that threshold has been met. But as the Minister noted, the threshold has, in terms of ministerial intervention, is high and has not been ever used.
I was trying to remember. I knew there was a particular irony to Senator Cash calling on me to seek these orders, and the irony was that no coalition minister had ever done that themselves, but they wanted to get out there and demand that Labor ministers did. I mean, it was just so hypocritical.
I note, though, no one's sought to repeal it, though, either. It sort of still sits there.
I guess it's there in an extreme situation.
Yeah, and that's what I was trying to understand. What is that trigger point for extreme?
Well, the officials have explained.
Yeah,
It was obviously so extreme that even a coalition minister didn't exercise it.
Okay. Did the department provide advice to government during the drafting of the recent industrial relation reforms regarding the risk of coordinated enterprise agreements expiring at the same time? Sorry.
There's been a number of acts under this government, numerous of which have had reforms to the bargaining system. Is there a particular one? So our advice would have been different, and consultation might have been different depending on the changes. Is there a particular one, Senator?
No, not any particular one. Just generally, would you do that and actually sort of, provide some advice or some briefing on, XYZ proposal creates X risk to this group of agreements, or is that a natural part of your process?
I would just note, in terms of the time that I've worked in workplace relations or industrial relations, it's I can't recall a time where there's been provisions that have necessarily dictated when agreements can expire or not. I mean, it is up to there's three parties to these agreements. They agree to often the expiry date, and the department, government doesn't get involved, I should say, in terms of those, when an agreement should expire. It's up to the parties to that agreement to determine when an agreement should expire or not.
Okay.
It's approved by the Commission.
I want to turn to the Secure Australian Jobs Code. Can the department confirm whether the code will require a business to enter into an enterprise agreement?
Sorry, could you repeat the question? Sorry, I was just changing witnesses. We've recently changed responsibilities. So I was asking Mr Keynes to stay, notwithstanding that Ms Brayshaw was coming to the table.
I can give you a little bit of background. Sure. My questions are aimed at getting a sort of a clear and on the record assurances around the limits of the code and how it will be applied and whether businesses can rely on it remaining predictable, transparent, and workable for them over time. So can the department confirm whether the code will require a business to enter into an enterprise agreement?
So the code is, there's a public consultation period on the code and the Future Made in Australia Community Benefit Principles, which commenced in December and is still running until 20 February. So after that consultation concludes, then I think government will make decisions about the scope of the code and its application. So we're not yet at the point of those decisions having been made. So.
Okay. Have any recommendations been made internally? I know you're in the public consultation period, but often there's a framework in place whilst the public consultation is going on, and then things may or may not change based on that public consultation.
Senator.
Senator, the consultation on the Secure Australian Jobs Code is essentially, it's a very broad consultation. It's asking questions about the types of measures that should be required under the code, thresholds, whether it should be targeted at different industries. So to my knowledge, no recommendations have been made around what a code should actually look like. That the purpose of the consultation is to develop that framework.
Okay, so there's no draft code perhaps that you're sort of testing out in public consultation, so there's no code that's been created yet. The public consultation is sort of that first line in development, perhaps.
No, Senator. No? Elizabeth Brayshaw, First Assistant Secretary, Entitlement Safeguards Division. In terms of that consultation, I note that there's actually been a paper released which is very much open-ended questions around each of those issues that Mr Keynes mentioned about its scope, its application and how it would be implemented. So we are very much inviting views from stakeholders
on those elements.
And
does that paper reference whether a business will be required to enter into an enterprise agreement?
Not to my knowledge.
Okay, thank you. If you could provide that on notice if it's any different.
We'll make the link available to the Secretariat. But I think as the officers have outlined, it's genuine consultation.
Yeah, no, thank you. So I have a number of other questions that relate to that. So I can put those on notice in relation to getting that information. The link that you're going to provide, what is that link to?
So that'll be to the discussion paper.
Consultation paper.
To the consultation paper.
Consultation paper itself. How large is that document?
Senator, it is 13 pages long, and it was released on the 19th of December, I think.
All right. Has there been any discussion as to what the definition of meaningful consultation will be under the code, and whether that will require businesses to consult with unions as a mandatory element of that code?
I don't recall that, Senator. Do you recall that? We'll take it on notice and confirm that, Senator, but it's not something I recall.
Thank you. Has there been any discussion as to whether the code will not preference any sort of union density, union presence or union endorsement in procurement or grant assessments? Has there been any work done on that or any discussion in relation to that?
Again, not to my recollection, Senator, but again, we'll confirm on notice.
That on notice?
It's been quite a long process, so we'll just consult the records and confirm.
Okay. Can the department confirm that unions won't be given a standing or formal role in triggering compliance action under the code, and whether that has yet to be developed or not?
Senator, I think we've said there's genuine consultation underway at the moment, so nothing's been determined.
I understand, but whether these, so you have a working document and you have a plan. I'm sure there's work being done outside that working paper as well. So whether there are and I acknowledge that you're saying there's genuine consultation, I want to understand what your baseline is, what you're working from, and what your base expectations are, because I'm sure that that's not all being developed out.
So I think the discussion paper articulates the context and the open-ended questions for people to respond to. Ms Brayshaw or Mr Keynes, I don't know whether there's anything else to add to that, but I think when you see the link, Senator, it will give you the kind of context and the broad questions.
Okay.
No, I don't have anything to add.
Nothing to add? Okay. Thank you. That's all from you, Chair.
Great. At this stage then, we are finished with this section, and we will be moving to outcome 1, employment. Officials as related to workplace relations are free to depart.
Thank you.
We're just suspending for 1 moment so the Minister can change at the table. All right, committee will resume. I welcome to the table Minister Walsh. Minister, did you have an opening statement for us?
I don't, Chair.
Great. All right, we'll dive straight into outcome one employment. I'll be starting the call with Senator Kovacic and then Senator Sheldon. I'm coming to you. Senator Kovacic.
Thank you. My first set of questions go to the effectiveness of the government's self-employment assistance program. I want to get a sense, in particularly given the record levels of insolvencies that we are currently seeing for small businesses, and noting that participation in this program has fallen since 2022-2023. And I'm a bit worried about the fact that, from what I can see, completion rates seem to have dropped, or perhaps even collapsed, from over 80% to around 60%, with Indigenous completion now closer to 50%. Can the department explain why completion rates in the self-employment assistance program have fallen from that figure of 80% in 2022 to 23 to that 60% in the 2024 to 2025 period? And if you're able to give us some insight on what specific program changes caused that deterioration?
So I think, Senator, in terms of program changes, I don't think there's necessarily the link to program changes to any drop in completions.
Okay.
So I'll kind of
we can start with that.
Yeah, let me not start from that.
Yeah.
Obviously, the self-employment assistance program has a range of elements that people can access. And I'll ask Ms Wettinger to kind of step you through some of the performance data and the changes there.
Thank you, Acting Secretary, and thank you, Senator. Jennifer Wettinger, Acting First Assistant Secretary of the Workforce Australia for Business Division. So, as Ms Rishnu mentioned, there are a number of elements under the Self-Employment Assistance Program that clients can access. In terms of completion rates, to your specific question, I might need to take that one on notice. I don't have the underlying data or the underlying reasons behind why those completion rates that you're referring to are dropping. What I would like to say from the outset, though, is that we are seeing really, really good employment outcomes that have been improving. So our post-program monitoring data shows that for people exiting C, 64% are employed 3 months after leaving the program, which does show that the supports that are provided under the program are, really proving to be effective, particularly when compared to other similar cohorts of people that are participating in the program and other services that are provided. So I can take you through some of the outcome data, but in terms of completion rates, I don't have that. Would you like me to expand on anything, Senator?
No, it was more to get an insight of what were the causes of the drop in those completion rates. So you don't have that information?
Not at hand, Senator. I think...
would you have a sense of what kinds of things without the specific data which you can provide on notice, but just a general idea of what has caused that deterioration?
Yeah, absolutely. And I might just throw to Ms Woodall, who is the Assistant Secretary leading this area, just to talk about some of the further information. Ms Woodall.
Sure. So Kate Woodall, Acting Assistant Secretary of the Business and Industry Engagement Branch. So there's a number of reasons why someone might choose to exit the program. It could be that they have found other employment, that their business is not quite going the way that they expected it to do, or indeed any sort of family changes in circumstances where they might need to seek other employment. But going to your specific question, I'd have to take that on notice.
Yeah, because I was going to say I understand the reasons why a person might exit a business. I'm trying to understand why in the 2022-23 year it was the completion rate was 80%, and in the last year, 2024-25, it was 60%. So there's a drop of 20% over that period. So
we can certainly take that on notice, Senator.
Thank you. Given small business insolvencies are at record highs, do you have any sort of has any work been done, any analysis, any modelling about why the self-employment assistance referrals and commencements have fallen rather than increased? Given there's pressure on the sector, one would think that those referrals would go up rather than down. And is the department concerned perhaps that the program is perhaps not operating counter-cyclically, or there are issues with the program?
Yeah. Thank you, Senator, for the question. You're happy for me. So as far as insolvency data, we haven't done any specific analysis, but I'd have to take that on notice just to double check that. I can share with you some of the commencement data that is showing an upward trend in some of our elements of the self-employment assistance, if you like.
Yeah, I'd like to hear that, and then I'll have a couple more questions around exits.
Yeah, sure. So if I just focus on the small business coaching, which is the 12-month element of the program, kind of the key element that people are kind of involved with. So if I start at 2022-23, we had utilisation of 5,775 places. In 2023-24, we had 8,035. In 24-25, we had 8,425. And so far this year, up to 30 November, 4,115 placements that have been used.
Okay. And so I'm taking my mind to, the work that you've done or that you do when people start and when they enter. Have you, particularly given the drop, have you started or formalised any process or extended any process, say in a form of exit interview, to understand when people are leaving, why they are leaving?
Yeah, there's a number of reasons why people that do exit that we do record, but I'm happy to give you some more detail on notice if that's your preference.
And that's just a regular, what is that process? Is it like a survey when people leave? Is it what do you do to capture that information?
Yeah, sure. There is some survey data, but there's also a number, and I'm just looking in my folder, if you give me a second. There is a number of reasons that participants will give us for their reason for exiting. Yeah. And so they can include things like, they, as I said before, that they are no longer interested in running their business. It could be medical reasons. It could be they didn't gel with their mentor and they might like to change. They want to do different training or different employment. So I can give you on notice there's a range. There's probably something in the order of 30 exit reasons of which I could give on notice if you'd like, or I can step through some of the data if you like now.
No, I'm happy for you to provide that on notice.
Great, thank you.
Senator, we do post-program monitoring of all of our employment programs, which is a survey. So participants get an opportunity to come back to the department to explain their experience. That's the survey data also that Ms Wettinger referred to earlier, that looks at how many people then go on to employment.
How many participants exited self-employment assistance in each of the last 3 financial years because their business was assessed as no longer viable? Do you have that data at hand? And do you have the data at hand on what proportion of total exits does that actually represent?
I would have to take that on notice, Senator.
Okay, thank you. Small business coaching participation has increased, but we're seeing completion rates and business viability outcomes deteriorating or worsening. What evidence does the department have that the coaching is improving participant outcomes and meets their needs, rather than perhaps for want of a better description, delaying that business failure for a period of time?
So, Senator, I'll just point back to the previous data that I provided, which was around, our post-program monitoring data that shows that people exiting, are staying either in their business or employed. So I think that that's a really solid indicator of the success of the small business coaching element. I'd also point to the fact that, like any business environment, the economic circumstances as well plays a factor. So we just need to look at those years that we're looking at. When self-employment assistance started, it was in immediately in that sort of post-COVID or still at that COVID time, and coming out of that, there's different economic circumstances that also need to be taken into effect, including the unemployment rate. So
and increasing rate environments and all kinds of factors. Yeah.
Sorry,
and increasing interest rate environments and
there's all sorts of things that impact businesses that are beyond the control of government is what I would say.
Okay, all right. What changes, if any, have been made since 2022-2023 to referral criteria and pre-entry screening? And does the department track whether higher referral volumes are correlating with poorer completion outcomes?
We'd have to take that on notice, Senator.
Okay, thank you. What is the average cost per completed participant in self-employment assistance for each of the 3 financial years? And if we can have a look at how that has changed as completion rates have fallen.
We'd have to take that on notice too, Senator.
Okay, so you don't have that there?
Well, we don't do completion. We don't do an average of that's not calculated in terms of an average, just given that there's so many elements to the program.
Okay, so you don't look at year-on-year comparisons?
We'll take it on notice, but just to set expectations, it is a difficult number to calculate in the sense of there are a number of elements in terms of it varies very differently per participant and per their requirements and their business requirements and the different nature of their business as well. But we can certainly take it on notice. But it's a difficult number to calculate.
Yeah. How do you then? What is sort of the best practice way then of you assessing whether the program is meeting the needs of the participants?
Certainly that post-program monitoring data, which the Acting Secretary has referred to and I've referred to several times, Senator, is an accurate reflection of how the program is being administered. We do have regular contact as well with the providers in our regular engagement with them. And as well as you'll appreciate the peak body, the National Self-Employment Assistance Association. So we're constantly in dialogue with our providers and the association, and looking at ways that we can always improve the program. But I think we've seen the evidence that there is really strong post-program data there, and it has been improving.
When you provide the data on notice for each of those periods of time, could you also give me the numbers of respondents for each of those? So how many participants are actually responding to create that data? Thank you. Female participation in the program is high, which is a good thing, but the completion rates have fallen sharply, so that's a concern. What analysis, if any, has the department done to understand this decline?
I think, as we said earlier, Senator, we'll need to do that. We'll need to come back to you on notice with the analysis of the drop in completion rates, some of the reasons that we've discussed previously, and some of those correlations that you're kind of testing.
Okay, so if we could have a set that looks specifically at the female participation on top of the broader numbers as well, and then going to that, is the department aware of that decline, and are you doing anything in relation to that decline at the moment?
So I think as Ms Wettinger and Ms Woodall have explained, we're looking at all of the data in relation to that program. So commencements, completions, where people are going and what the trends in that are. So as I said, I think we'll take on notice that data to give you a year-on-year comparator and make sure that we're comparing apples and apples.
Sure, I understand, but my question is, have you noticed, has the decline in female completions been something that has been noticed and that some work is being done on? So I'm not asking for the data on it.
Yep.
Have you noticed that the specific decline in the female completions? Or is anyone particularly working on that?
Senator, we're monitoring all of the data. I would just like to note that this this program is commenced in 2022. And we're now 3 years into the program, and we are at a point where we are assessing the program and its operations. And obviously you'll be aware that there is broader employment services reform as well that is being looked at by the government. And so we're at a point now where we are really assessing all elements of this program, and we'll be using all that data to be assessing a way forward. So, yeah, I think that's...
Sure. Okay. And on the post... last question, is it? Okay, thank you. On the post-program data, is there a breakdown... Can you provide me, a breakdown of data by gender so we can see perhaps if there are some exiting factors that are potentially disproportionately affecting female participants? If that would be okay on notice?
We can absolutely take that on notice, Senator.
Yeah. And my very last question, I'll be very quick, has the...
Only because it's your birthday.
Yeah, thank you. And it's not really my very last question for today, but for this bit. Has the Minister's Office provided any direction in relation to this program so far?
I'm not any direction in terms of this program. Certainly, as we've outlined, it is one of the programs that the government is looking at in the context of broader employment reform.
Okay, thank you. Thank you, Chair.
Thank you, Senator. Senator Shelton.
Just questions regarding the PALM scheme.
We'll just get the right officers at the table, Senator.
Great. I just want to get some questions just regarding data collection, redeployment. Can you step me through briefly how does DEWA monitor and track the roughly 32,000 workers who are in PALM?
Yeah, good afternoon, Senator Jason Stott, First Assistant Secretary, Pacific Labour Operations. I'll invite my colleague, Ms Rowe, to the table. She can give some detail, but I'll start in with the first part of your question that went to how do we identify and track?
Yes.
So PALM scheme workers all hold a visa, so there's a shared responsibility between, of course, the Department of Employment and Workplace Relations, the Department of Home Affairs, who rightly monitor the visa requirements. When a worker deploys under PALM, we monitor them via a now electronic information system, the PALM information system. We have their details. That includes the employer and the nature of their employment. That commences when the employer puts in a recruitment plan, so we have those details. And then when there's changes along their deployment, then those details will be updated routinely. We're finding that's an effective system. So, for example, we can identify the number and cohort of workers in an area if there's an approaching disaster, for example. So late last year with fires and some floods, we were able to notify the employers and notify the workers of the pending disaster or disaster event, weather event. We're also able to monitor then compliance with settings along the way. So I might hand over to Ms Rowe, who can give you a more specific detail than I think your question went to.
Thank you.
Okay, Felicity Rowe, Assistant Secretary, PALM Integrity Branch. As mentioned by my colleague Mr Stott, our IT system PALMIS tracks our workers. We've got PALMIS is our system that the department has, and there's an interface to that system which is an approved employer portal which approved employers put data into. Starting from the beginning of a recruitment, our labour sending units in each of the 10 sending countries enter data into their systems, which actually sends data into our system. So we have visibility right at the outset of a recruitment of the data that comes through. When workers arrive on shore, our approved employers then enter data into the system to say they have arrived. And then, as Mr Stott said, when there's movements of workers in country, if workers at a move location, approved employers actually have to seek the department's approval to do that. And we go through and do our due diligence around those processes, but they would then also enter that in the system. And similarly, when workers depart the country to go back home, at the end of a deployment, they would also enter that in the system.
We also cross-check our data with Home Affairs visa data, so there's a marrying up. I should also say, and I think we've mentioned before, we insourced that system back in 2023 when we insourced the program. And we've been gradually, and we've said at a previous estimates, the data in the system wasn't perfect. We've been going through a big data review process to improve our data. And part of that is about also looking at how we improve the capture and the quality of the data, having the right fields in the system and everything. So we've been going through a big process of education of employers and at the same time improving our system so we have the best possible data available to inform us to manage those events like, serious weather events and so on.
Great. Just on the data collection, the fields that are mandatory, for example, worksite location, accommodation, contract duration, sending country, disengagement, injury or death, and when there's field visits by DWAR as well, grievances raised, or the request for redeployment, are all those things included, are you aware?
Which we should start with.
I gave you quite a list. I might have noticed as well. So
I think we can work through that though, so I'm quietly confident. I just want to make plain the system we've been progressively improving. So forgive me for talking about a human as a module, but if a worker is present in the system as a module in the system, not all modules have all the data available because we've been progressively improving the data. We still have workers in the system who were in Australia when we insourced the system, and as we transitioned the model, the data available for those is a little bit like looking at a PDF document. A staff member of the department needs to go find it and look at it closely compared to a more dynamic data environment we have progressively. It's the first part of the response to that. The second part is not all fields in the way that you just described will be mandatory in all instances. So we wouldn't keep data on a monitoring visit perhaps associated with a worker. It might be associated with a location or with an investigation, and that wouldn't always necessarily be in the system. So with that sort of caveat, I can ask Ms Rowe to go through those details for you.
Yeah, thanks.
Yeah, and just to add to Mr Stott's comments there, the approved employer deed sets what is mandatory in terms of what employers need to tell us. And then the system does have some mandatory fields, but there's also fields that are mandatory. They're not forced in terms of being hard-coded into the system, but they are mandatory requirements under the deed. So a really good example of that, Senator, would be if there's a critical incident at a work site or at an accommodation, the approved employer has a mandatory requirement to report that to us within 24 hours of the incident occurring, and they do that through our IT system. But because not every work site or employer will have a critical incident, we can't make that a mandatory field, if that makes sense. So there are mandatory obligations and then there are mandatory fields, and the two different things, but sometimes they correlate. And the mandatory fields and the nature of the mandatory fields, they will vary depending on the type of information we need to fulfil the obligations that we're actually assessing at that point in time. So, for example, if we're assessing a recruitment plan, we need to know the number of workers, which country they're recruiting from, the roles, but it depends on the circumstances which fields are actually going to be mandatory at that point in time. And as Mr Stott has also said, the quality of the data we have for each of the fields is variable depending, because some fields were not mandatory when we insourced the system, and progressively they may have been made mandatory because we've realised we actually need that data for an integrity reason or for approval reasons. So we've been incrementally adjusting and improving the system. We've been doing that in consultation with our stakeholders as well.
Yeah. Does DWA conduct random site audits, and does DWA also request data checks with other agencies like the ATO, Fair Work Ombudsman, in order to assess records that might be relevant to approved employers?
Yeah. So we have we do conduct random site audits. We conduct site audits generally as well, of course. So we have a network of a regional network of relationship managers across Australia who are on the ground and actively go out and monitor our approved employers. I can give you some data in terms of last financial year. There was over 400 monitoring visits of approved employers' sites.
And the number of actual active employees varies from month to month, but it's in the vicinity of about 370. So we have quite a high level of monitoring of our approved employers at any point in time. You asked about
So just on that, is that physical visits or?
Yes, physical. We do some virtual visits, but yeah, the vast majority are physical on-site visits, and at those visits we would usually also talk to workers to verify. You know, we talk to all parties, so we'd talk to the employer and we talk to workers to make sure that everything, the information we're receiving correlates. You asked about whether we do unannounced type audits. We do. They're less common. Like, our approach is generally to work with employers to educate them and try and really build their capability and their capacity, and where we can build that and get the best outcome for everybody, that's actually a great outcome for us and for the worker. We do unannounced audits, though, where the circumstances suggest that we would need to have the element of surprise so that things can't be changed before we come, and we do that where the circumstances. So, for example, if we have a tip-off suggesting that something was happening, and we would go out and actually do an unannounced visit. But I don't have data on the number of unannounced visits we've done. It is something we do quite. We don't shy away from doing where the evidence suggests it's something we may need to do.
We'd better just take it on notice about whether you're able to give us, from the period of the beginning of the PALM scheme, the practicalities of this, but where the visits where the break-up of the category of visits are physical, non-physical, unannounced. Is that possible, or is that, how practical is that?
I think what we could do for you, Senator, is not from the commencement of the program. The data isn't clean from the entire life cycle, but we could take the point, certainly from mid-23, our data is reasonably reliable. We could have a look at, so if we could make that adjustment by agreement on taking that on notice, I think we'll set say June 2023. And
if you could highlight why it's difficult to do you just mentioned when you send that over, if you wouldn't mind, just
Senator,
the complexity.
That correlates to when we were starting to insource the program.
Correct. So what I'm talking
we can rely on that data more accurately.
Yeah, maybe you could explain, just as the reasons why it's 2023 would be helpful, that the data before would be difficult to assess.
Yeah. We're most concerned about the quality of that data and giving you the correct information to be
and also, by all means, if you just mention the quality of the data, would also be a challenge. So it's not to catch you. I'm just trying to work out how the system's changing.
And that's why I think, Mr. Stott and Ms. Rowe were caving in. Our data has improved since we've insourced the program, and we continue to improve that. I'd also say we were.
that idea of the progression, giving it context would be helpful.
And we have officers across the country who do site visits.
We have a very strong regional presence. The precise number slips, but around about 11 locations we have multiple officers. The visits that they do aren't necessarily counted as the formal monitoring visits, so they will be in some instances, but they're talking to employers, workers, community stakeholders daily. That's in addition to then the deliberate, what you might consider a compliance or an assurance order that could be announced or unannounced. It may be associated with investigation, or could just be checking that what's been reported is in fact the case.
Where you're able to capture those other type visits and just on numbers, that would be helpful if it's practical or capable of doing that. Just trying to get a good picture of the activity.
And that's why I raised it, Senator, because I wanted to give you the sense of we are actively managing this program as well as doing those compliance kind of integrity checks.
Yeah, we can give you a flavour of the strength of the institutional compliance and assurance action as part of that. So we could talk to the number of compliance activities undertaken, the number of assurance activities undertaken, what those topics were and what the outcomes were. It will show you quite demonstratively the strength of the institutional protections for the PALM scheme.
That'd be helpful. That'd be very helpful. Thank you. One of the issues that's on redeployment, in particular, that there's been concerns raised about, and I'm not suggesting these are all necessarily in control of people here directly, but or the department, but may or may not be influenced by department processes. The concern about and particularly, for example, the aged care sector, trying to find redeployment positions and some of those difficulties. And just wondering, is it correct to say that the PALM visa does not permit change of employer without the formal approval and action by DEWA? Is that a right way to say it?
I wouldn't characterise it that way, Senator. Yep. The visa settings are set like any other visa, so the settings themselves are a matter for the Home Affairs portfolio and the immigration context within that. It's perhaps best characterised as our approved employers go through a process to become a temporary activity sponsor prior to being assessed as an approved employer. So those settings are set by the nature of the visa, almost comes into effect before the PALM scheme. To answer your question more directly with that context or that characterisation, the PALM scheme worker can be redeployed with the consent and the involvement of the Department of Employment and Workplace Relations, and that is a relatively routine consequence within the program. But I think where your question goes to is that the visa and the nature of the visa scheme more generally prevents a worker from executing agency themselves to make their choice to leave their PALM scheme employment and go work somewhere else without the involvement of the department.
So one of the things I'm trying to get a picture on, which you may not be able to help with at this point, but is that anecdotally, people that are waiting to go on to be redeployed are having to, particularly say for example aged care, are looking for alternate work because they have to feed themselves. So it's pretty logical.
What I might do
and remit money, so that there may be individuals also going to Uber care workforce, contract workforce opportunities. Some suggestions, some are going to cash in hand, which will be reflective of the market, not reflective of those individuals. But yeah, I'm just wondering if you want to make any observations on that.
In fact, if you don't mind, I'll swap out Ms Rowe for Dr Bryson.
Yeah.
We've done a large piece of work on disengagement, commencing around a large-scale compliance activity we undertook a couple of years ago associated with a PALM scheme approved employer. We mobilised the department on a lesser planned basis to try and prevent, lessen or deter completely disengagement.
Yep.
A second piece of work we did on that was to produce an interdepartmental, so with colleagues in Foreign Affairs, Home Affairs and a range of other departments, created a task force to really think through what are the push and pull factors that might generate disengagement. And we produced a body of work of that is now being implemented. We've also built, as a consequence of that work, an ongoing redeployment team within Dr Bryson's branch who actively works to detect those who have already been disengaged and see to what extent we can implement the outcomes that we'll go through in a moment, including redeploying those people. We also have oversight of a professionalised welfare and wellbeing team within the department where we have allied health professionals, including social workers and others, who provide guidance and oversight with grievances or with complaints or with the more difficult or more novel welfare circumstances that sometimes emerge with our program. We have that group of professionals who provide some oversight to assist the worker directly, assist an advocate who's assisting the worker, or assist the employer to get the best possible outcome. So with that context, perhaps over to you, Dr. Bryson.
I'm sort of when you touch on that, and thank you for doing and handing over to Dr Bryson. And it's that context, some of the coverage that we've seen in the media about some of the alleged or actual incidents reported of everything from sexual abuse to physical abuse matters, about how that's dealt with. So maybe
we might break this into two parts, Senator. We might do the grievances after we start with the disengagement task force, the work that's going on, then move into how we deal with those more egregious grievances.
Yeah, thank you.
Senator, I'm due to rotate after this answer.
Yep.
But I can come back to you.
Yep.
Thanks, Senator. Patrick Bryson, Assistant Secretary, PALM Delivery Branch. In terms of redeployments, Senator, they generally occur where a worker's still in an arrangement with an employer. So the employer will come to us, or the worker will come to us and give us notice that that arrangement is going to end early. And so what we do in that circumstance is then reach out to other approved employers and seek to place those workers in another arrangement, particularly if they've got quite a long time left on their visa. And that did occur towards the end of last year in the aged care sector with about 30 workers or so. So it is something that we work through there. In the instance that you were talking about in your question around people working for cash or sort of seeking out their own arrangements, that would be then in the disengagement space. So in that circumstance, if a worker approached us, the government is of the opinion that if a worker's had to leave a role through no fault of their own, that we as a department should do everything we can to make sure that they've got an opportunity to stay in the program. So that particular case would come to the disengagement team, and there'd be an assessment made on the reasons for the worker being in that particular situation. And then we need to see if they've still got a visa, how long they've got left on their visa. And from there we can sort of work with improved employers who are willing to take on disengaged workers and re-engage them and seek to place them in that way. That will not be achievable for all workers in that circumstance, particularly when you're dealing with a historical cohort of workers that might have disengaged some time ago. If their visa's expired, we won't be able to get them back into the program, and it's more about working with them and working with partner agencies like Home Affairs to repatriate them and sort of get them home.
I'll come back. Yep.
Thanks, Senator Jordan. Senator Kovacic and then Senator Nampijinska-Price.
Just two quick questions to round out my questions on the Self-Employment Assistance Program. I do note that you said that all the programs are currently under review, and I note that. All the program is currently under review. Have any internal reviews been done to date on that program, or is this sort of the first one given the program's some 3 years old?
I think I'll get the officers to answer that in specifics, but I would suspect, Senator, that given the program is only 3 years old, you're waiting for data to be able to evaluate.
I was just curious as to
detail.
whether this is sort of the first major one or whether there have been a couple of little ones or something along the way.
Thank you. Thanks, Senator. So, look, we're constantly reviewing the program, and we do have a policy area as well that looks into this. There's no specific review that I can point to other than that it's an ongoing monitoring and evaluation.
Gotcha. So not a formal process with a set of results or outcomes you're looking at, just monitoring the program as it progresses.
Absolutely. Other than, of course, the regular reviews that we do, which you've seen in the data and the data that you've been talking about. But no, there's not sort of been a big review that I can point to, Senator.
I was having a look at the DUA website, and there are I think it's 14, I was just counting, small businesses and individuals sort of featured there on the website. I think there's a Hannah and Anthony, Taylor, Cameron, Andrea, Jaren, Zoe, Lauren, Arthur, Meredy, Hyun Jin, Mari Jae-woo, Kim and Dion, I think are all of them. Do you have any data that you can provide for me whether those small businesses are still operating, whether they're open or whether they're insolvent?
We'd have to take that on notice.
If you could, that would be wonderful.
Can I just clarify, just for expectations, we don't monitor or collect data from participants who have left the program. So some of those good news stories that you are talking about, if they've left the program, we don't collect any data. I wouldn't be able to share that. But certainly if they're still actively engaging with the program, then we'd be able to answer
But
that.
would you know if they've left the program because they no longer have a business?
We can take that one on notice, Senator.
Yeah. Okay. But is that something you would know, that if someone's no longer in the program because they don't have a business, that would be a reason that they're not in there, right?
It will depend on their reason to exit, I suspect, Senator, and whether they've told us for that reason.
Okay. So it would depend on whether, when exiting, they told you they were exiting because their business had closed or was no longer viable.
And remembering this program is about supporting people to develop their business plans, to get coaching and to start a business. So it also depends on kind of which elements of the program they're accessing and at what stage they're at. But we'll look at those case studies and provide what we can based on the data that we have.
Okay, yeah. Would there be, and this has sort of led me to another question, sorry, Senator Nampijinpa-Price, wouldn't it be an idea to maybe understand whether people are exiting, like actually flag to them proactively if you are exiting this program because your business is no longer viable? That is something we would like to know, because that would help you understand how the program is working, or perhaps how to make improvements to the program.
So it goes to the data that we were referring to earlier, I think. But
yeah, absolutely. And the providers would be collecting, the data, both the data that they're contractually required to collect and, anecdotal evidence as well. And as I said before, we certainly do work with our providers and the peak body to collect, both the data that's required and the anecdotal. But as I've said, we are looking at reviewing the program, so looking at sort of the information that we collect as well as part of that.
Thank you.
Senator Nampijinpa-Price.
Thank you, Chair. My questions relate to the Workforce Australia program. The ANAO has identified the completeness and accuracy of Workforce Australia program expenses as a key audit matter. Sorry, I'll let you get organised.
We'll get the right officials to please keep asking your questions, Senator. I think, why don't you ask your question, Senator, and then we'll figure out who the right people are.
Sure. So I'd like to know what specific weaknesses or risks led to the ANAO to determine that this area required targeted audit coverage, and I suppose how have these been addressed?
Hi, Senator. Lisa Schofield. I'm the First Assistant Secretary of the Evidence and Assurance Division. Can I just potentially maybe ask a clarifying question? Are you referring to the ANO's sort of latest information around the performance statement audit that they did?
Yeah, so the accuracy of Workforce Australia programs expenses and the compliance requirements.
So I wonder if you could reference the specific audit that you're quoting from, Senator. The ANAO does routine financial statement audits for the department. It's also just completed a performance audit across all departments.
So it would be in relation to the 24-25 financial statements, where the ANAO has highlighted specific audit coverage.
So I think that would be standard financial reporting, auditing, and the usual financial statements. I think the ANAO and a lot of that would generally be covered in cross-portfolio estimates because it's the broader audit program. In terms of the ANAO's findings for 24-25...
For our performance statement...
For the performance statement audit?
Which sits alongside the financial statements audit that is done. So in relation to that one, and also I look after the employment services related measures in that space, but certainly for the audit for DUA, there were no sort of significant or moderate findings in that. So there was... the ANO gave us a clean bill of health on those. The ANO did flag two minor findings in relation to our performance statements. It flagged that we need to look at strengthening our sort of data governance and quality assurance processes over some of the data sets that we use on those measures, and also indicated that we could improve some of the aspects of what are called performance measure assessment tools, which is the documentation that we use to really drive those performance measures. And certainly in relation to the employment services measures, we have activities underway already to address both of those minor findings.
Okay. So, in terms of, so there's nothing specifically related to the completeness and accuracy of the Workforce Australia expenses as a key audit matter.
Not that not that I'm aware of or that I have in front of me, Senator, but we're happy to sort of, if you can provide us with any other information about the audit that you're referring to, but we'll certainly take it on notice and come back to you, make sure that we haven't missed or that we're referencing the right thing.
Okay, so, well, it's suggested that the Workforce Australia's payment structures and compliance requirements what we've found is that what we need, I suppose, are assurances that the department all provider payments recorded in the financial statements are complete, accurate and correctly classified.
So I think, and Senator, apologies, not knowing kind of which particular audit you're looking for. I don't recall us having any qualified statements in 24-25 in terms of financial audits. We do a range of processes to get accuracy around payment information for providers and outcome payments and the payments across the system. That is also assessed in terms of finance and estimates variations.
Okay. Look, what I'll do is I will put the rest of the questions on notice with regard to this matter.
If you could. Thanks, Senator. And apologies, without kind of seeing the specific audit recommendations, like I say, we've got a range of processes in place that verify payments and we've got clawback provisions if we need to, but if you put them on notice, we'll make sure we have a comprehensive answer for you.
Okay.
I'm coming to Senator DeLager and Sheldon sharing a block now, and then Senator Pocock will come to you.
Okay, great. Thanks, Chair. I have questions about the Reconnection Employment and Learning Program.
Thanks, Senator. We'll get the right officers to the table.
No worries. Thank you. All right, thank you. I understand that the REAL program is due to commence and is to prioritise delivery of services by Aboriginal community-controlled and First Nations organisations. Can you provide us with an update on the outcome of the selection process?
Good afternoon, Senator. I'm Lisa Conway. I'm the Assistant Secretary of the First Nations Employment Policy and Programs Branch and a Yorta Yorta woman. We have just a couple of contracts left to actually be signed to finish the official grant process, so I can't give you exact details. I can let you know that we've had a really good, we had a lot of applications and more than 70% of those were from First Nations organisations and a lot of Aboriginal community controlled organisations, and so far we've had 7 contracts signed with Aboriginal community controlled organisations and another 5 that are First Nations orgs out of the whole 16. And there's still just a few to go.
And sorry, Dr. Conway, how many applications did you have?
It was over 100 applications.
That's fantastic.
It was a really good outcome for us.
I'm happy to take that over 100. That's fantastic. Yep. Can you explain how the department has engaged with First Nations communities to design the program and encourage such a large proportion of First Nations organisations to apply?
So originally there was another program called the Time to Work Employment Service, and that was undersubscribed, and we did evaluations and consultation to work out why that was, and one of the what we found out was it wasn't really developed with First Nations people involved in that process. And so we've then gone out, and the last 3 years we've actually gone out and done consultations each year, sort of informing the next steps of the process. So we've talked to communities to work out what they think success would look like, why the previous program didn't work, what they needed now, and also to find out what would make it easier and more accessible for them to be able to apply for the grants. And so we've worked really closely with them. They made it really clear to us that that the programs needed First Nations mentors, and so and of course communities servicing their own communities. So we've really prioritised that as an area, and really happy with the outcome.
Thank you very much. And broadly across the employment and workforce group, what are you doing to uplift the cultural capability in line with the Priority Reform 3 of the Closing the Gap to make government organisations culturally safe and responsive?
Well, the department's really committed to embedding Priority Reform 3, which is about transforming organisations to be more culturally safe and responsible, because we know that by lifting our cultural capability, that our programs and policies and programs will be more suited to First Nations people, and they're the outcomes we want, is better employment outcomes. So we have been working hard. We've gone through a process of working out how do we upskill our leadership so that they can drive transformation. And to do that, what we did was designed a bespoke cultural capability package. So all SES and EL2s in our employment and workforce group have received a one-day full training that's based on cultural capability. And then we've also, to help them find ways to actually, because this is about transforming internal workings of government and how we do things, so we've actually, we're the early adopters of the draft Commonwealth Monitoring and Accountability Framework, which is a maturity model that actually teaches, shows people where we need to be, how we need to work differently for better outcomes for mobs. So what that means is we were able to do a bit of a base self-assessment and work out where we're at, and what the beauty of it is, it tells us what we need to do next. It means it's measurable, but also gives us a bit of a guiding steer towards that. So we've implemented that, and I guess we've been able to inform the broader Commonwealth pilot that has just happened, which is testing that monitoring and accountability framework.
And Senator, I should say we are very fortunate in the department to have Dr Conway and some amazing First Nation staff. Dr Conway's PhD is actually informed and in this area, so we've been really lucky to grow that capability. We take our responsibilities under the Closing the Gap partnership arrangements really seriously.
Thank you, and Dr Conway, sounds like you've been doing some great work. How, when you with the training with the senior executive, has it been well received by the exec?
It has been, and it was interesting because it wasn't necessarily easy training. It's really important that people are able to embrace the discomfort of sort of identifying where that maybe you're from a group that experience government programs different to other people do. So, but people were really courageous and embraced it, and it had a hugely positive impact for First Nations staff who were delivering it, who've never seen this sort of training delivered before.
Thank you. I look forward to hearing about this as we go through estimates throughout the rest of the year. Thanks very much, Chair.
Thanks. Senator Sheldon, if you want to finish off.
Yeah, I might just go back to Palm scheme. Thank you. And particularly looking at the re-engagement team and the work that's happening there, and take it from there. Good, thanks. Just on you just sort of briefly outline and you've touched on this before, on the policy and procedures and practices for the re-engagement team. And I specifically just wondered, how many staff are employed at DY re-engagement team, and has that changed over the last 5 years, through 20 2023 in particular?
Yeah, thanks, Senator. Absolutely, we can. It's a brand new function. So it started from there was no staff, and now there are. So I'll hand over to Dr. Bryce and take you through the process and the people.
Yeah, thanks, Senator. The team itself was stood up on the 3rd of June 2025. We started with 9 FTE. We currently have 16 and we've budgeted for 19, so we've still got a little bit of recruitment to do. So it's a specialist team covering 3 different functions. So one part of that team is to take forward the recommendations from the disengagement task force that the government signed off on the report from last August. They've got a working group and working through those recommendations with partner agencies. A second part of the team is focused on grievances and the management of the grievance process. And the other part of the team is the re-engagement process that we spoke to in the previous response.
Right. And the approved employers directed to contact DY re-engagement team prior to hiring new palm workers?
They're not directed to, Senator. We take sort of a positive approach to it in that we had to win over hearts and minds with stakeholders through this particular process. So there was a fair bit of scepticism from both improved employers and also partner governments on disengaged workers and how they should be treated. We had to do a fair amount of communication with both stakeholder groups once the disengagement task force report was finalised late last year. And so we've got to a place now where we're building relationships with approved employers and we're sort of basically signing them on as being employers that would be interested and willing to take on workers in a re-engagement space. And so we've got a number of those now.
And how's that actually tracking? Is it?
It's going well. It started slow, but that was because we had to build those relationships. And I think it's really a case of the proof in the pudding. So they want to see that this process can work and that they can give a worker a second chance and that it'll work. And so I think a lot of employers are sort of standing back and waiting for that process to play out.
We should just add the context, Senator, for completeness, that the circumstances that impact or limit the ability of a worker to be redeployed can be as diverse as those that prompted a disengagement in the first instance. So the experience of the worker, the amount of time left on the visa, the requirements from the receiving or sending country, the community that we're within can be diverse. So we do ask a lot of our employers in this scheme, they sign up to commitments that are well above what they would ordinarily, and I wouldn't want to mischaracterise them in this instance. So there is a very broad church of stakeholders and a very broad range of views, and so this work is often done on a case-by-case basis, and that's reflected in the size of the team that's undertaking it.
But no, thanks, that's helpful. Just the PALM scheme support services, might take some of these questions on notice, but in case I need to clarify anything that I'm asking. But the PALM scheme support services line operates Monday to Friday during business hours, as I understand. If you could take this on notice, can you just provide some data for the last financial year or on notice, the number of calls, the nature of calls, and how many of the calls led to a satisfactory outcome for the worker or approved employer?
I think we can give you some of that now, can we?
We can. I can give you a total figure from when we stood up the support line on the 10th of August 23 until 30 November 2025. In total, we've received 10,354 calls. Half of those have been from approved employers about various issues, general inquiries, logging incidents, Palmer's IT issues, that sort of thing. And the other half would be from workers. So where they're seeking information, they might be seeking information about re-engagement, grievances, complaints and allegations, and then a small number of tip-offs. Yeah, but we can take the rest of your question on notice, I think, Senator, and probably just give you some statistics by financial year as well.
Yeah, and a bit of the breakdown of what
go into specifics on all the categories.
On those categories, that'd be helpful. Do the officers of on training, just and again, might have to take this on notice, but do officers of DEWA who deal with PALM workforce inquiries receive training on any of the following or combination? the Australian Modern Slavery Act, the UN Guiding Principles on Business and Human Rights, forced labour indicators from the International Labour Organisation, other Australian legislation including Fair Work Act, Workers' Health and Safety Act, superannuation, workers' compensation, and finally the global standards for social compliance auditors. And maybe you could take that on notice, but give me an indicator would be fine.
I can actually swap that. I think we can give you some of that. It was quite the stack, and I apologise, Senator, I couldn't keep up. My short end's terrible. The answer is yes and no. It is mandatory for staff members who work in the Pacific Labour Operations Division to undertake the Australian Federal Police awareness training to identify modern slavery. We are not the regulator for some of those matters, so our people don't have as intimate knowledge on the matters that were going to the end of your list. I think you go to work, health and safety or some other matters there.
There's quite. What I'll do is I'll actually send them over to you in a question, so you've got the list there. And,
So our people have. It is mandatory to undertake the modern slavery awareness training, and we have a formalised joint whole of Australian government risk management framework where we share risks across program. That includes risks that are shared across foreign affairs, as you would imagine, with the strategic policy, understanding home affairs, fair work, and other departments. That process links to how we identify those and how we make progress with referrals to regulatory agencies. In addition, we require our staff, but in particular those who undertake contract management or provide a frontline service, our regional presence we spoke about before, the people who work in our welfare and wellbeing team and others, it's compulsory to undertake cultural awareness and cross-cultural training. That's the same obligation we apply to our approved employers, we apply to ourselves and our own staff. There's an introductory unit in that training, which is generalised cross-cultural training. There's a further 9 to 10 modules that go to the specifics of the countries with whom we engage. If our people, approved employers and our own staff, are engaging with folks from those nations, it's compulsory to undertake that training as well.
And adding to what Mr Stott has outlined, Senator, we also provide a lot of information to the workers, both ahead of arriving in country, but also when they arrive, in terms of their rights, their entitlements, access to healthcare, access to the Fair Work Ombudsman, for example. So we can kind of complement the answer in terms of the training that we do with staff, but also the information and advice we provide to workers.
The Acting Secretary makes an important point that's important to complete the thought, Senator. That's the training we do ourselves. The workers are also prepared. The preparation for those workers commences in their own country and is largely a matter that in the Australian context is the responsibility of the Foreign Affairs and Trade portfolio, but we have some engagement with them on that. The nations from which they come, they're sovereign nations, they undertake that training. There are packages provided that prepares a worker for their experience in Australia. So it's a cross-cultural experience for them. It is a new experience with a different regulatory environment for a worker who hasn't been deployed previously. When a worker arrives, a worker in the Palm Program will experience an arrival briefing. That arrival briefing has mandatory aspects that are detailed through the program, but also includes the requirement to invite the Fair Work Ombudsman and the relevant union for the particular sector or industry. At the conclusion of a deployment, there are obligations on our approved employer to prepare the worker for return home. That process has occurred, and then subject to the nation's own requirements, they have return obligations or return reintegration activities at home as well.
Yeah, great. You've got a little bit more to say.
If I might just add to the Acting Secretary's comments and Mr Stott's comments too, and just to round that off, we also have an approved employer e-learning platform, because core to actually ensuring the employers do the right thing is that they understand what their obligations are. So we actually make sure that they are educated as well in terms of their obligations, and our assurance activities that we talked about earlier actually inform that. So if we're seeing areas that maybe are less understood, we'll actually build things into our e-learning platform to build greater understanding and capability in our approved employer cohort as well.
Great, thanks very much for that.
Thanks, Senator. Senator Pocock.
Thank you, Chair. Thanks for your time. I was keen to ask some questions about your annual report, and on page 36, we can see that only 11.7% of Workforce Australia participants achieved a 26-week employment outcome against a 15% target. When did the department first know that the target would be missed?
Senator, we covered some of this in previous estimates hearings, but I'll ask Ms Schofield to kind of go through when we first knew and what the other targets look at.
Thanks, Senator. So those measures that are included in our annual report, we report on those quarterly and have done for as long as those measures have been included in our annual report. So we do sort of have a sense over time about how those measures are tracking. So I don't have an exact date for when we knew that we would miss that target, but we certainly capture that data and have a look at how we're going at least quarterly in that space.
And thank you, that's good to know. What do you do when you see that it's so low?
So, Senator, when we gather that quarterly data, and obviously it comes from a range of places, this is a pretty big program with lots of moving parts, as you've probably heard over the course of the evidence today. We will have engagements across the key sort of program areas. So Workforce Australia, that measure around the 26-week outcome is a result of a lot of different activities. So how does the employment fund work? How are those various sort of criteria and access pieces working? How are we finding our job placement rates are going? How are wage subsidies being used? So there's a lot of components, I guess, of the broader Workforce Australia machinery that would sort of play into ultimately what we would report in terms of 26-week outcomes. So whenever we're tracking that data, there are sort of ongoing conversations with all of the parts of the program, the group, to really sort of have a look at each of their components and get a sense of what we might need to do to improve those. We have seen in other data that we track. So in order to sort of get to a 26-week outcome, we also have a look at job placement rates. So how many people are just sort of being placed in roles, how many participants are getting 4-week outcomes, how many are getting 12-week outcomes, and how many ultimately sort of get to that 26-week part. We are seeing across actually each of those over the life of Workforce Australia. So from when it started back in July 22, we are sort of seeing an upward trend, I guess, for those numbers. Not significant, so not massive percentage points, but definitely the trend is going upwards for all of those placements.
What percent to what percent?
So over the, as I said, from the life of the program, so Senator, I've got lots of numbers in front of me and I'm conscious of time, but I would say that at the end of, so I'll use end of November 25, so at the moment our job placement rates are sitting at about 37.4%. Our 4-week outcomes are sitting at 27.9%. Our 12-week outcomes are at 25.3%. And our 26-week outcomes are at 20.6%. Would flag that, as I said, those numbers are from the beginning of the program. The ones that are in the annual report are year on year. So we'll need a bit more information to sort of see whether or not that trend that we're sort of seeing is going to turn up in the year on year data.
Thank you. And how many employment service providers' licences have been terminated?
Yes. So, Senator, in terms of termination, I think we'll go to Ms Field and Ms Spanos. There's often a distinction between termination and not renewed. So we'll give you those.
Sure,
those
maybe
datas.
both then, not renewed versus termination, please.
Hi, Edwina Spanos, First Assistant Secretary, Workforce Australia Provider Support Division. I can give you those numbers, just give me a moment. So the department conducted a licence review with all Workforce Australia Services licences ceasing in June 2025. So we reviewed all 176 licences. Of those, 10 licences across 9 employment regions were not extended and they expired on the 30th of June 2025.
And thank you. What specific performance threshold triggered that termination?
So we actually considered a number of factors across that. We looked at the requirements in the Workforce Australia Services Deed of Standing Offer. We looked at the provider performance assessment. We looked at other performance information. We also looked at what providers had said in their original request for tender. Did they do what they said they would do when we gave them business? We looked at the service guarantee and joint charter. We also looked at financial viability risk indicators and data, and we also looked at their compliance with Commonwealth and state or territory laws and policies, and also as part of that, any sort of breaches or issues or compliances with their deed as well. So it was multifactored, and we looked at every single licence with those factors in mind.
Thank you. And those most recent figures seem to be substantially better than the sort of historical quarterly and annual figures. Do you put that down to the cancellation of those 10?
I would say that would be too simple of answer. I think it's complex. There's probably been a number of factors that are influencing that data over the time. I would say that the removal of those licences has given participants a better service, so those participants that have moved to different providers, and I would say that the government is achieving better value for money from that process. I don't know if I'd be game to tie it directly to that data, but I would say overall it's a better outcome for those in the service and a better outcome for government.
How often do new providers get registered? What does that look like?
So when we did the licence review and we had those licences exit the market, we did have a look to see if there were any gaps. In some cases, and I'll just get the numbers, there were service gaps as part of that process in Cairns, Darwin and Townsville. So while doing the licence review, when we had those made decisions about which licences would cease, we had a look at where there would be a service gap. In some locations we didn't have a service gap. We could allocate participants to existing providers that could provide quite a good service. But we did identify there were gaps in those 3 locations, and we did do a request for an expression of interest at that time, which targeted, due to the locations, Indigenous organisations on the Workforce Australia Services panel.
Okay, thank you.
Senator, sorry, I should also add, in some cases, the licence review led to a 2-year extension of a licence. In some year, for those 10, it was a termination or a cessation of those licences. In some circumstances, we only extended for a year to basically see where the performance lifted.
Okay, that's good to know. I understand that there were also 17 providers that have been placed on conditional performance plans.
Correct, there were conditions. So as Acting Secretary said, when we extended those 166 licences, we did extend. With those, there were some that had conditions placed on them.
So 17 had the 12-month?
No, I'll give you the specifics. So 2 licences were extended for 1 year with conditions. 15 licences were extended for 2 years with conditions.
And have they met those conditions? When's the deadline for improvement?
So we're reviewing those at different points depending on how long some of the performance improvement plan modules were in place or the expectations we had. What we're seeing, and it's quite pleasing, is a marked improvement across all the performance improvement plans. So the 2 licences that are ceasing, we have looked at those at a 6-month period. Given when the licence extension was, so we advised providers that they had a 1-year extension from February, so we started working with them then. So even though the extension came into effect in July 2025, we actually have been working with them since February 2025. Hopefully I've got my years right and it's 2026. We did a review early this year, and for both those licences that we'd extended for only 1 year, they had improved in all the modules that we'd specified, and therefore we've actually been able to give them a licence extension for another year. That has just been approved. And then from there, we've still got a couple of items we're working with those providers on. So overall, I would say it's been quite a successful process in terms of driving performance. And each performance improvement plan was different. So it was about what did that licence need to do, what what aspects were we thinking they needed support to build their capacity as well, and where did we think participants needed some additional supports.
And will these changes result in the performance getting to 15% in this financial year?
Senator, as we've discussed, as Bronwyn Field, Acting Deputy Secretary, Employment and Workforce, there are a range of incentives that we have right across the Workforce Australia system that goes into how we achieve employment outcomes. We've talked of previous estimates that we have both kind of that job outcome payments, but also within that we have other incentives such as wage subsidies. We have other programs that really are supporting those who have got more complex barriers into work. We've introduced Work Foundations, which is really wraparound support for job seekers and working with employers and being placed into employment that will have a job at the end of it because they need more support around that entry level and that continued support to get employability skills. We have a range of measures where we're working with employers around their understanding around how to provide both jobs and wraparound support for those who have more complex needs. So provider performance is absolutely one key part of the system around improving job outcomes, but we have a range of other incentives and programs that we've put into the Workforce Australia system to really try and drive up those job outcome figures.
Thank you. That's good to know. We heard earlier that you're tracking this quarterly, so you must have an idea whether you're heading for the 15%, given the 26 week is an important metric. So do you think we'll hit that this financial year, or how are we looking?
Senator, let me take that on notice. Obviously, 26-week outcomes measured for a financial year. We've only just kind of hit 6 weeks, 6 months of a financial year. So 26-week outcomes are a 6-month kind of indicator. But let me take that on notice in terms of what we're seeing in terms of any improvements in those numbers.
And my understanding that some major providers lost licences while still holding hundreds of millions of dollars in contracts. What safeguards are there to prevent poor performers retaining sort of a dominant market share?
But I might just speak to the particulars of that. Just in terms of the licence review, we were really clear we wanted to... Licences are provided at a location level, so we assign them based on employment region. So while you might have an organisation that holds multiple licences, when we did the licence review, we actually looked at each employment region separately. That was because we wanted to ensure they were providing the service at that local level. So there were some organisations that lost licences because they weren't achieving or delivering the service we wanted in that location, but in other locations they were still delivering a service that meant they were eligible for a 2-year extension. So I just want to be clear on the particulars there, because that was quite an important factor of the review.
And so of the 176, it was 176, wasn't it? Licences.
Yep, 176.
How many companies does that represent?
So that represents, at that time, because we've got 41 organisations delivering now, 2 organisations completely lost their business with Workforce Australia, so that would be 43 at that time.
And Senator, I should say, when you say companies, the services are delivered by a range of private and not-for-profit sector.
What's the breakdown between private and not-for-profit?
I can also provide that if you just give me a moment.
And what was maybe the breakdown of not-for-profit and private that lost licences and also have been put onto performance management?
Okay, so I'll answer the first one first. So as at the moment, if we go for provider characteristics by service type, Workforce Australia Services, Australian Services, we have 14 for-profit, so that's 34% of the market. Now this is at November 2025, and 27 not-for-profit, at 66%. So that's of the 41 organisations currently delivering Workforce Australia services.
Thank you. And then the ones that got canned, the 10 that lost licences, what was the breakdown there?
I think it would be best if I took that on notice. While I have the organisations in front of me, I don't want to really do it on memory and get it wrong.
And maybe I'll notice also the ones that have been given the either 1 or 2 year extension with the performance management.
Yes, of course. So just to be clear, there were two licences given a 1 year extension placed on a performance improvement plan. There were 15 given a 2 year extension. 12 given a 2 year extension placed on a performance improvement plan. There were 3 organisations, and sorry, it's getting quite technical, but there were 3 organisations given a 2 year extension that had other conditions attached. They were things such as delivering services solely in a certain location because we didn't have another provider there, so we'd want to make sure they committed to that. Another example is we asked an organisation to update their key tender representation, so we wanted them to be a bit clearer about what they said they would do, so we could hold them to account. So I'll give all that information in the response to the question on notice, but I just want to be clear there.
Thank you very much. That'd be great. Thanks for your work on this. Thanks, Chair.
So I believe we're now in a position to move to the next outcome. We will take the tea break early, so the committee will suspend for 15 minutes, returning at 4:05, and at that point we will be calling officials from outcome 2, including JSA.
Thanks. So, Chair will release officials from outcome 1.
Those witnesses from SACMA are released.
Committee will now resume. We are in Outcome 2, Skills and Training, including Jobs and Skills Australia. I will be commencing the call with Senator Nampijinpa-Price.
Thank you, Chair. My line of questions will go to the priority hiring incentive. That's all ready to go. Great. Just referring to a question on notice SQ 25001870. I'm pretty sure we've tabled
0070.
001870. Yeah. Some of these questions might require answers on notice as well. Just flag that.
Thanks, Senator. Ready when you are.
Great, thank you. So the department's answer provides data on the priority hiring incentive. Can you please confirm which categories A to S are eligible for the clean energy or construction priority hiring incentive?
So, Senator, the focus of the key apprenticeship program is both housing construction and net zero. The eligibility requirements also allow for occupations that may not directly be in housing construction or net zero but might have a net zero component or a housing component, so for instance manufacturing or say mechanics. We might, I'm just turning to my colleagues, we might just need to take on notice the question in terms of being able to provide you with that specificity of detail.
Please, yeah, if you could take that on notice, that would be great as to which are eligible. You might also therefore be able to provide which categories are not eligible as well on notice. And for those categories that are not eligible, what payment will be available for the employer?
So I can speak at a high level. The arrangements are such that priority occupations have available to them $5,000 per apprenticeship, so $2,500 for the employer and $2,500 for the apprentice. So we'll be able to give you a detailed breakdown of both priority occupations but also key apprentice program occupations, and be able to articulate then what occupations are not eligible.
Great, thank you. And I suppose with that, I'd like to know what process is being undertaken for those employers no longer eligible.
Certainly what... so it was decision of government around non-priority occupations, but I would note that there are a range of other supports available for all apprentices, including apprenticeship loans, the living away from home allowance, the support for employers who are employing apprentices with disability. There's also a range of supports around, for instance, employers using group training organisations. So what we'll do is we'll list all of that because there is, in addition to the incentive, there are a range of other supports government provides.
Okay, thank you. I'd appreciate that. Okay, so just going to the key apprenticeship program, apprentice incentive program. I'd like to be able to discuss the key apprenticeship program, incentive, where eligible Australian apprentices can claim up to $10,000 for a full-time apprenticeship. What is the total annual cost of the apprentice incentive program?
So the total annual cost of the key apprenticeship program, so the total funding for the incentive system for 25-26, which is an estimate, is just over 1.1 billion. The total cost for the key apprenticeship program, can I try this?
Yeah. Belinda Campbell, First Assistant Secretary, Apprenticeships and Digital Projects Division. So the key apprenticeship program is an element within the incentive system, and it involved an additional $626.9 million.
Okay. Just going back a step, sorry, to that previous question as well, with regard to what other supports are available for employers. Can you, and I don't know, you might have to take it on notice, but whether this was communicated to those supports, availability of those supports were communicated to employers?
So in terms of, yes, supports were communicated to employers, both through our providers that do the signing, the connecting of employers to apprentices and do the signing up and support through that process, and also broadly through industry peaks and organisations and through our general communications channels.
Okay, thank you. Just getting back to the apprenticeship incentive. What evidence does the department have that the $10,000 payment increases apprenticeship commencements?
Okay. Senator, the $10,000 payment to the apprentice under the Key Apprenticeship Program and the New Energy Program, which was formerly the NEAP program, includes payments to apprentices, regular payments to apprentices. So it's not a one-off payment of $10,000. It's paid in instalments over the life of the apprenticeship. That is designed to address retention, particularly in those early years when we know that wages are lowest. And we can see, since the introduction of the incentive system, which includes a payment to both the employer and the apprentice, that year on year, looking at a cohort of apprentices who've commenced in the same period of each year, that we are seeing increased retention rates. So taking 2021 as a baseline, a year after those apprentices commenced, 57.6% of them were still in their apprenticeship, as opposed to 2023, where we can see that 66.5% are now retained 12 months after their apprenticeship commencing, and in 2024, that cohort, we can see that 75.7% are still in their apprenticeship.
Okay. Does the department have any modelling of how many recipients would likely have commenced an apprenticeship without this payment?
So the settings for the incentive system do go to driving commencements and as well as retention, as I've covered. The apprenticeship relationship is one of both the employer offering the placement and the apprentice taking it up. So it's not as simple as... It's a much more complex relationship. The incentives to the apprentice are really focused on encouraging people to take up commencements and take up an apprenticeship, and addressing what we know is a key barrier to apprenticeships, the low wages. Also addressing where we know that 80% of the disconnect from an apprenticeship is led by the apprentice deciding to drop out of their apprenticeship, so seeking to address that barrier, while the supports to the employer also encourage them to use an apprenticeship pathway.
Okay, so are you able to provide any data around all of that and what you've just suggested to table that for the committee, and if you have to take that on notice?
I think because of the complexity of that, we'll need to take that one.
If you can take it on notice, thank you. Has the department evaluated whether the payment improves retention and completion rates, and if so, by how much?
So, Senator, thank you for the question.
Sorry, you probably already addressed that in the previous.
Well, and I think the other point to make is that in over 2024, the government commissioned the strategic review into Australian Apprenticeship Incentive System, led by Lisa Paul and Ian Ross. Thank you. And they did an extensive consultations, extensive modelling, looking at historic modelling as well, and did find that the incentive did play a role in both employer and apprentice decisions, but also really highlighted what Ms Campbell just reflected on, which is then the other factors that play out in terms of making those decisions, including prevailing economic conditions, etc. But one of the key findings was the role that the incentive can play, but then also identified a range of other recommendations going to culture, workplace safety, support and guidance to ensure that the investment basically has a return on investment.
Okay, thank you. And does that also provide, I suppose, a comparative when it comes to completion rates between apprentices who receive this payment and those who don't at all? Do you know? And if it doesn't, are you able to perhaps provide that on notice?
So we can definitely look at what we have got in order to provide that on notice. What I would say is that I think the incentive system has been evolving and changing over many decades, and then when you combine that with state and territory supports as well, so there's not necessarily a clean ability to compare a set of circumstances in a set of arrangements with the current arrangements and be able to do that clean compare and contrast. But we will certainly look at what we can provide from the strategic review.
Okay, so I suppose you haven't formulated a measure to do that. Is that what you're suggesting?
So when you say measure, so we do have a model that looks at that considers the impact of incentives on the current numbers, but that model is limited in the context of being able to adjust for all of those other factors that both were highlighted in the strategic review that Ms Campbell's reflected on. So it's a model, but it is limited in its ability to reflect the complexity of the nature of the relationship between the employer and the apprentice within the broader economy.
Okay, so I would assume that there was the department held stakeholder engagement with regard to the successes on completion rates. So what was their view when compared with the employer incentives?
Yes, so I think the strategic review found, certainly highlighted the benefit of the incentives across employers and apprentices. I think that, so your question is stakeholders' views in terms of the relativity of the apprenticeship incentive over the employer incentive. Have I understood that right, Senator?
So in terms of the comparative completion rates between apprentices who receive the payment and who do not, you said it's difficult to measure that.
Yeah.
But how did that compare? In terms of your stakeholder engagement with the sector, what was their view when compared with the employer incentives?
So we can certainly take on notice and provide further detail and a summary from the strategic review stakeholder findings, because we've got quite extensive summaries that we can provide for you. I think, do you want to...
So, Senator, the incentive system that is in place and has been in place since July 2022 is underpinned by a priority list, and so there has been since that time a differentiation in the level of support provided to occupations that are determined to be in shortage, with more support going to those priority occupations. We can see, based on commencement numbers, that since the introduction of that model, which provides support to both employers and to apprentices, that when the support has been taken away from occupations that are not on that priority list in early 2024, in July 2024, there has been a decline in the number of occupations that are no longer receiving priority support.
Okay, are you able to table that model that you have mentioned?
We could show you, provide the data that demonstrates those changes over time.
Thank you. Why was $10,000 selected as the appropriate amount, and what modelling supports that particular figure?
So ultimately, this was an election commitment, and so decision of government. Certainly what we were able to demonstrate to government in making those decisions was that the predecessor program, so the key apprenticeship program, stemmed from the new energy apprentice program, and the predecessor program, which had support for the apprentice and emphasised support for the apprentice at that amount, was demonstrating high uptake, and so was demonstrating to us that that amount was both enough, but not too much, but enough to be able to make a difference in terms of the cost of living considerations for the apprentice, the issues around being able to sort of continue to stay in your apprenticeship because of some of those cost of living pressures, and to support with things like tools and uniforms and so on.
Okay, so you've got the evidence that sits behind that.
We can provide you with that data.
Thank you.
Previous program.
Senator, I'm due to rotate soon.
Yeah, one more question on this section.
Sounds good. Thank you.
And will the department undertake an evaluation of this payment?
Senator, thank you for the question. I think we certainly have a practice of doing evaluations of all of our programs, particularly in skills and training, in the context of the obligations that sit under the National Skills Agreement and the reviews and performance assessments that sit within that National Skills Agreement. So I would anticipate that we will do a review at some point, but I think also it'll be a decision for the Minister at the right time.
Thank you.
Thank you. Senator De Laker.
Thanks very much. Just wanted to get an update on closing the gap.
Just shuffle.
No worries. Great. So I'm just wondering if the department can update us on what progress you've made to date towards closing the gap in skills and training, please.
Certainly, Senator. Thank you for the question. So probably by way of context, closing the gap is a priority under the National Skills Agreement, so for both the Commonwealth and all states and territories signed to that agreement. Within the NSA, there was $214 million invested over 5 years.
I'm sorry, Chair, I'm struggling to hear. If if we could just get, sorry.
So within the NSA, 214 million invested over 5 years to focus on the key priority reforms. So that includes working in partnerships. So we're in the final stages of establishing. We've had an interim policy partnership in place with the coalition of the peaks, and we're in the final stages of establishing the enduring policy partnership signed by all states and territories and the Commonwealth. Strengthening the ACO sector, so we have a sector strengthening project in place, as well as we've been focused on particularly First Nations trainers and teachers, and working, trialling a suite of programs around that RTO workforce. We've also been focused very much on PR4 and improving data and sovereignty of data. So that's in addition to a range of other initiatives that we have that we believe go to supporting our targets under closing the gap. But I might ask Ms Perosa to just reflect on any of those 4 kind of PR4 activities.
PR4 activities?
And the ICOs.
Thank you. Tamara Prosser, Assistant Secretary, First Nations and Inclusion Branch. So as Ms Faithful mentioned, we're working with the Coalition of Peaks to develop a sector capability analysis project. And we're also looking at a government supports mapping project. So what that will do is, from the Peaks point of view, they're looking at mapping the current First Nations Registered Training Organisation sector footprint and assessing operational and strategic capacity and identifying opportunities for sector strengthening. From the government side of things, we're looking at identifying government policies, programs and frameworks and funding measures that may impact Aboriginal community-controlled and First Nations-owned RTOs. What we will do once both of those exercises are finished is bring the two together to inform what a sector strengthening plan may look like. We have also established the Interim Partnership Committee, which is the Interim Vet Policy Partnership. So the IPC is working towards establishing the Vet PP. The IPC was established in late 2004. That group has met 5 times and we are on track to establish the Vet Policy Partnership later in the year.
I might also just reflect on the targets themselves. So we're responsible, there's target 5, 6, 7 and 8. Specifically, we focus on target 6, which is people aged 25 to 34 years who have completed a Certificate 3 and above qualification. And target 7 in terms of people 15 to 24 years who are in employment educational training, but feed very heavily into target 8, which is around employment outcomes. And of course, with our Vet in Schools program, also focused on target 5, which is around attainment of year 12 or equivalent. So in terms of, based on our current data from NCVER, there are 181,635 First Nations students in the vet system. That's up 4.4% from last year, and 3.5% of the total sort of vet population, student population. In terms of our apprenticeship system, there's 12,715 First Nations apprentices in trade and 8,778 apprentices in non-trade. Sitting around the work that we're doing under the NSA, we've also got, in our apprenticeship system, we've got specialist First Nations providers for what we call Apprenticeship Connect, so signing up employers and supporting apprentices. We've got a dedicated skills for employment and education, so foundation, numeracy, literacy, digital skills program. I think there's 12 programs across the country in communities, designed by communities. And we've also got work that we've been doing with communities on the Central Australia response, but also mobile TAFE, so really trying to take training to people where they're at. and that's in addition to a suite of work that all states and territories are doing about uplifting TAFE capability as well.
How's the mobile TAFE going? That sounds...
Do you want to talk about the mobile TAFEs?
That's not in my...
That's another colleague, but so far extensive conversations with states and territories to get them up and running, and Ms McDonald will be able to give us a little bit more detail.
Thank you. Thank you, Senator. Kimberly McDonald, Assistant Secretary, Free TAFE and Skills Funding. So in terms of the mobile TAFE initiative, we've been working with state and territory governments on the parameters for the program. We shared a draft agreement with states and territories for their signature late last year, and to date South Australia has signed that agreement.
Tasmania hasn't signed up yet?
No, not yet, Senator.
Eagerly awaiting them. Thanks very much. That's for me, Chair.
Thank you, Senator Delega. Back to you, Senator Nampijinpa-Price.
Thank you, Chair. My next round of questions with regard to the skills and demand visa and will be directed toward the department but also the JSA Commissioner.
We'll ask JSA to come to the table. Senator, you'll appreciate the work that we do through JSA and the department to inform the skills and demand and the skills migration. Home Affairs obviously manages the visa system and the skill migration piece.
Sure. No problem. So, with regard to the skills and demand visa, 482 is a visa which helps employers to address labour shortages by bringing skilled workers where employers can't source an appropriately skilled Australian worker. So has the department had an engagement, I assume by what you've just told me then, with the Department of Home Affairs in formulating this visa?
Barney Glover, Jobs and Skills Australia Commissioner. I'm here with, my apologies, that's who I am. Jobs and Skills Australia has a mandate under the Skills and Migration Strategy to provide advice to Home Affairs in relation to temporary employer-sponsored skill migration and other aspects of the skills and demand visa system. So we, for example, provided advice to the government on the core skilled occupation list, which is used by employers who are interested in temporary employer-sponsored skill migration. So we've had a lot of dialogue and discussion with Home Affairs about the migration system, particularly as we develop the core skilled occupation list and provide other advice in relation to migration strategy.
Okay. What specific skills shortages informed the design of the specialist skills stream, and what evidence did the department rely on?
Well, again, I might ask my colleague, Mr Bingham, to respond to that.
Senator Cliff Bingham, Assistant Secretary, Jobs and Skills Australia. Senator, with respect to the specialist skills stream, specifics are a matter for Home Affairs in terms of how that policy was formulated, but it is not something where there is a specific regard to occupational shortages. That is more pertinent to the core skills occupation list. The specialist skills stream is deliberately less specific about occupational shortages, and it relies more heavily on a higher income threshold for faster processing times for high paid, high productivity roles, for employers to be able to engage those workers more quickly without relying on specific advice from Jobs and Skills Australia.
What kind of roles would they be?
So the migration strategy set out that the specialist skills visa would be available to all occupations except major occupational groups 3, 7 and 8 in the former Australian New Zealand Standard Classification of Occupations, or ANSCO. So it was the bulk of the Australian labour market is able to use that readily, except those 3 major occupational groups.
And Senator, the structure of the migration strategy is a matter for Home Affairs rather than Jobs and Skills Australia. And occupational shortage is very relevant to, along with other characteristics of the labour market, to the core skilled occupation list.
Okay. This visa only includes Australian New Zealand standard classification of occupations listed in major groups 1, 2, 4, 5 or 6, but excludes technicians and trade workers group 3, machinery operators and drivers group 7 and labourers group 8. Can the department advise why these groups are excluded from the visa and where they recommended to be included?
They're all included under CSOL, under the core skilled occupation list, Senator, rather than the other list.
So I might just add to that, Professor Glover's comments. So the decision around inclusion and exclusion as it relates to the specialist skills visa is a matter for Home Affairs. That was not a matter which they sought advice from Jobs and Skills Australia on. The migration strategy sets out that the government specifically asked Jobs and Skills Australia for advice on the core skills occupation list. That reflects roles that are what are called skill level 1 to 3 occupations. So these are roles where you would typically expect to see either higher education qualification or a vocational education and training qualification of a Cert 3 and above. They cover a significant span of the Australian labour market, but some lower skilled roles are ineligible for the core skills occupation list. Again, that parameter is a decision of government, but it is consistent with previous decisions around skilled migration, around previous iterations of the 482 visa and its predecessors such as the 457 visa.
Okay. So what assessment has the department made of this stream's impact on domestic training, apprenticeships and workforce development?
Senator, it's still relatively early days for that particular visa. That visa, the core skills occupation list and the skills in demand visa, came into operation in December 2024, recognising that at that point there were still visas to be processed under the preceding 482 visa, under the temporary skills shortage visa. As part of our work in providing advice to the government to form its final deliberations on the core skills occupation list, we, in our quantitative analysis and our stakeholder engagement, considered domestic skill shortages, domestic skill needs, but also worker outcomes, both for migrants and for those who've recently been trained domestically through the higher education and vocational education and training pipelines, which is sort of consistent with the key mandate that the migration strategy set out for Jobs and Skills Australia. We provided that advice to the government in August 2024. That led to the government decisions in December 2024 to implement the Skills in Demand visa. To date, matters of detail around exactly the visa composition are matters more for Home Affairs, but certainly from what we see through the published Home Affairs data, we see use of the core skills occupation list and the Skills in Demand visa pathway there predominantly in professionals roles and technicians and trade worker roles, and that aligns pretty closely to where we see some of the most challenging domestic skills shortages.
Okay, so given you're saying it's too early to for an assessment, will it be understood as a sort of time frame?
So the migration strategy set out a role for us for essentially a regular monitoring and evaluation of the Skills in Demand visa, and of course, as the government asks us for updates to our advice, for example, for the core skills occupation list, we will take into consideration what we are observing through the use of those migration pathways, the complementarity of that with domestic higher education and vocational education and training pipelines, the evolving needs of the Australian labour market and how that's playing out in labour shortages. Obviously, as the longer that visa has been in effect and the more migrants have utilised the Skills in Demand visa, the better the evidence base we will have to be able to provide advice to government.
Has the department identified any evidence of displacement of local workers or wage suppression linked to this stream?
Senator, not at this early stage, recognising, and again, Department of Home Affairs would be better placed than me to talk about the quantum of visas, but the use of the Skills in Demand visa to date, I think, is still less than 1% of the total Australian labour market. I might have to take on notice the specifics just to get the most recent data from Department of Home Affairs, but the utilisation of that skill stream is still in its relative infancy and therefore a relatively small component of the total Australian labour market. We would expect things like wage data to take a year or two to manifest, given that wage data you want to see annual figures to sort of smooth out some of the shorter term volatility. But at this stage we've seen no early signs of job displacement or wage suppression.
With regard to my next question, you might want to take it on notice, but what advice has DUA provided to the government on reducing long-term reliance on skilled migration under this stream?
So could you repeat the question, Senator? Sorry.
What advice has DUA provided to government on reducing long-term reliance on skilled migration under this stream?
So, Senator, I might step in there. Obviously, advice in terms of skilled migration and visas is a matter for Home Affairs, for the Home Affairs Minister. I think the role of JSA and Jobs and Skills Australia in providing a robust evidence base that is tested, that is transparent, and that is evidence-based that goes to informing those skills gaps and the need for migrant, skills is a clear evidentiary role. In terms of advice to government, though, on reliance on skilled migration, that's a question for Home Affairs.
Okay, what is the JSA Commissioner's role in advising on specific skills shortages, and how is this used to inform the design of the specialist skills stream?
Well, Jobs and Skills Australia produces the occupational shortage list every year, which again, Mr Bingham can provide some detail on the background to that, but we look at recruitment difficulty and shortages across the Australian labour market and produce an occupational shortage list. That's one of the contributing factors that we consider in producing our core skilled occupation list advice to Home Affairs and to the relevant minister, along with, as Mr Bingham said, other factors like migrant outcomes in the workforce. So propensity for shortage, reliance on skill migration, these are all considerations, along with a great deal of consultation that we do in preparing our advice to the Minister on the core skilled occupation list. Bearing in mind, Senator, this is temporary employer-sponsored skilled migration, so it's a particular category of skilled migration. The employer sponsorship is important, so there's an income threshold involved as well. And so this is important for employers to understand which occupations are on that list that they could use for temporary employer-sponsored skill migration. So that's the nature of the way we determine it and the methodology we use to provide, as the Acting Secretary said, the evidentiary basis for advice to the Minister.
So, I assume that you have evidence to rely upon. Are you able to table that or provide that on notice?
Our website contains the detailed methodology we use for the core skilled occupation list. We can provide that on notice to the Senator.
Thank you. How often is the occupations and skills framework for this specialist skills stream reviewed, and when was the last review completed?
I'll let Mr.
Senator, just to clarify on the previous point, as Professor Glove touched on, our analysis and the relationship between occupational shortages and skilled migration is specific to the core skills occupation list. So our analysis of occupational shortages does not flow through to the specialist skills stream list. That is a decision that Home Affairs would be best placed to speak to. But as I said before, the specialist skills stream is available to 5 of the 8 major occupational groups, and it does not use our occupational shortage assessments as an input. Our work on the core skills occupation list, the migration strategy, indicated that Jobs and Skills Australia would be asked by the government on a broadly annual basis to consider updates to this. Obviously, we're still fairly early in the process of doing that, but that is our continued anticipation in terms of the timeframes. And as Professor Glover touched on, coming to your earlier point about long-term reliance on skilled migration, the core skills occupation list is a temporary employer-sponsored visa for a maximum of 4 years. If we are in the world of annual updates to that, that list will evolve over time, reflecting Australian labour market needs, reflecting the complementarity of migration with what we're seeing in terms of domestic training outcomes, labour market outcomes for people coming through higher education and vocational education training pathways.
Thank you. If I have any more questions, I'll put them on notice, but in the interest of time, I will hand over the call.
Okay, are you finished with questions for this outcome?
No.
Well, then you still have the call.
Continue. Okay. I would like to address fee-free TAFE as my next lot of questions. There you go. Great. Okay, so my questions refer to question on notice SQ25 001873. Can the department confirm that based on the government's own data, not a single construction-related qualification appears in the top 10 free TAFE courses by enrolment between January 23 and September 2025?
So, Senator, these course lists are for the free TAFE program overall, not just fee-free construction, but yes, that's correct.
That's correct, okay. Yeah. Given the well-documented housing and infrastructure shortages facing Australia, does the department consider it concerning that no construction trades feature in the most popular free TAFE courses?
So, Senator, construction is one of the most enrolled sectors for free TAFE. And if you just give me one moment, I will get the figure overall. Yeah, so there have been 59,023 enrolments in construction-related courses, which is 8.1% of the program overall.
8.1%. How does that percentage compare to enrolments in administration, education, support and compliance-related courses?
So, Senator, we don't have those exact categories that you referenced. The largest sector for enrolments is the care sector, so disability, aged care in particular, and that's seen 198,666 enrolments, which is 27.4% of the program overall. The next largest behind that is technology and digital enrolments, which is 9.5% of the program, and then construction is the third largest sector.
Okay. Are you able to get that information for me on notice with relation to the question?
Different categories? Yes, we can take that on notice and prepare
Senator,
that.
I think there's some detail in Table 2 of that QAN that you referenced that provides some of those numbers, but we can supplement that.
Thank you. What analysis has the department undertaken to explain why certificates in carpentry, plumbing, electrical, bricklaying and construction management are not attracting comparable enrolments?
So, Senator, sorry, bricklaying, what were the courses you mentioned? Bricklaying?
Carpentry, plumbing, electrical, bricklaying and construction management.
So, what I would point to is the government's announcement around fee-free construction. That kicked off January 2025. It has a focus on construction trades, so I will double check, but I suspect it does include many of those occupations that you've listed, so maybe we can take that on notice to give you that specificity. Okay. But that is, Ms McDonald, 30,000 places across the country, 20,000 places across the country.
For 2025 and 2026. And for that initiative, as of September last year, there had been 16,000 440 enrolments in fee-free construction, which was 82.2% of the 2-year target.
Okay.
Yeah.
I mean, has the department assessed whether current funding settings are unintentionally discouraging enrolment in construction and trade-based courses?
Fee-free TAFE as a policy has a range of policy objectives. So it's the one core objective is to deal with cost of living and support students to overcome barriers to accessing skills and training. Another policy objective is to attract priority cohorts, people who might otherwise never have dreamed of attending VET, and enable them to participate in skills and training. And the third policy priority is really focused on attracting people into those areas of national skills needs, national priorities, which are articulated in the National Skills Agreement. So understand the nature of your question in terms of is this investment, which is really only a quarter of the total VET investment. So it's a quarter of the total VET student activity. So there's 5.1 million adults in VET across the country. Free TAFE is focused on a quarter of that activity with those very specific policy objectives in mind. We're obviously keen to ensure that people participate in VET across the board, but our current assessments would say that it's not having a negative impact on the broader funding and health of the system.
So is the department satisfied that current free TAFE incentives are aligned with the national priorities around housing supply and major infrastructure delivery?
So, Senator, as Ms Faithfull said, there's a range of different national priority sectors, of which construction is one element. We're confident that the program overall is delivering across all of the national priority areas. And I would just point to the fact that those qualifications that you mentioned just before, the key pathway for those professions and industries is the apprenticeship pathway and the incentives that obviously you were discussing a little bit earlier today.
Okay. Can the department explain why nearly 31,000 students were enrolled in the Cert 4 in training and assessment, making it one of the most popular courses under free TAFE?
So, Senator, yes, and that obviously to grow the construction workforce, you do need more trainers and assessors who are qualified to train builders, plumbers, a whole range of professions. So most of those enrolments are coming from Victoria in particular, and they've focused fee-free construction in part on growing their training workforce to boost longer-term construction supply.
Okay, and does the department track how many of those Cert 4 in training and assessment graduates are currently employed as qualified trainers in priority skills areas?
So, Senator, we don't receive individual student data and we can't track that through to employment, but we are able to look at completion figures and over time.
Are you able to provide that on notice then? In terms of...
I can take that on notice. The only thing I would note is that because fee-free construction started just last year, there hasn't been a lot of time for those enrolments and those people as part of the system to finish their courses. But yes, we'll take that on notice and see what we can provide.
Okay, and does the department have a breakdown on which sectors are using the Cert 4 on training and assessment?
So, Senator, is the question like the people that do the Cert 4 in training and assessment, what sectors
they're going into?
Yeah. I can take that on notice.
Yeah.
I don't think we will have that level of information, but I'll look and see what we can provide.
Okay, and does the department monitor whether graduates of Cert 4 in training and assessment are primarily training others in the same qualification? creating what some might describe as a training for the sake of training?
Senator, I'd have to take that on notice just to see what we can provide in relation to the Cert 4 in training and assessment.
Okay.
What I would say though, Senator, is just to Ms McDonald's point earlier, is that it's a requirement of any teacher or trainer in vocational education to have the Cert 4 in training and assessment. So it really is a key component of being able to build our teacher trainer workforce, and that's kind of our first priority in that context of being able to then increase the pipeline of people coming, increase training capacity. We need those teachers and trainers.
Okay, so on that note, has the department assessed whether a high volume of training and assessment qualifications represents workforce development, renewing, upgrading qualifications, or is it just simply training for the sake of training?
So I think it's a good question, and we'll take that on notice. Yeah.
Okay, thank you. And can the department advise how many free TAFE places were allocated specifically to construction trades in each year from 2023 to 2025? You might want to take that on
Yeah, I can
notice.
take that on notice. We can definitely provide the enrolment figures for construction over that time period.
Thank you. What steps has the government taken to prioritise construction and building skills within the free TAFE program, given their absence from the top 10 enrolment list?
So, Senator, the main pathway is through the fee-free construction initiative, which was announced in the 24-25 budget, and that's providing $86.4 million over 2 years to deliver that 20,000 new fee-free construction training places. It also includes 5,000 pre-apprenticeship places, providing young students and others with a taster of what it's like to undertake an apprentice and to gain some experience in the construction sector. And as I mentioned earlier, we've had 16,440 enrolments to date, so it's reached 82% of the 2-year target in just 9 months.
Okay. All right. Well, I mean, in light of this data, how does the department justify claims that free TAFE is addressing skills shortages when the sector's most critical housing delivery appear to be underrepresented?
So, Senator, obviously the fee-free construction pathway is an important element in terms of fee-free TAFE overall. And as I mentioned earlier, apprenticeships are also an important pathway to growing the construction workforce overall.
And I think that's, just to add to Ms McDonald there, I think that's an important part of the intersection. So the government did make that commitment to the key apprenticeship program, which focuses on construction, energy transition, net zero, but very much focused on housing, apprentices in housing construction, with that $15,000 investment in that apprenticeship, and that covers the occupations that you articulated earlier, Senator. So I think they're pulling both levers to respond to that critical workforce need.
Okay. What I might do is put all other related questions on notice.
Great. All right. Thank you very much. In that case, we are now in a position to dismiss officials from outcome 2, skills and training. So thank you all very much. We'll suspend for a couple of minutes while we call the Office of the Fair Work Ombudsman to the table. Office of the Fair Work Ombudsman, including the Fair Work Ombudsman herself, Miss Anna Booth. Ms Booth, do you have an opening statement?
Good afternoon, Senator. No, not on this occasion. Thank you.
Okay, thank you and welcome. Senator Kovacic, you have the call.
Thank you. And thank you again for appearing today.
Thanks, Senator.
I just want to ask some questions in relation to the Fair Work Ombudsman's investigation into some alleged safety breaches by a CFMEU official. When did the Fair Work Ombudsman first become aware of the allegations that a CFMEU official had breached workplace rules?
Senator, are you referring to the matter of the Cross River Rail Wollongabba incident that we have recently lodged in the Federal Court? Yes, it was in the newspaper, the Courier Mail. I haven't got the date, but I believe it was October of 2024. It could be the 16th. That's the date that comes to mind, but I will ask Ms Volsky if she could confirm that.
Yes, Senator. Rachel Volsky, Chief Counsel, and it was reported in the Courier Mail on November the 16th of 2024.
Sorry, it was not November, not October, Senator.
Yeah, thank you. And just, did the awareness arise from a complaint, a referral, media reporting, or another regulator, or maybe a combination of those?
It was in fact the media report that first came to our attention, which is a common way in which the Fair Work Ombudsman identifies matters that we consider worthy of further inquiry. And on that occasion we made those further inquiries, and Ms Volsky, or indeed Mr Campbell, who would have overseen the investigation, and then of course Ms Volsky's overseen the filing of the matter in the Federal Court. Both could give more detail, but I'm very happy to keep answering as much as I can before I pass over to them.
Yeah. What you can, and what you can't, we can do. Can you confirm whether a formal investigation is currently underway, and if so, when that commenced?
The investigation has concluded, and the matter's been transferred to our legal group that has actually filed in the Federal Court. So there's a statement of claim which will contain obviously the allegations that we have formed the view are appropriate to put before the court as a result of that formal investigation.
Okay.
And my colleagues will, of course, correct me if I'm...
Senator, the only point that I would add is that the court, and it's actually the Federal Circuit and Family Court of Australia, the Brisbane Registry, and the first court date is the 25th of May 2026.
Okay. So there may be some things that you aren't able to speak about as well in relation to that, I'm assuming?
Senator, there's been a media release that we have put out in relation to that matter. It's obviously before the court at the moment, so we'd have to be careful what we say.
Well, please let me know if at any point, obviously, we need to be careful. Are you able to tell me what the scope of the investigation was? And given it's before the courts now, this might not be an appropriate time. Does it relate to conduct by an individual official, the CFMEU as an organisation, or did it relate to both?
I'm going to ask Mr Campbell to comment on the scope of the investigation.
Sure. Senator Michael Campbell, Group Manager of Operations, the Fair Work Ombudsman. So the proceedings that we've commenced involve contraventions and with respect to conduct of officials on site, two officials, so both them and their conduct, and also the union itself.
And then do the claims also relate to those, the legal claims now?
Well, I'll let Ms Volsky speak to this, Senator.
Sure. So, yes, so the statement of claim lists the two individuals, two of its officials, Mr Cody Budgeon and Mr Dylan Howard, in relation to conduct, and then the CFMEU, it is alleged, and again, allegations only at this stage, obviously, that they are potentially liable as an accessory under Section 550 of the Fair Work Act.
Okay, thank you. Has the Ombudsman coordinated or shared information with work health and safety regulators including state-based safety regulators in relation to these allegations?
Senator, as a matter of course, we have made referrals to state-based health and safety organisations. I'm not sure with respect, I don't think with respect to this conduct, I can take that on notice.
Okay, that would be great, thank you. Has the Ombudsman assessed whether the conduct that was under investigation and now subject to claim could affect the validity of the right to entry permits held by the officials concerned?
Probably for Ms. Volsky to...
So, Senator, again, I would stress that these are allegations only at this stage. Okay. I can confirm that both of those individuals hold a right of entry permit at the moment, and then obviously, and I would talk more generally now, that any finding of contraventions may well be relevant as a permit qualification matter for the Fair Work Commission to determine whether or not someone is still fit to hold a right of entry permit.
Yeah, so that's where I'm sort of wondering, so would the Ombudsman then take or consider taking any interim compliance or enforcement action while the matter is afoot?
So, Senator, I think the Fair Work Commission there are a number of permit qualification matters that they can take into account. Allegations that haven't actually been subject to a formal court determination would only potentially be relevant as any other matter that the Commission might consider relevant. I guess, at this stage, we've got this matter in court and, we think that's the appropriate action to take in relation to these individuals, particularly, we filed this matter, but obviously the conduct allegedly occurred back in November of 2024 as well. Okay. So some time ago, and I think reasonably soon, close to the administration.
Thank you. Has the Ombudsman briefed the Minister or the Department on the progress of the investigation as it went and then its current status?
I don't know whether...
So, Senator, at a broad principled level, we obviously keep the Department and the Minister informed of our activities at a high level, but of course it's important that we maintain the integrity not only of our investigations, obviously, but also potential litigation. So, we share thematic information as appropriate.
What you need to, while not compromising what you're doing. So the Minister perhaps was briefed on key elements of it without giving away particular information.
Well, and I couldn't even confirm because I can't recollect that there would have been a discussion about this particular matter, but obviously as part of our broad work in building and construction as a priority area, there are areas of focus that we've looked at, and obviously right of entry is one of those matters that we're particularly concerned with also going forward, as well as some of the work that, Ms Booth is looking for right of entry, I guess, moving forward in terms of a more collaborative approach.
Is there then maybe a process or a protocol in place to sort of monitor this, and then perhaps if it gets to a certain point, that's when you actually report concerns to the Minister, or what's sort of the plan with that?
So our regular protocol is to, when we're about to issue a media release, to inform both the Department and the Minister's Office of the imminent release of the media release. We also do a quarterly report to the Minister's Office that covers our performance outcomes and would, as a normal course, identify any matters that we were bringing before the courts. But I'm not aware that we keep a running commentary between the Fair Work Ombudsman and the Minister. I expect that we do not, Mr Campbell, in relation to investigations, because these matters obviously unfold, and even I do not get, as Fair Work Ombudsman, a running commentary of what's unfolding with investigations, because things change, and it's important that the investigation integrity is maintained.
Yeah. I guess my sort of thinking is around if there is an increasingly consistent problem with a certain element like the right of entry, that you're getting, more complaints, or it's becoming a regular feature in your complaints? What would the process be for dealing with that?
In terms of the generality of the conduct of organisers and other union officials in workplaces, it has been a priority for the Fair Work Ombudsman to work with the industrial parties to develop advice about what the appropriate approach is to take. Unions have a very important role in workplaces and in our industrial relations system. And so we've recently issued some new guidance under the title of Representational Rights and Responsibilities, which was developed collaboratively with both employer groups and the ACTU, and presented to and accepted by our advisory group. So that's the kind of systemic response that we have to the becoming aware of issues in the workplace. And then there's the more general approach we're taking in building and construction, which Mr Campbell can speak to.
Are you able to tell me, if you have the data at hand, and if not on notice is fine, but if you have it, it would be good, what the total number of active investigations into members of the CFMEU is now?
Yes, we certainly can, Mr Campbell. I'll ask Mr Campbell to do that.
Thank you, Senator. As of 29 January, we have 29 investigations involving the CFMEU, its officials and/or employers with alleged association with the CFMEU. So 17 specifically with respect to CFMEU and its officials.
Okay, thank you. Okay. I have another set. Did you want to rotate the call?
I'll rotate at this point then. Thank you. Senator Payman, you have the call.
Thank you, Chair. Good afternoon. So my line of questioning is around the criminalisation of wage theft. Since the criminalisation of wage theft commenced, could you please outline how many allegations relating to wage theft have been reported to the Fair Work Ombudsman?
I can tell you, while Ms Carey's becoming settled, who has responsibility for this area, that we have 2 current matters under investigation. As to the genesis of those matters, I think your question really goes to what actual complaints might have been received that have crystallised into investigations. I'll ask Ms Carey to speak to that.
Thank you.
Thank you, Senator. Michelle Carey, Group Manager, Regulatory Transformation at the Fair Work Ombudsman. As Ms Booth just said, we have 2 active investigations at the moment. It's a bit difficult to answer the question as to how many allegations have been received in relation to wage theft. Obviously, the agency receives a number of requests for assistance from workers and through our intelligence channels and anonymous reports, so that's not data where we could necessarily provide you with a specific answer, but what we do in accordance with our compliance and enforcement policy and our prioritisation model, some water, my throat's very dry, is we obviously then assess those matters according to how they get treated. So the matters that are serious allegations of deliberate underpayment potentially come to the Criminal Investigations Branch, for assessment.
Okay. So there isn't really a way of finding out if, the number of allegations that then turn into, or at least have formal investigations initiated. But at this moment in time, we've only got 2 active investigations.
That's correct, at this point in time.
What we can tell you is that we get, around 200 last year, around 288 inquiries, 1,000 inquiries. We get of those inquiries, around sort of 18,500 become disputes, and we also do, of course, proactive work. We've conducted last year about 1,500 proactive investigations. So all of that, as well as having 15,000 anonymous reports, and those all come in, and then they are triaged, and some of them will make their way, a much smaller proportion, of course, would make their way to Ms Carey, and then a decision is made based on our compliance and enforcement policy about which we would actually investigate, and that's where you get the 2
Excellent, thank you. So where appropriate, are you able to share how many investigations have resulted in referrals to the AFP or the Commonwealth Director of Public Prosecutions?
So no referrals have been made at this stage, Senator.
Beautiful. The 2023-24 budget allocated $49.5 million over 4 years to support the new criminal investigation function. Could you please provide an update on how that funding has been implemented, including how many staff are currently dedicated to wage theft investigations?
Thanks, Senator. So we've established a dedicated criminal investigations branch. That branch currently has 16.7 ASL allocated to it. There are 8 Fair Work inspectors that are badged inspectors, but I would make the point that whilst they're dedicated to the function, they're then supported by a range of other resources across the agency. So that includes our calculation analysts, our intelligence analysts, our in-house legal team, project support, and we also have support provided from external providers. So we have forensic support provided by a third party, and we obviously can call upon the Australian Federal Police for support in relation to warrant execution.
Wonderful. Okay, thank you. And in the 2024-25 budget, $1.9 million was allocated to pilot increased monitoring of wages under the Seagoing Industry Award 2020, particularly for seafarers on foreign vessels engaged in coastal trading. Are you able to share any early findings or observations from that pilot?
I'm going to ask Mr Campbell to address that, but we certainly have been active in that space, Senator.
Thank you.
But the detail will be in his briefs.
Yeah, it will be. Bear with me, Senator, because I just want to make sure that we're talking about the same thing, because I know a few different topics have been discussed around Maritime in the House today. So you asked about the work that we're doing, the compliance and enforcement program we're doing with respect to coastal trading, is that correct?
Yes, the pilot increased monitoring program.
So we have we designed a 2-year program where we agreed to conduct a series of investigations with respect to contraventions of the Seagoing Industry Award. We've so far conducted 28 investigations as part of that pilot. I think, if I recall correctly, we agreed to conduct 40 as part of the MOU we struck with the participants. We've been able to recover $783,000 for 209 crew members across those investigations.
Okay, great,
And
thank
we
you.
work closely with the other regulator, the Australian Maritime Authority.
Great, thank you. Obviously, without necessarily naming individual employers where matters are ongoing or currently under investigation, could you provide a sense of the sectors or types of organisations that have been the focus of wage theft investigations since the criminalisation commenced?
So you're going back to the general criminalisation, yes. Again, I think I think Ms Carey will be constrained in that regard because the matters are under investigation, but I'll turn to her.
Yeah, Senator, it wouldn't be appropriate to comment on the nature of any ongoing investigations, even disclosing, I guess, specifics as to the sector or even in general terms could prejudice ongoing investigations and lines of inquiry.
Okay, no worries. Was worth asking. In relation to the review of the Fair Work legislation amendment, Closing Loopholes Act 2023, could you please update the committee on how that review's progressing?
So, Senator Payman, that review, of course, is being undertaken by an independent reviewer, former Commissioner Susan Booth, with the support of the Department of Employment and Workplace Relations. So how it's going would be a question for the department. I can say that we have met with the reviewer and are providing whatever factual information she requires to conduct the review.
No worries. And is there, in your conversations, have you had any indication of the timeline of when that review might be completed? Or
I think the terms of reference do provide a timeline. I don't have it with me. Does anybody else have that? I think
that's fine.
it will be on the department's website, I'm anticipating.
Awesome. Thank you, Ms Booth. Appreciate it. Thank you, Chair.
Senator Payman. I'm returning to Senator Kovacic and then Senator Barbara Pocock.
Excellent. Thank you. I have some questions about redundancies. If you could tell me, in 2025-26, there have been a significant rise in redundancy costs at the Fair Work Ombudsman. How many positions have been made redundant?
I'm going to ask our Head of Corporate and Engagement, who has the financial side of the organisation within his remit, to respond to that. What I can say is, whilst they will be of a certain dollar value that may look to you to be significant, they'll be isolated to specific structural circumstances.
Okay.
But, Mr Scully, I'll ask you when you're ready to address that question.
Thank you, Ms Booth. Mark Scully, Chief Operating Officer and also Group Manager, Corporate and Engagement. Senator, I wasn't sure about the source of your information. You were suggesting there's been an increase in redundancy costs in the 25-26 year.
Yes, so I believe it's come from a Quan SQ 25002773.
Right, I might just need to...
we can come back to that one if you like, or...
Sorry, Senator, what was the Quan number?
25002773. So it's got total financial cost of redundancies at $518,924 for the 25-26 year, and in the 24-25 year it was $275. 23-24 was roughly the same at $288, and 22-23 was $208,000.
Sorry, what was it, 25-26 number? Sorry, Senator.
$518,924.69, and that's to the 30th of September 2025. That's what's noted in the Quan.
I might need to take that on notice,
Okay,
Senator. I don't have the
okay.
answer in front of me. All I would say is there has not been a redundancy program within the organisation, but we do consider on a case-by-case basis, depending on the circumstances. But I said there's been no broad redundancy program through the organisation.
Great. So there's no impact to site visits and things like that, just business as usual, largely?
Yep.
Wonderful. So my other question just relates to some credit card expenditure. There was also in a Quan 2527, there was a $9,000 expenditure for training purposes. Would you be able to let me know what that was actually for?
Again, without having the Quan in front of me, Senator, I might need to take that on. Notice.
All right, okay. And then there was also another 30 credit card purchases totalling $900 that were deemed appropriate, but there's no description of them. But there's also a list of inappropriate purchases. Are you able to give us a list of what they actually are?
Without having the information.
And sorry, that should be deemed inappropriate. My apologies, I've misread that. So there were 30 credit card purchases totalling $900 that were deemed inappropriate.
Without having the information in front of me, Senator, I suspect that what they are is unintentional misuse by credit card holders.
So accidentally using the wrong card or something.
So typically, I can use myself as an example. We have one or more credit cards in the wallet, and some of those are FWO and some of them are your private. Accidents do happen where people use the wrong credit card when they're doing general purchasing for personal purposes. I have to say that in every instance, they are detected in a timely manner and repaid by the appropriate person. So I've no issues in terms of fraudulent use or inappropriate use, intentional inappropriate use of the credit cards.
Okay, wonderful. Well, if you could just provide that confirmation on notice, but I'm happy with that. That's all from me, Chair.
Thank you very much. Senator Pocock.
Thank you, Chair. Thanks, everyone, for being here. I wanted to pursue an issue raised by Senator Payman in relation to cruise ships and their regulation, and I was directed by the department, this is the spot to get more insight about that. as I understand your earlier answer, you have a goal of 40 investigations in your pilot. You've conducted 28, and you recovered salary. Is that right? Have I understood it correctly? Or salary and payments of $783,000 for 209 crew members. Is that right?
Senator, $783,000 for 209 crew members, but I'd need to qualify that that compliance action is with respect to coastal trading.
Coastal trading?
Yeah.
Thank you. What investigations do you... Sorry?
And those running under a temporary licence to do so.
Okay, so that is not the cruise ship sector.
No.
Do you have any work underway in relation to cruise ships?
Well, Senator, cruise ships are usually exempt from our jurisdiction as a result of the carve-out in the Coastal Trading Act. That said, we're aware of the allegations raised by the MUA at the end of last year, so we are conducting inquiries into the circumstances, the allegations, to do a couple of things. One is to test whether our jurisdiction is enlivened, and two, the nature of any contraventions that might have occurred. That said, and without predetermining the outcome of those inquiries, it appears to me that the ship in question is going to be outside of our jurisdiction. But we haven't completed our inquiries to a point where I can say that precisely.
What do those inquiries look like? What are you doing?
Well, site visits. Site visits in northern Queensland and attempting to speak to workers to understand what their experience has been like on the ships.
So...
and also then obviously looking to understand the commercial nature and structure of the companies that run and operate the ships in question.
I guess a lot of Australians have been reading those reports. There was another one this week, and are curious about how the employment terms and conditions of these workers are set. And that sounds like that's what you're looking at. Is that correct?
It's going to come down, Senator, to whether our jurisdiction's enlivened, and I want to manage expectations at this point. Is that it's not? It seems unlikely to me that they're going to be within our jurisdiction to enforce a minimum wage. But as I said, we haven't concluded the investigation or inquiries to get to that point. But they would be set most probably by their country of origin. But again, I wouldn't know without confirming or at least completing our inquiries into the matter.
So could you take on notice then to provide to us your assessment about the reach of your jurisdiction in relation to this population of workers, and can you give us any estimate of when that piece of work might be done?
Sure. Well, if I can just put this in to assist now, that our jurisdiction will not be enlivened if the cruise ship fits the definition of the carve-out in the Coastal Trading Act. So the answer to that is we have no jurisdiction. If they are, and I'm wading into aspects of my jurisdiction that, someone else's jurisdiction that I'm not an expert. But if they were an Australian employer, then that would change things, or at least be an input into changing things. But again, we haven't concluded our inquiries on this matter. So what I will say, Senator, is I'll undertake to confirm whether or not they're within our jurisdiction at the conclusion of our inquiries, and what, if any, steps follow from that.
Thank you. Do you have any role in drawing the government's attention to gaps in your jurisdiction? For example, this is a sizable group of workers who provide a service to Australians on many of these ships almost exclusively. They have a right, under ILO conventions at least, to the right to collectively, freedom of association and to collective bargaining. Will you be making a report to government on any gaps you see in your jurisdiction which leaves a group of workers like that vulnerable?
Well, Senator, I'd only observe that the carve-out's not within our jurisdiction, so the decisions behind the carve-out would probably best be directed to the Department of Infrastructure. So I'm not going to comment on an aspect of our jurisdiction which doesn't exist because of being the subject of parliamentary processes.
Ms Volsky might want to comment on this. Though we are not a policy department, as you know, the factual circumstances that we uncover of a general nature, as Mr Campbell's commented on, would come to the attention of the department, and then it would be a matter for the department and the minister as to what they would like to do about that.
And when you say the department, you're talking about the Department of Infrastructure, Transport,
well, actually,
or
in this case, I was thinking about, in a general sense, the Department of Employment and Workplace Relations. So across the full gamut of industrial relations, we don't make recommendations about changes to policy, but we are always working with the department on implementation of government policy, and if we have a factual matter to bring to their attention, it comes to their attention, and their analysis of that and their conclusion as to what to do about it is a matter for them.
And Senator, I'd just add that in 2023 the government agreed to review the Coastal Trading Revitalising Australian Shipping Act 2012 in response to Recommendation 6 of the Strategic Fleet Task Force final report. I understand that report, I think, is either provided or imminently to the government, which I think will traverse some of these issues because of the intersection with the coastal trading legislation and the Fair Work Act. And Mr Campbell's already alluded to, depending on the circumstances, how, for example, cruise ships might be treated in those circumstances. It's not for us to say, but clearly a matter for government to consider, you know, whether or not, for example, that exemption is appropriate to continue, how voyages are calculated on loading and unloading, vessels, for example.
Can I just clarify who's the report from and to?
I don't have, I think that would be a matter for infrastructure, but I just know more broadly, I think that the government did commit to a review of that Act. I think it would be properly a matter for infrastructure, including the timing of any report. But there are certainly intersections and complexities between the coastal trading legislation and the Fair Work Act and how it might apply to seafarers and coastal trading.
And Minister, can I come to you and ask whether the government has a view about a gap here that needs attention, and have you as a government got any oversight or plans to be looking at this? Seems like a significant gap.
Thanks, Senator. I think what I heard from the Fair Work Ombudsman is that some of the gaps may relate to the infrastructure portfolio and the frameworks there, so the questions might be best directed there, and if they relate to this portfolio, it might be best to come back when the department officials are here.
Seems to me this is a real intersection though, Minister. We've got workers who are, some of them on, it's alleged, $2.50 an hour. They don't have access to fresh water, we hear. They don't have the right to organise in a union. These are basic rights which the department, DUA, clearly wants to make sure apply to workers who deliver services in Australia.
Sorry, can you just say the last part of your question again?
Well, this is a serious gap that affects the rights, which are clearly the purview of DUA. I would hope the government would be looking at this, led out of DUA.
So I think, Senator, that the report into coastal trading will go to infrastructure, not to this department. So obviously, issues of workplace exploitation are, of a big concern to our government in general. We're really proud of all of the reforms that we've done to try to protect workers and improve wages and conditions for workers. But on this matter, I just understand that the best place for it to go is to infrastructure, and it's probably the RAT committee, I think, where those questions should go. Yeah.
Thank you. So can I then move to another issue? It won't be long. Do you play any role in relation to the conditions of Pacific Australia Labour Mobility Scheme participants, the PALM scheme? There have been 2 reports in the last week or so drawing attention to the lack of mobility and the potential for exploitation of palm workers, and a real danger of modern slavery as a risk for these workers?
So, Senator, we don't play a role in the policy which the disengagement issue is part of, but we do have a specific role in partnership with the Department of Employment and Workplace Relations and the Department of Foreign Affairs in relation to the approval of employers to participate in the scheme. We make checks on applicants. We conduct arrival briefings for palm workers, and we have a program of proactive investigations, 50 per year, of approved employers, and quite recently we've had 2 pieces of litigation that relate to palm employers. Mr Campbell can give you more detail about that.
You've done a great job summarising it, Ms Booth. So, yeah, we are a very active participant in the PALM program. We provide, I suppose, the advice, education and compliance support to the program itself. We're very active in that space. We work very closely with the department. As Ms Booth said, we've recovered money for workers who have commenced litigations in circumstances where we say there's been serious or contraventions with respect to those workers. So I can give you some stats if you want, but I'll let you know. You tell me what you want.
Could you do that on notice?
Yeah, sure.
I would love to see a summary of the work you've been doing. Right. Did I understand correct that there are 2 employers you have, because of your investigations, have been dropped from the list of possible employers?
The 2 that I have in mind have not yet been. One is still in court. The Bulmer Farms is the name of the company, and another we've achieved penalties against a company called McChrystal, but I believe they still are an approved employer, and the approval of the employer is not a matter for us. We support the department in their decision making by providing them with information.
So you may be able to not answer this question because I'm asking for your opinion, but given the experience of what you're saying, these reports say the question of being tethered as a worker is a major way in which their power is undermined, even to complain or seek redress. Do you see that in the evidence in front of you, and are you in discussion with, advising out of your experience with DUA about, or any other part of government?
So we certainly must avoid giving policy advice, but we did participate and support the department in what I believe is called the Disengagement Task Force, which was a group of people looking at this question, and I believe that report is with the government.
Okay, great. Thanks. I look forward to a bit of detail on that, and thanks so much for your answers. Thanks, Chair.
Thank you, Senator. I believe that concludes our questions for you, Ms Booth. So we thank you for your appearance today, and you are now free to depart. I am calling officers from the Fair Work Commission. Are they in the room? Can you just hold their heads in and then again? Okay, we'll just suspend for 1 minute. Oh. Now resume, and I'm calling officers from the Fair Work Commission, including its General Manager, Mr. Murray Furlong. Welcome, Mr. Furlong. Do you have an opening statement today?
Good afternoon, Chair. No, thank you.
Did I say good morning? Sorry, it's well beyond that.
No, thank you, Chair.
Okay, great. In that case, I've just got a short block from Senator Mulholland, and then I'll come to you, Senator Kovacic.
Thank you, Chair, and thank you to the Commission for joining us. I just have a couple of questions about junior rates of pay. So the SDA submitted an application to abolish junior rates of pay for young adult workers. Hearings were held last year, is that correct? The end of last year?
Ms Leggett will be able to assist you, Senator.
Yes, Senator. Hearings were held over a number of days in October and November, and the full bench reserved its decision on the 26th of November.
Thank you. Is it possible to get an update on the status of that?
It remains before the full bench, Senator.
Thank you. I know thousands of workers will be eagerly awaiting that decision, so thank you very much for the update.
Thank you, Senator. Senator Kovacic. Thank you.
Thank you, everyone, for being here today. I'm going to ask some questions in relation to the Watson report. Has the Commission received, cited or been briefed on the Watson report into the Victorian division of the CFMEU? And I note elements of that are in the media, but I'm referencing more formally.
I received a copy of the report Monday this week.
You received it?
Yes.
When did you receive that report?
It was Monday afternoon.
So Monday the 9th?
Yes.
Okay, thank you. Did you receive any prior information that it was substantially complete or near complete, or were you expecting the report, or it was just something that turned up?
It was in the well, I understood that the Mr. Irving KC had instructed Mr. Watson to undertake the report. I understand that it was in commentary late last year that it was due to be completed. I was anticipating that it would be finalised, subsequently released around this time, yes.
Okay. But you weren't sort of said, oh, it'll be January or February, it was just...
No, it's just yeah.
It was just soon? Yep.
Yes.
Thank you. Was the Commission advised that more than one version of the report existed, or there was a characterisation this morning that's not an official one, that perhaps one was a draft, but were you aware of there being more than one version? Or
I received the redacted version on Monday afternoon, Monday the 9th. I subsequently received the two deleted sections that have been discussed throughout the day last night, along with a statement from Mr. Irving. Now, the statement, and I had a conversation with Mr. Irving last night as well, but his statement that the administrator determined to remove the two sections attached because he was not satisfied that they were well-founded or properly tested.
Okay.
I'm very happy to table those sections this evening or this afternoon if you like.
That would be wonderful, thank you. Could you tell me, so you had that conversation with Mr. Irving last night. When you received the report on Monday, were you aware that sections had been removed, or had you been told that there had been, well, we know there were redactions, which is different, but that two sections had been removed from the report?
I received the report Monday afternoon. I subsequently read it Monday night. I identified that it appeared that a section was missing.
Yeah.
I then wrote, sent a message to an officer within the administration indicating that it appeared that there was some content that was that may have been missing, and I had a meeting with a conversation with this officer within the administration already organised.
Yes.
And that conversation occurred, and I was advised in my conversation in quite a significant detail with Mr. Irving last night that the reason that it had been removed is because the content hadn't been adequately tested, and including with the public servants involved.
Who did you speak to in the administration that you had the meeting already set with?
Michael Flynn.
Michael?
Flynn.
Flynn?
The Chief of Staff.
Oh, thank you. And could you tell me, did he indicate to you why those sections were removed?
Yes, it's consistent with what Mr Irving indicated about the veracity of those sections, that Mr Irving hadn't been satisfied that they were well-founded or properly tested.
Were there any concerns around whether there might be impacts to transparency or public trust by removing those, given it was an independent report from Mr Watson?
I have no reason to question Mr Irving's integrity.
Oh, yeah, I'm genuinely not questioning his integrity. I'm just asking about whether you guys had discussed whether it would create concerns from a public trust.
To contextualise, in all the time that I've been working with Mr Irving, and I've known Mr Irving, including when I identified him to be the administrator of the division prior to the legislation that brought the division into administration, that he makes decisions based on the information that's in front of him. I've not seen him make a politically motivated decision in my interactions with him over that period, and so I can only go on what my experience, what my knowledge is of Mr Irving. Yes.
Thank you. Could you tell me what time your meeting was yesterday with Mr Flynn?
It was a telephone conversation.
A telephone meeting, yes.
And I had a meeting with Mr Flynn this morning at 9 a.m. It was a Teams meeting that ran for about 20 minutes.
Okay, thank you. And it was in those discussions this morning with last night with the administrator and yesterday with Mr Flynn that you were told the reasons or why the specific sections were removed?
No, there was interactions with Mr Flynn's office yesterday about coordinating the meeting.
Yeah.
So there was those interactions, and then last night with the administrator, and then subsequently with the Chief of Staff this morning.
So no meeting with Mr Flynn yesterday, just this morning. Okay, thank you. Was the Commission advised that the author of the report didn't recommend the removal of the material?
No.
Okay. Has there been any meeting between the Commission and the Minister in relation to the report?
No.
Is there any meeting scheduled or...?
No.
No? Okay. Is it your experience, and we heard earlier today that it is the belief that all the other reports of Mr Irving have been provided in full and they haven't had sections removed. Does the Commission expect that reports, when they're prepared by independent investigators, that they are actually provided in full?
The administrator is independent of me and of government, and these are operational decisions that he takes in the normal course of leading the division of the CFMEU. I imagine with the finalisation of any report that's been commissioned by an institution, there is an opportunity to work with the drafters in the finalisation of them. I don't think that is, certainly in my experience, it's not an uncommon activity that occurs.
Okay, thank you. And have you had any meetings with the department in relation to this report?
I had a conversation with Gregory Manning last night at about 9:30. I think you discussed that earlier today.
Probably roughly the time he got it, yes.
Yes,
yep.
That's right.
Would it be a normal practice or a best practice perhaps for the removal of findings to be clearly disclosed to anybody relying on the report? Like you actually realised that they were missing and you contacted the appropriate individuals, but would it be normal practice for that to actually be disclosed to you in advance to say, you know, here is said report noting sections have been removed for X reason?
I hadn't had the opportunity to speak with anyone from the administration after receiving the reports, and the earliest that I had was with the meeting with there's a text exchange with Michael Flynn, but in terms of the first meeting that I had was with Mark Irving. The first conversation last night, and went into reasonable detail about his reasons for asking for those sections to be removed.
Okay.
And do you mind if I just...
Sure.
I had in preparation for this evening, I went back and had a look at the scheme of administration and Mr Irving's powers, functions and duties. And it goes obviously to the operations of the division, the CFMEU.
Yeah.
It certainly doesn't go to the responsibility to the conduct of other participants in the industry. Those responsibilities rest with others, including governments, labour hire companies, Tier 1 builders, Tier 2 builders. So in terms of Mr Irving's legislative remit, it probably falls outside commentary around the alleged sort of involvement or conduct of governments. Probably falls outside of his...
So are you saying that because the information contained in those sections related, let's just say in some part, to conduct in the Victorian state government, that is not the remit of the administrator, only the conduct of the CFMEU, so it's actually okay for him to remove that from the report?
No, I'm not saying that at all. I'm talking about his... I mean, in terms of first principles, I go back to the legislation. I go back to look at what his functions and his powers are.
Yeah.
I'll just bring it to your attention.
So he has no power to do anything in relation to the
He can certainly make
government.
those observations, and I think Mr Watson can make those observations. The position taken by the administrator was that the two sections were removed because he was not satisfied that they were well founded or properly tested.
Okay. I guess, Mr Commissioner, are you aware that in the estimate in the Watson report that conduct within the Victorian construction sector inflated project costs by around 15%? And do you have any reason to dispute that figure based on matters before the Commission?
No. In terms of conversations that I've had with officials, I think that that figure is consistent with what I've heard from officials from the Victorian government.
So that figure is accurate in terms of...
I can't question whether or not it's accurate. I can just say that in terms of the conversations
it's
that
consistent.
I've had,
it's not inconsistent with other information that you have received?
Yes, it's within the range, yes.
Okay. What is that range that you have seen?
Up to 30%.
Up to 30%? And is there any particular area or sector of the construction industry where it regularly goes to that 30%?
It wasn't the conversation. The conversations that I recall didn't go to that level of detail.
Okay. Is the range 15 to 30 or is the range less than 15 to 30?
The range that was provided was up to 30%.
Up to 30%?
Yes.
Okay. From the Commission's perspective, if bargaining conduct or industrial behaviour were contributing to double-digit cost increases on major infrastructure projects, would that raise concerns about whether agreements are genuinely in the public interest?
I think we're traversing a number of sort of areas here. Enterprise bargaining occurs between parties who want to bargain to make an enterprise agreement. They go through that process, and in terms of the terms and conditions that are negotiated through that process, once they meet the pre-qualification requirements, they come before the Commission, and then a Commission member will determine whether or not the legislative tests have been satisfied, and on the basis of that, they will approve the enterprise agreement. So the matter that I'm sort of raising, it's not about the terms and conditions in these enterprise agreements. It's more it's more closely aligned with the and Mr Watson refers to this in his report. It's the conduct associated with the with the practices on these large construction sites.
Yeah, and so then is it fair to suggest then that some of those practices on the large construction sites would lead to scenarios and cost increases that are not in the public's best interests?
I can only comment on the information that I've been provided, and I'm not in a position to provide any evidence to confirm or deny that position.
Okay. So just so I can understand this properly, the independent investigator that the administrator hired found that the CFMEU control over building sites occurred in part due to failures of government oversight. The administrator directed that this section should be removed from the report on the basis that he didn't feel that it was sufficiently substantiated or tested appropriately. And the administrator has now indicated today that those same matters are being referred for a formal independent investigation. In your discussions with the administrator last night, was it explained why material now considered serious enough to warrant an independent investigation was removed from the original independent report?
I'm not aware of that statement made or that commitment made by the administrator.
Okay.
What I can say is that there is an option available for others to commission a separate report or inquiry into alleged conduct on the big build sites, and this would resolve some of the administrator's reservations about Mr Watson's content. In my exchange with the administrator last night, I also indicated that this issue won't and shouldn't go away without accountability, that it impacts on every Victorian and to varying degrees the rest of the country, and that I said that Victorians have a right to know.
I'm interested in that comment in varying degrees around the country, and obviously we have the Commission of Inquiry in Queensland. Are you receiving, and I know I've asked similar questions before, but are you continuing to receive similar concerns across other states? And if so, which particular states are you seeing those concerns come from?
When I was considering initiating or contemplating initiating proceedings to bring the Construction and General Division of the CFMEU into administration about 18 months ago, I established a hotline, and it was a national hotline, and it was available for any member of the public to make reports, some of them obviously on a confidential basis, but also if they wanted to provide information that we could sort of look into further, including the names and the identities of the people involved. That was heavily utilised, and I might ask Mr Cole to provide some further information on the referrals. We were making about 500 referrals. Of the approximately 1,100 reports that we've received from across the country, about 10% or so of them relate to infrastructure projects. In the last 2 weeks, I've provided a de-identified list of each of those matters to infrastructure ministers across the country, and I'm happy to table that document with you as well.
That would be wonderful.
So you will get a sense of the issues that have been raised and the locations of those of that alleged conduct. I must stress though that it is alleged conduct.
Of course.
They haven't been tested yet. But I understand that a lot of...
They're reports to a hotline.
Absolutely, and they resulted in referrals to many law enforcement agencies. So if you want some further detail, we're happy to go to it, but it's available to you if you like.
I'd be interested in, if you have it at hand, the particular statistics or numbers in relation to New South Wales and whether there is an increasing or growing number of tip-offs or complaints in New South Wales.
Well, I can say that the hotline, it's an historical account pretty much now. We're not receiving many reports to the hotline these days. There was a significant amount at the point in July after the Building Bad. Building Bad. The media commenced, but it tailed off. And what I'm hearing from industry participants, peak organisations as well, is that it's industrially it's very quiet in the industry at the moment. I'm certainly not receiving complaints, a significant number of complaints through our hotline service.
Okay. And is there any other mechanism for those complaints?
Well, there's other organisations that have established them. I know the Fair Work Ombudsman has one.
Yes,
I'm aware that the Victorian Government has established one recently as well.
Okay. And just, and I know you've answered that you don't know in relation to that, but I just want to confirm about this shift in position with last night the administrator indicating that the material was insufficiently substantiated, and today it's being treated as having enough substance to justify a formal independent investigation. I just want to confirm that that hasn't been discussed with you yet, and you don't have any information about that at this stage from the administrator.
Not about the full independent investigation.
Okay.
No, I'm not aware of that.
All right, thank you. If credible evidence suggested that unlawful conduct or intimidation had materially increased the cost of infrastructure projects, would the Commission consider that relevant to the approval of future agreements or to the ongoing assessment of right of entry and fit and proper status?
The Fair Work Act contains the legislative regime for the approval of both enterprise agreements and right of entry permits. So the matters that the decision maker, whether it's a member of staff or a member of the Commission, it sets out the steps that they need to be satisfied of, or the points they need to be satisfied of before either a entry permit is approved and made, or the same with an enterprise agreement.
I understand that, but I'm guessing would there be any sort of a trigger for you to go, okay, well, we're seeing credible and increasing evidence of this occurring. Is this sort of an appropriate moment to consider whether we need to...
That's beyond the legislative remit of the Commission.
All right. Okay. Are you able to tell me when the Commission first became aware that Zach Smith had resigned from his position?
I can. Just bear with me, Senator. Thank you. It was on the 21st of January.
21st of January. Was the Commission notified formally of the resignation? And if so, by whom?
I was informed a number of hours before the public statement was made, and I was informed via text message.
From Mr Smith?
No, from an officer within the administration.
Okay. Are you able to tell me who that officer was?
It was Michael Flynn.
Okay, thank you. Prior to the resignation, was Mr Smith the subject of any proceedings, complaints or compliance concerns known to the Commission?
I raised some issues with the administrator on the 23rd of October 2025 in relation to Mr Smith, and this followed the public commentary around Mrs Smith allegedly organising for an organiser of the union to meet with Mr Gatto. Yeah. I asked a series of questions and I received a response on the 28th of November, and that response indicated that amongst, and it's quite a long response, I'm quite happy to table that as well.
Could you please table the response?
If you'd like to,
yeah.
Absolutely.
If you could give us just an overview of the response.
Well, I asked several questions. and at the in terms of the extent of any investigation or steps the administration had taken into allegations about Mrs. Smith's direction to an organiser to meet with Mr. Gatto at a private location. I asked about alleged meetings or involvement by Mr. Smith to remove former officers of the division. Also asked about alleged conduct involved in the continuation of former corrupt practices by the branch relating to the negotiation of enterprise agreements involving Mr. Smith and a number of other matters. Now, ultimately, and we discussed this I think in the last estimates, Mr. Irving indicated that he maintained confidence in Mr. Smith, and I indicated that I maintain confidence in Mr. Irving.
Did your confidence, you didn't need to have your own confidence in Mr. Smith because you had confidence in Mr. Irving, who had confidence in Mr. Smith. Is that an accurate characterisation?
I work on the basis of trust but verify.
Yeah.
And I asked for significant information to satisfy myself. Now, in relation to this, the company that had alleged to contract Mr. Gatto, Maz Constructions, working on building works at Tullamarine Airport. I've subsequently written to the director of that company under provisions of the Registered Organisations Act that were amended to facilitate the administration of the CFMEU about anti-avoidance. And my understanding is that we requested some assistance from that company, and that company hasn't responded to our request as yet.
Okay. Did you give the company a deadline for a response?
Yes, we did.
Has that deadline passed? When was that deadline?
We can take that on notice.
Yeah,
if you like.
Absolutely fine for you to take that on notice. I've just got a couple of quick questions before we rotate, before the chair needs to rotate the call. That letter that you received the response to was on the 28th of November, is that correct? You received the response, is that right?
Yes, that's right.
Is there anything that transpired between the 28th of November and the 21st of January that you, when Mr. Smith resigned, that you are aware of that could have triggered a resignation?
No.
No? Okay.
The information I was provided is what was provided more publicly.
So there's nothing
personal,
new
family,
in
and
that,
health reasons.
In that intervening period. Thank you. Prior to the resignation, was Mr. Smith the subject of any proceedings, complaints or compliance concerns known to the Commission outside what you've already articulated?
There were no formal or informal investigations into Mr. Smith's conduct.
Perfect. Did the resignation of Mr. Smith prompt the Commission to undertake any review or assessment of governance or conduct issues within the CFMEU?
No, and the reason being is that I've never felt the need to do that. I work closely with as the independent regulator, work closely with the administration on a range of operational and strategic matters on a weekly basis. At no point have I been concerned about the governance or the operation of Mr. Irving or his decision making. If you look at the scale of the reform that's occurring within that institution, and that's occurred within that institution within a short period of time, I doubt that you'd find any sort of or very few comparators in very difficult circumstances as well.
Thank you. And my final question, has the Commission considered whether Mr. Smith's resignation has any implications for any matters previously before the Commission, including representation or compliance issues?
The answer to that is no. As you know, Mr. Irving has two roles. He has one, a role to conduct the operations functions of the union, to represent the industrial and work health and safety interests of his members. And in addition to that, he's responsible for cleaning up the union. He is doing both of those jobs very proficiently from my assessment, and that is an ongoing assessment who works closely with his office. And
that's your long-held view?
Offices. Yes, it is.
Thank you, Mr Furlong. Thank you, Chair.
Thank you. Senator Roberts.
Thank you, Chair. Thank you for being here again today.
Good evening, Senator.
Mr Furlong, you have previously agreed that an enterprise agreement cannot remove all applicable award entitlements. And you have agreed that an enterprise agreement cannot remove entitlements provided under the Fair Work Act and the National Employment Standards. That was both of them in November 2022. Do you still hold the same views today?
I do.
Isn't it true that these propositions were confirmed by the majority of the High Court in the Rosado decision?
I can't talk to the High Court decision, Senator.
And the Court went on to say that even, quote, where there are express terms of the contract between the parties, they must be given effect unless they are contrary to a statute, end of quote. Are you aware of that?
It's been a long time since I've looked at that decision. I can't comment.
Yeah, I know what you mean.
Yeah.
If an agreement includes terms that would remove statutory rights, such as annual leave and other award entitlements, wouldn't those terms be considered contrary to statute?
It's difficult to talk in the abstract about such matters, but if the terms and conditions in an enterprise agreement they need to be better off overall. It's a global assessment in determining whether or not an enterprise agreement will satisfy a member of the Commission and subsequently be approved by that member.
Thank you. This issue was further considered in One Key Workforce versus CFMEU, where the full bench of the Federal Court held that, quote, it is an error of law to fail to have regard to relevant material in a way that affects the exercise of the power. An administrative decision maker, Fair Work Commissioner, an administrative decision maker who makes such an error exceeds his or her authority and acts without jurisdiction. Isn't this exactly what the Commissioner did when approving an enterprise agreement that ignored the Black Coal Award, which was relevant material?
I think that the circumstances of one key relate to the one key enterprise agreement. If we are talking about the Chandler-McLeod and other agreements about casual coal miners, is that
I want to know if an enterprise agreement takes away annual leave by calling someone a casual, is that going against statute?
It depends on if the employee is a casual or a permanent employee. If they're a permanent employee, they'll be entitled to annual leave and sick leave and all the other conditions that will be applicable to a permanent employee. As you'd be aware, there are casual conversion entitlements now for employees that they can exercise if they want to transition from casual employment to an ongoing role.
How does it comply with the National Employment Standards and the Fair Work Act if someone loses annual leave, ends up on lower pay and doesn't meet award provisions? It goes against statute.
The Fair Work Act provides the framework that members of the Commission have to observe before they can approve an enterprise agreement. If there is an aggrieved party to a decision that is made by a member of the Commission, those decisions can be the subject of an appeal. If the agreement has reached its nominal expiry date, then a party to that agreement can make an application to have that agreement terminated.
So the express terms of the contract, or EA, must be given effect unless they are contrary to the statute?
No. What I'm saying is that a member in assessing about whether or not to approve an enterprise agreement which has been lodged with the Commission for approval, there is a number of statutory tests that need to be satisfied, one of which is the Better Off Overall test. Once a member of the Commission who has been allocated that file is satisfied that each of those conditions has been met, they are required to approve the agreement.
So can you tell me how the loss of annual leave, a pay rate that is less, how that complies with Better Off Overall? and loss of other award provisions because the award prevails. That's the High Court.
Well, it's very difficult to talk in the abstract here. It's a case-by-case basis.
Lost annual leave, lower pay rate, loss of other award provisions. That's not abstract.
We've traversed this several times.
Yeah,
Senator.
and I'll keep traversing until we get these people their fair due and comply with statute. Thank you, Chair.
Thank you, Senator Roberts. Senator Kovacic, did you have further questions?
I do, thank you. I want to turn to the capacity of the Fair Work Commission. The President of the Commission has warned the current operational framework isn't sustainable, not because the demand has fallen, but because the workload has exploded and there are concerns about that funding going backwards. Obviously, this isn't an accident. Can the Commission confirm the total reduction in funding it faces between now and the 2028-2029 year?
Senator, I'll ask Mr Lambach to assist you in a second. In terms of the commentary, the current operating model, the President of the Commission indicated that it is unsustainable, and we are driving significant transformation across the organisation. And while the organisation is more efficient than it's ever been, it's dealing with more matters than it's ever dealt with, and caseloads have never been greater than what they are now. We're finalising more matters than we ever have previously. It's just not enough to keep up with the increase in workload that we're receiving. Mr Lambach, are you happy to go to the future estimates, please?
Yes, Jack Lambach, Executive Director of Enabling Services. So in terms of operating revenue for government for funding our operating budget, in the 2025-26 year it's 109,560,000. The year after it reduces to 108,616,000. The year after that it's increases to 110 million, and after 294,000. The year after that it's 111,395,000. So the issue really is fundamentally that the growth, I guess, in our operating funding is very flat over the forward estimates when we're expecting, of course, inflation, wage rises and those kind of things, as well as what Mr Furlong highlighted, the increase in workload, which is that issue, because our workload, our resourcing is obviously heavily tied to our to workload because.
Of course, that makes sense. So, how much of the Commission's increased workload is attributable to new or expanded jurisdiction created by the recent Fair Work amendments?
Interestingly, a significant proportion of the growth in the workload relates to our traditional matter types, individual rights-based matters, including unfair dismissal and general protections involving dismissal. Now, we have seen significant increases across many matter types, but if I was to focus on the most profound change, it's those two case types.
Okay. And has the Commission warned government that funding cuts could undermine confidence in the tribunal or the enforceability of workplace laws?
We continue to have, and as we have for many, many years, ongoing conversations with the Department about the resourcing requirements of the Commission, and it's on a weekly basis. So we were actually working with very closely with the Department about a number of things that go to our resources and the efficient operation of the tribunal, including, while we don't enter the policy debate, some technical amendments to the Fair Work Act that would assist in improving the efficiency of the tribunal.
I note that, and I note it would be normal for you to have those ongoing conversations, but I guess what I'm asking is, particularly in the current environment where your workload has actually exploded, where the funding that you currently have, and correct me if I'm wrong, is largely inadequate for the work that you have in front of you. For this financial year, I've sought and recently received approval to run an operational loss of $4.5 million, which I'm thankful for the support of government. That will enable us to deliver a significant amount of transformation, including digital transformation,
reviews of case management practices respond to some of the changes that we're seeing in our caseload and in terms of the behaviour of some of the parties as well. So it provides us with that opportunity to get to a point where we can return to a balanced budget position. We're also looking, and it's an ongoing review of all expenditure items across the organisation. We're also looking at our property profile. We continue to find savings while ICT infrastructure and costs continue to rise. We continue to find savings in relation to our digital infrastructure as well. But it's an ongoing piece, and we are driving deep transformation across the organisation at the moment.
Thank you. Can you confirm for me whether the termination of the small business support measure will affect your small employers' ability to navigate the commission processes? Is that something that you guys have looked at or modelled or planned for?
I might start and then ask Ms Bright to assist you. The measure has been used, or the funding has been used to develop a series of services. Some of them are digital services as well. So what I can say at the outset before I hand over to Ms Bright for the detail is that we have not reduced any services to small business. Ms Bright.
Thanks, Mr Furlong. Zoe Bright, Executive Director of the Legal Performance and Engagement Branch. So, yes, as Mr Furlong said, we have a program of work to support small business. We run a small business reference group, which is chaired by our small business national practice leader. The Commission's Communications, Education and Engagement team works across the organisation to deliver a program of work to support small businesses. And our small business reference group is invaluable in providing feedback on that work. Some of the work that we've undertaken this year includes a new online learning module to support self-represented parties in appearing in hearings before the Commission. We've undertaken a number of communication campaigns about issues that affect small businesses, including the new right to disconnect and casual conversion terms that commenced last year. We have also undertaken a review of our website to ensure that it meets the needs of small business, as well as using sort of user experience reviews and methods.
Okay. At what point does the Commission believe, or if you've mapped for it, that you'll be unable to meet your obligations under the Fair Work Act without either additional funding or some kind of legislative change?
We are not at that point, Senator. We continue to have conversations with the department. We are in the early stages of a deep organisational review where we're working closely with staff across the organisation to identify efficiencies. In the last 12 months, we've rolled out a whole lot of digital systems that we are just starting to find the productivity benefits of as well. We are changing the materials on our website. We are looking at our case management practices for our highest volume cases, and we continue to sort of monitor it very closely. As I said, the government has been supportive in allowing me to run an operational loss this financial year, and these conversations will continue.
Yeah.
There is
so effectively you can continue doing what you're doing because you're running at an operational loss that you have not been funded for yet.
Well, just for this year,
yeah.
And we're going to use this opportunity to, as far as possible, to drive as many changes as we can. In addition to conversations that we're having with the department about possible legislative reform, which would assist in the efficiency of the operations of the tribunal.
Okay, and when did you first raise the funding reduction would impact? Like, when did you first raise these, funding problems with government, and how it would impact your ability to do what you need to do?
I have to take that on notice. I certainly raised it in my incoming government brief.
Okay.
Yeah, but it's ongoing conversations.
Sure.
Yeah.
Okay. I have some questions as well in relation to the New South Wales Health and Safety Amendment Digital Work Systems Bill. I think it's referred to as a Digital Right of Entry Bill.
I'm not too sure if I can assist you.
I'll ask my first question and then you can let me know. Has the Commission considered or monitored the New South Wales Work Health and Safety Amendment Bill 2025? and its potential interaction with federal industrial relations frameworks?
No, I'm not aware of that.
Not aware of it?
But I can't comment on it.
Okay, no, that's fine. Thank you. Okay. What in your view is the purpose and desired outcome of the Albanese government's 2023 changes to the multi-enterprise bargaining and the rope-in mechanism?
The roping mechanism. I'm not too sure if I can comment on the policy intent of the legislation. I can provide you with information, obviously, about the operations of the Commission.
Yeah, and the desired outcome, like what outcomes. Yeah, so I have said either the purpose and the desired outcome. What are we trying to achieve from it?
Right.
Or what are you trying to see?
About multi-employee bargaining.
Yeah, correct, and particularly the rope-in mechanism.
Might
if you're
ask Ms Fonseca to provide you with some information on that, if we have that information available to us.
Thank you, Senator. I'll just see if I can find some information about that.
Thank you.
Senator, I don't think we'd be able to comment on the policy intention or the desired outcome of the legislation. The Commission's role is to perform its functions under the Act. We're an independent tribunal and we wouldn't normally comment or be part of the discussion around the legislative intent.
Would you have, like in the performance of your function, would you be required to ensure that outcomes are being met or not, just providing effectively the framework for it to occur?
So the Commission members who make decisions under the Act, they are required to make those decisions in accordance with the framework, and we'll be able to provide information about numbers of applications and that kind of thing, but just members of the tribunal are independent decision makers and they interpret the legislation in accordance with the framework.
Thank you. The legislation included a carve-out for general construction workers. Given up to 80% of the workers on a construction project are subcontractors, do you think it would have been more workable that all workers on a construction project are covered by the carve-out?
Just to continue, it's...
I think the people sitting next to me were making the point well, but these are questions of policy, I think, Chair, and they probably belong in outcome 3, which was early this morning.
Sure, not a problem. I thought there might be particularly given the impacts to the workload of the Commission, there might be some work or some framing that had been done in relation to that, or some kind of advice or briefing to government.
As Ms Bright indicated, that we can provide you with information about caseload volumes.
Yeah.
The caseload volume associated with these matter types is low.
Yeah. Okay. All right. Thank you. Does the Fair Work approve right of entry permits for ETU organisers who are former CFMEU officials, including, for example, Carl Hitchcock?
I'll ask Mr Coyle to assist you in questions there.
Senator Patrick Coyle, Acting Executive Director of the Registered Organisations Services Branch. Sorry, I missed the name of the official that you
Carl,
referred to.
so, number one, do you approve those right of entry permits? And the individual was Carl Hitchcock.
So, Senator, I'm not familiar with the individual in question. We'd have to take on notice the status of that particular person, but the right of entry permit system allows for applications to be made by organisations on behalf of their officials, and that includes registered organisations, including the ETU.
When they make those applications to you, does Fair Work consider their history, and do you view these, and based on that history, do you make an assessment of them being fit and proper persons, or that's something that's done by the organisation that's applying for the permits?
The application process requires the organisation to disclose relevant matters, but that is not the limit of the effort that goes into it. Right of entry permits are assessed by a member of the staff in my branch against a permit qualifications relevant matters list, and that can include all sorts of information about someone's background. If they were a former permit holder, a new permit matter would be linked in our case management system to that previous permit, so it would ingest the information on previous matters that has involved that person. We also keep a list and are aware of a range of different cases that have come up and where people have come to our attention through various industrial matters in the public sphere. We keep a list of those matters and do assessments in that regard. Permit matters are then either identified as being routine or more complex. The routine matters are determined by a delegate sitting in my branch, but anything that may give rise to fit and proper person issues is referred to a member of the tribunal for consideration.
There are some allegations, and I note that you've said you don't have an awareness of Mr Hitchcock, so you may need to take this one on notice, that Mr Hitchcock allegedly abused workers, calling them, blank scabs, dogs and grubs, in a case that was discontinued when the ABCC was disbanded. I'd like to get an understanding whether the Commission is aware of those allegations, and if they are or if they are not aware of them, if that would impact his fitness to hold one of those right of entry permits.
Thank you, Senator. I'll take on notice the specifics in relation to the individual you've named. We, through that assessment process, do have, as I have identified, a list of persons that would be of interest because they have had previous findings against them. I note that in this particular case you said that those proceedings didn't result in a civil penalty. So whether we have information that is recorded about that particular matter is something that I'd have to take on notice.
Okay. But if you found that there was an issue there and that perhaps for whatever reason that wasn't disclosed or you weren't made aware of it or there were other matters that prevented you being aware of it, would that be something that would constitute the requirement to discontinue that permit or to take that permit away?
The applicant would be under an obligation to disclose a relevant matter if there was an active prosecution in relation to their conduct. But if that matter has been discontinued, they
wouldn't be required to disclose it.
They might not have the obligation to disclose that there had been a matter that was investigated. And those are allegations and they haven't been resolved in a court.
Yeah. So if the matter was discontinued when the ABCC was disbanded and a new complaint wasn't made, that individual wouldn't be required to disclose that to you?
That would be the prosecution, or whether a matter was under investigation in relation to that individual would be a matter for the Fair Work Ombudsman and an inspector, who would be the agency that would take on those matters, and obviously the decision to discontinue similarly would fall within the purview of the Ombudsman. Whether we would have holdings and information about a matter that was started and not finalised, I suspect that we probably would not have that information in our holdings, but I can take that on notice.
That would be great, and also it can be on notice, what happened to the matters that were on foot or discontinued when the ABCC was disbanded, and how many of those are there? That would be great to know if you can find that out.
Again, I think that question is probably better directed to the Fair Work Ombudsman.
Okay.
We wouldn't have a record of the matters that were discontinued upon the abolition of the ABCC.
Okay, all right. Well, thank you very much. That's all from me.
Thank you. We're now in a position to dismiss officers from the Fair Work Commission and officials, so thank you very much for participating today. What I propose we do is suspend for the dinner break 5 minutes early, so we'll be suspending for an hour and returning at 7:40. When we return, we'll be going straight to Common Care. Thank you very much.